The inquiry is now resumed. I think you can all hear me. I can tell you can hear me because I can hear myself again, so that's fine. Okay, just for those who weren't here yesterday or the day before, my name is Stephen Normington. I'm a Chartered Town Planner and a Chartered Surveyor who's been appointed by the Secretary of State to hold this inquiry into an appeal made by Semix UK Operations Limited. The appeal relates to the refusal of planning permission by Hampshire County Council for the proposed extraction of sand and gravel with restoration to grazing land and recreation using imported inert restoration materials. It also includes the erection of associated plant and infrastructure and the creation of a new path and access onto Hamble Lane. The appeal site is located at former Hamble Airfield, Hamble Lane, Hamble Rice, Hampshire. As usual, before going any further, can I ask the council to confirm or otherwise whether there's a fire alarm test, and if there is a fire alarm, the evacuation in the toilet facilities.
Thank you, sir. So if there is a continuous alarm, there's no drill plan for today. If you can go out the door towards the restaurant, follow it out to the main reception, out of the door by reception, round to the left and towards High Street. You need to cross over to Castle Avenue where the fire assembly point is. Basically, you can follow officers and there will be fire marshals to assist you on the way if we're in that position. In terms of toilets, just out the same door there, over to the right, and then the toilet's just on the left-hand side by the Nightingale room.
Thank you very much indeed. Just to avoid any interruptions, just a reminder again for everyone to turn mobile phones off or to silent, any email notification alerts, and that includes me. Please ensure those are silenced as far as we can as possible. We had one yesterday, I did say it's £10 for advocates, £5 for expert witnesses, £2.50 to the council, and resignation for the inspector. So that's the stakes we're playing with. All right, just a couple of things of housekeeping before we get to some formal things. Just a reminder tonight, before I leave, I need a final copy of the Section 106 agreement. I had some plans and I think there were some amendments yesterday, but as long as somebody, whoever that might be, from the council or the appellant can give me a final copy tonight, that would be helpful. Also, just remind that I did say on my opening announcements on Tuesday that just to have another final run through of the plans list. I don't think there's going to be any further amendments, but it's just worth checking because you only get one chance of getting this right, and it's tomorrow morning. I think that's it as far as I'm concerned. I've had some correspondence with Amy regarding some interested parties speaking tomorrow. I was going to move the room closer tomorrow for a roundtable session, but I can't because we've got third-party speakers and we're limited a movement by the technology. So unfortunately, the roundtable session will look like this, but we'll cope with that. Before I go into introduce the witnesses, anything of housekeeping that I need to be aware of, Mrs. Strawn? Mr. Fulbrook, no. Anything? Oh, there is something.
No, I was just turning on to say no, thank you.
Thank you.
So just obviously, I'm sure we'll talk later about site visit arrangements for tomorrow afternoon, but one of the things that we think will be relevant for the site visits for you to understand what the rainfall patterns have been recently. And my understanding is that the Environment Agency produces data about rainfall, and the latest data drop, if you like, is today. So we would be able to give you that latest data if it would assist you in your site visit to understand what the rain has been like in the weeks, months prior to you, for example, seeing the springs, which we would say is a relevant factor. So I just flagged that, and we would like to provide that to you. I don't know whether there's any objection to us providing that to you, but I thought I'd flag it now so that people can respond.
Mr. Strawn, do you have a view on that?
So you can have the rainfall. It is what it is. Yeah, I'm not sure that it relates to how it relates to the site visit. But
all right, you can provide me it. It is what it is. So tomorrow morning, if it's published by then, if you can let me have it, I'll record it as a query document. Obviously, if you do give me it, bear in mind it's probably hard copies, and we've got the site visit with other parties as well. So it might be worth just bringing enough copies for parties to take with us, because we're not going to be on email connectivity during the site visit. And obviously, if we can let Amy have a copy to upload onto the inquiry website as well. That would be helpful.
Thank you. I understand it's published today, and so we will make sure that copies are available to everyone.
No problem. Thank you.
Could I just ask why it's what relevance it is to the site visit? Is it?
You can ask. I think I know, but you can ask.
Is it about whether what you're going to see you can compare it against rainfall?
I think that's my interpretation, Mr. Strawn, and that's.
Yeah, I mean, what we hope you will see, sir, tomorrow is you'll see string-fed streams flowing, and obviously the length of time which the springs flow after rainfall events is something that was relevant and discussed yesterday. So for you to sort of understand what you're seeing, it will be helpful for you to know when it last rained and how much it's rained. That's the basic premise of it, sir.
Okay. If I'm being honest, I don't have a problem with that. It's fact.
That's fine. I said rainfall data are fine.
I understand the relevance. So I can understand why you're giving me it. So I don't have a problem with that. I'm not going to ask for comment. It's something you give me to inform the site visit as opposed to something you're scrutinising by evidence.
It's just for data information.
Absolutely.
No comment. Yeah, thanks, sir. Yeah.
Anything from the council side, Mr. Lewis? I'd be amazed if there were.
Nothing from us.
Thank you very much indeed. All right, in which case that's the kind of preliminaries done. This morning, we'll hopefully get through the evidence of Mr. Andrews, hopefully get through the evidence of Daniel Hay, and then this afternoon, hopefully, and that's a big hope, probably, get through some highways evidence. We'll see where we are later this afternoon in terms of inquiry programme and whether or not we need to invoke that contingency day or half day, but we'll cross that bridge when we get there, I think. So this is day 3 of the inquiry. We ended last night with evidence in chief from Mr. Andrews, and Mr. Strawn was kindly alerted us to the PIBA guidance regarding PERDA for witnesses that have commenced their evidence, and we agreed that in this particular case we would allow a waiver of that to enable inquiry progress. So thank you, Mr. Strawn, for agreeing to that. Without further ado, I think we may as well just go straight then into the cross-examination of Mr. Andrews. Mr. Strawn.
Thank you, sir. Good morning, Mr. Andrews.
Morning, Mr. Strawn.
So I've got a few documents. A few documents for you. Perhaps I'm happy to get them out as we go along, or would you like some now?
I think it's probably helpful to just alert us to some of the documents now, Mr. Strawn, so that bear in mind some of the, if we are using the IT system, some do take a little bit of time to load.
So CD G10, G11, G12, G13, which are Natural England responses on the application. And already, perhaps the larger documents you might need are CD D14, which is a map. Takes a while to come up. CDL35, which is the Solent mitigation, bird mitigation strategy. CDC1, I think it is, which is the flag. Yeah. C1. CDB61. CDL34. Sorry, these aren't in order of alphabetical order. And CDL14.
At least that's a start.
Thank
I've
you, Mr.
almost certainly encountered a document I haven't been to early in the cross-examination, but I hope that helps.
No, it's helpful, at least. There's some knowledge as to where we need to look. Thank you.
I can't promise that I've downloaded all of those, so I may need some time to get to them, but I will. I've tried to download them as you've gone along.
Yeah, I tried to give you the ones that take a bit longer, in particular, because they're maps or high,
You may have to bear
high
with me.
megabyte. Right. I will certainly bear with you. So, Mr. Andrews, if you could help me, obviously, just by answering my questions. If you don't understand them, please say, and I'll have a go to rephrase them.
Thank you.
So, paragraph 5 of your proof first.
Yes.
Your evidence, and having read it, I can see this, your evidence is not to provide any form of shadow HRA of your own, but rather to criticise the ones that the inspector has already from the appellant and the county council.
Yes.
Yes. And you, having explained what your evidence is doing, you then proceed to consider the legal and policy position. On the legal position, paragraph 7, are you a lawyer?
No, I'm not.
Okay. I didn't think so because you haven't put it in your evidence. So,
Yes.
but notwithstanding that, you have sought to set out law from the case of Wyatt and Fareham Borough Council in paragraph 8.
Yes.
Is that your summary, or someone told you to put that in? Is it your identification of what is relevant for the purposes of this inquiry, or someone else's?
It is taken from, through my choice, I used a summary that was in the statement of case, our statement.
It's your summary of the case. You've got 4 numbered or lettered paragraphs
Yes.
in summary. So is that your summary of the
Oh,
case?
it is my summary. It is my summary. It has been taken from, or I've used other sources to make that summary.
All right.
But it is my summary, and I agree with everything that's in there. Though, yes. Otherwise, I wouldn't have put it in my evidence.
Yes. Okay. I just wanted to.
Reflects my understanding of the habitats regulations.
All right. But can we, without interrogating on the law, but certainly questioning you about your summary as to whether it provides all the material from that case which you've clearly read, then can we just turn up L14? And which should be the case itself.
Sorry, let me just give me a moment, please. Yes, I've got that.
And if you're following this electronically, did you manage to get open CD, G10, G11, G12, and G14, which are the natural England responses?
I have, yes. 11, 12, 13.
Sorry to ask you to have so many documents, but if you, that's my set of questions are going to relate to natural England in the first place.
I'm missing one of those. Was it 14?
Yeah, G10, G11, G12, G13, and G14, I think it is.
Right. Give me a moment and I'll get G14 up. That would be the first Regulation 25 request letter.
Maybe I've got that reference wrong, but let's just start with CG G10.
Would it be G10? Sorry, yes, G10. Okay, I have those downloaded now.
It's we can look at each of the letters if you want, but I assume you've read the Natural England responses.
I have.
And let me just see if we can agree a fair summary of the position.
Yes.
CDG10 is a letter dated the 3rd of March 2022,
Yes, it is.
and it's Natural England's consultation response on the application. You can see that from the second paragraph, yes?
Yes.
They provide a summary of their advice in a box, identifying the potential for significant effects on a number of sites.
Yes.
And they indicate they need information about that. Without this information, they may need to object.
Yes.
Bottom of the box.
Yes.
Over the page, page 2, a shadow habitats regulations assessment has been produced in support of this application, LC Ecological Services, November 2021.
I see that.
So we're not going into any of the content at the moment, but it's clear, isn't it, that Natural England is being consulted on the application and is aware and has the shadow HRA.
Yes. Yes, that's
Good.
clear.
And I don't need to go through the detail of what they're saying, but they're picking out clearly points that they want covered.
I would presume so, yes.
Yes. Okay. And then if we track it through, CDG11,
G11, sorry. Yes, I have that.
so 21st of March 2023, I think a year later,
Yes.
they're being consulted again, paragraph 2, see 5th of December 2022.
Yes.
And bottom of the page, they've been provided with the updated shadow HRA. Bottom of the page, a shadow HRA has been produced in support of this application. Page
Yes,
1
I
of 7?
see that. Yes,
Yeah.
I was just checking the dates at the
Well,
end, and that would appear to be an updated
Yes.
version. Yes.
Yeah.
I'd agree with that.
And they then similarly go on to express views on what they've read.
Yes.
And they're clearly aware of not just the HRA, but also material supporting the application that's been obtained. If you take, for example, hydrological impacts on page 3,
Yes.
they're referring to a letter from Stantec, 24th of May 2022.
Yes.
So without being tedious and going through all the material, what you have here is a Natural England second time consultation, updated HRA, but in addition, clearly aware of the content of the application and the subsequent materials being provided. Here, in this case, the hydrological update.
Yes. This is evidence that they are aware of the materials that have been provided by the appellant.
Yes.
So, yes.
And not only aware of it, but having sufficient time to consider it. They've been consulted in December, they're responding in March. There's no suggestion in this letter that they've not had enough time or they're not aware of information, save for that they asked for.
I don't think you can measure the time that individual officers would have, sir, to consider a case unless you understood their full workload and the resource pressures that they were under. Purely looking at the calendar and the dates which they received information and which they responded to that information is not an indication of the time they've actually had to focus on that information. If they are very busy, they might have had 10 or 12 or 300
All right,
cases.
let's both avoid speculation then. There's nothing indicating in this letter that they haven't had sufficient time or need more time, is there?
No, there isn't. No.
No, good. And then if you go to CDG 12,
Sorry.
this is an email 15th of December from the Sustainable Development Lead Advisor Thames Solent team back to the council. You get that from the bottom of the email, sir. Yet another consultation on the application. First paragraph.
Okay,
Yes.
So I'm there now. This is headed, dated Friday, December the
15th.
2023. Yes.
Exactly.
Yeah. Okay.
So nearly a year on, but later in the same year.
Yes.
And then they've been provided with the further updated shadow HRA from Ecological Services, LC Ecological Services, October 2023.
Yes.
And then they're dealing with a number of matters which they comment on. Yes?
Yes.
And then DD, is it G13? If I've got to.
Dated the 14th of May 2024.
Exactly.
Mhm.
Natural England responding to a consultation on the 17th of April 2024.
Yes.
And here, if you look at the bottom, page 1 of 6, not only have they been consulted on the shadow HRAs, they are now being consulted on the HRA by the County Council. Bottom of page 1 of 6.
Yes. Just
Natural England note that your appropriate assessment dated 7th of March concludes that the proposals submitted will not result in adverse effects on the integrity of any of the designated sites in question following the agreed mitigation measures to offset noise and recreational impacts being appropriately secured. Yes. It then goes on to refer to the conclusions about air pollution.
Yes.
And then they raise an objection about that.
Yes.
Air quality. Yes?
Yes.
So, again, fair summary of the position. Natural England being consulted yet again on the application, yet again on an updated shadow HRA, and now also the County Council's HRA, which I'll turn up in a minute. And insofar as they've got a problem with it, they're identifying what they think it is, in this case, air quality.
That is correct, yes.
And it's entirely consistent with Natural England's position. You would have experienced this, that they identify bases for objection and set out what those are. If they don't have an objection, they'll normally express that quite curtly.
Normally that would be the case.
Yes. So they've clearly read the HRA, including the section on noise and recreation. They're content with it. What they're not content with is the air quality.
They have clearly expressed that they're not content with the air quality.
Yes.
Yes. They haven't commented on the hydrological or recreational impacts.
No, but consistent with what we just explained, Mr. Andrew, and agreed, you wouldn't expect them to. What they would do is, if they had a concern, is express it as they did on air quality.
Sorry, I heard your question as saying they would express that quite curtly, that if they don't have an issue with it.
Oh, well, if you want the non-objection letter in a moment, we're going to get to it. But if they had any issue with the council's assessment of noise or recreation, they would express it in this letter.
I would hope so. That would be the appropriate thing to do. Yes.
And that's the normal way they work.
Yes, I would agree with that.
Okay. And again, no suggestion that they haven't had sufficient time or resources to consider the documents that have been provided to them.
No suggestion from them, no.
No. Well, you say from them, from anyone. What do you mean from them? Who else could it be from?
Well, we're referring to their letters, so I'm commenting on
they're
those
the
letters.
ones who are looking at the document. So if they think there's a problem with the time, they're the only ones who could say that.
That would be right, yes.
Yes,
Yeah.
okay. And then the final consultation letter is in September, which I think is 15, G15, if I've got that right. Oh, it appears in a number of places, so apologies. I think it might be CDD6. Yes, it is. I don't quite know why it's in that order. I think it's because it represents the final consultation. I'm sorry, I can put that on my list. CDD6.
Yes, dated 25th of September 2024.
Yes. And now, because the application was turned down in relation to, amongst other things, air quality because of Natural England's objection, they've writing to the inspectorate because the inspectorate become the competent authority. And paragraph 2, this letter is intended to represent their new advice following the ongoing work. And this letter, they say, should be recognised at any forthcoming appeal as Natural England's revised and current position on the application. We've got that in the second paragraph.
Yes, just reading it. Yes.
Yeah, so they're expressly asking that this letter be taken as and be recognised as their statutory advice, as we'll show you in a minute, but their advice to the inspector in determining this appeal, aren't they?
Yes, I thought I just agreed to that. I said yes.
Good, okay.
Yeah.
And it is clear it's a position of no objection subject to appropriate mitigation because of the absence of the effects on any of the protected sites.
They are stating that they have no objection at this stage.
It's clear that they have no objection.
Yes, it is clear.
Yes, good.
Yes.
And they go on to explain, for example, the additional point about air quality that's been resolved. If you look at the top of page 2, further advice.
Yes.
And then there are a few paragraphs which follow.
Yes.
1, 2, 3, 4, 5, which deal with the air quality summary. Will not result in adverse effects. Additional advice, please refer to our previous letters, which I've already taken you to.
Yes.
So they're asking for the whole package to be treated as their advice on the scheme. Demonstrate our trail of advice on all the other matters, including, for example, hydrology. And they conclude, we previously advised on the above considerations, helping to secure measures to address the potential impacts from construction and operation on sensitive ecological receptors. We've got no further comments to make. Yes?
Yes.
So, again, no suggestion from Natural England, the Thames Solent team, Sustainable Development Senior Officer, that they haven't been able to consider fully the application, the shadow HRAs, the HRA, the materials that support the application in order to provide that considered view. Is that?
Yes, they haven't said that.
Well, there's nothing, and they haven't said it, and there's nothing inherent or implicit in the letter to suggest it. Asking for more information or saying we don't understand anything. Are they? Okay. And so far as the picture is concerned, for the inspector's perspective, they were Natural England's advice, as we know, was also based upon the County Council's HRA, Habitat Regulations Assessment, to use the full terminology, because I showed you that in the correspondence.
Yes, the correspondence dated 14th of May 2024.
Yes, that's the only thing they took exception to was the air quality point, which this subsequent letter then resolved.
That's right.
Yes. And if we turn up CDE 15, which again I don't think was on my list, apologies, but that is the County Council's habitat regulations assessment, which Natural England were considering.
Sorry, I'm struggling to get onto the system now. Sorry, could you give me that?
E15 it should be.
E15,
With
thank
my
you. Yes, the Council's habitats regulations.
without needing to go through it all, in essence, that sets out, doesn't it, the council's approach as then competent authority. No likely significant effects on the protected sites, I'm going to call them, so far as hydrology is concerned.
That was their conclusion, yes.
Yes, and no adverse effects to the integrity of the protected sites are concerned so far as recreation is concerned.
Yes, that's their
And
conclusion.
they've explained their reasons for both those views,
Yes.
which we can come back to if it's necessary. And so it's clear from the whole chain of material I've shown you, Natural England agree
With
those conclusions.
the conclusions of Hampshire County Council. Not at the time that the HRA was written.
Sorry, on hydrology.
Oh, sorry, on hydrology.
Air quality is not an issue between us.
No,
Okay,
it isn't.
So
No.
I'm just that's why I asked the question
be
about
accurate and
hydrology
and
recreation.
Yes, on those matters, their position was the same as Hampshire County Council's. Hampshire County Council's was the same as Natural England.
Great. Now, let's just then go back to your proof. Paragraph 8. And I asked you to open up L14. Have you got L14?
I thought I'd opened it. That may be one I missed, so I'll open it now. L14. Oh, yes. Yeah.
Yeah.
Wyatt versus Fareham.
Yes, your summary of the case.
Yes.
And you've set out 4 bits relating to, in effect, passages to be derived from paragraph 9 of Sir Keith Lindblom's judgment.
Yeah.
Yes? And putting it, we can ignore some of the case law itself. We'll not ignore it, but we don't have to go trawl through it. But you, in effect, deal with some of the paragraphs here, but you omit subparagraph 4. In your summary of what's the inspector, as the competent authority, is required to do, don't you?
Not a deliberate omission.
Oh, I didn't say it was, but you've omitted it.
I have omitted it.
And it's important, isn't it?
It is important, yes.
Right. If you were rewriting your proof, you might, in terms of this case and the summary, you might well have directed the inspector immediately to paragraph 4 as well, because in these circumstances, the competent authority, sorry to refer you to you as that in personal terms, but that's your status. The inspector, as the competent authority, is not just entitled, but is actually expected to give significant weight to the advice of, in this case, Natural England, the expert national agency. And he can, as a matter of law, disagree with and depart from that advice.
Yes.
But if he's going to do so, he's got to have cogent reasons. It's elsewhere expressed as compelling reasons. So
Yes.
I think they're treated as synonyms, but you'll see it as either expressed as compelling or cogent reasons.
Yes.
Yes. Because although you mention later on the ability to attach weight to Natural England's view, you don't express it in those terms. And indeed, you talk about the burden of proof being on the appellant and in all of these assessments. But for present purposes, this is a fair summary, isn't it, Mr. Andrews? In fact, in order to accept your different view of the world, the inspector's got to have compelling reasons or cogent reasons for rejecting Natural England's advice. That's the correct position, isn't it?
As far as I can see, that's the case, but as you've rightly pointed out, I'm not a legal expert.
Well, I know you're not a legal expert, but you're the one who's purported to set out the law for the inspector here. That's why I've got to ask you about it.
Of course, I understand that.
Yes. Were you aware of subparagraph 4?
I'm aware of that, that is the case, yes. Yeah.
Right. So it is fair to say, isn't it? Because you're trying to put a contrary view to that of Natural England. Mm-hmm. If the inspector is going to have to go with your view, he's got to have compelling reasons
He does.
to do so. Yeah.
Yes, yeah.
And insofar as they're going to be scope for matters of difference of judgment, let's assume, I'm going to assume generously that your different view falls within that scope, just difference of opinion or judgment. I'll come to your difference of opinion in due course. But insofar as there might be differing opinions, that's not going to be good enough. He's got to have compelling reasons for rejecting the expert national agency's view on the subject.
Yes, he does, and I believe that's what I've set out in my evidence.
We'll come to the substance. I just want to get the context right for when we look at your proof, because as I said, you yourself aren't offering an alternative shadow HRA, you're just criticising what's gone before.
I'm not offering a shadow HRA. I'm not doing doing the appropriate assessment. I am stating where I feel there is reasonable scientific doubt.
Oh, okay, we'll come on to reason, but it's in the context of Natural England, the expert national agency, having reached their judgment. We'll come on to look at the 2 points you've raised, hydrology and recreational,
yes,
in a moment. Okay. So you also, I don't think we need to spend a lot of time on it, but paragraph 7, there's some reference, I think, in your evidence, or perhaps your counsel's opening, to the concept of certainty and satisfied beyond reasonable doubt on adverse effects on integrity, subparagraph 7.
Sorry, which document are you referring to?
Subparagraph 7 of L14, which is the judgment.
Oh, right.
There's
yes.
a discussion about this concept of certainty, but it's not absolute certainty halfway through. That would be disproportionate.
Yes.
And authorities can, from their point of view, be certain there'll be no adverse effects, even though from an objective point of view, there's no absolute certainty.
I'm sorry, could you say that again? I missed the beginning.
Just reading from it, it's Advocate General Cocotte's opinion in the Vodensee case.
Mm-hmm. Yes.
And being cited here by the Court of Appeal. the necessary certainty can't be construed as meaning absolute certainty. The conclusion of an appropriate assessment is of necessity subjective in nature, and competent authorities can, from their point of view, be certain there will be no adverse effects, even though from an objective point of view there's no absolute certainty.
Yes.
And it's pointing out, if you're talking about certainty in this field, that of course there are going to be judgments to be made which are subjective in nature.
Yes. I believe that's what that is saying. Yes.
Yes. So, putting those two things together, if Natural England's reached a view certain that there are not going to be adverse effects on the integrity, exercising their expert judgment, subjective in nature, the inspector, to depart from that, is going to have to identify compelling reasons or cogent reasons.
It sounds like the question you asked a short while ago, and I think my answer was yes, so I'd say
All right.
yes again. Yes.
Well, I'm putting the two together, but sorry if I'm repeating myself,
No,
that's
no.
fine. Okay, good. All right. Thank you. Right, then can we then turn to just Natural England's role here? Natural England obviously is, as we know, the expert national advisor, but in addition, Natural England, of course, is responsible for the SPA, SAC and Ramsar's protected sites.
Yes, they are.
And therefore, they are particularly well suited or experienced to make judgments on, for example, impacts of recreation and whether they'll have an adverse effect or not.
I'm sorry, could you repeat the question?
In consequence of what we just agreed, Natural England are particularly well suited and expert to be able to make judgments on, for example, recreational impacts on the protected sites.
Well, I think in answer to that, like any authority, any organization, an organization is made up of individuals with, and those individuals will have varying levels of skill and experience and so on. And Natural England will largely be staffed by ecologists, and they will rely to some extent on information provided by other topics and even by other ecologists. They're not necessarily experts on recreation. They may be experts on the species and habitats within the European sites, but that doesn't necessarily make them recreation experts, for example.
Well, that wasn't my question. But I was talking about Natural England as a body. We don't know who they use internally to provide their responses and what expertise they draw on, but they provide a response. And my simple question was that they're particularly well suited as the body responsible for these sites to make a judgment on impacts, for example, on recreational impacts on those protected sites.
Yes, I would agree with that.
Right, let's then turn to the two issues in dispute. Hydrology first.
Okay.
And the first point of context, important point of context here, of course, is that the conclusion by Natural England, by the appellants experts, by Hampshire County Council, and also the Environment Agency and LLFA, are all directed at the first stage of the habitat regulations assessment. Are there going to be any likely significant effects to any of the protected sites? Correct?
Yes.
And without going through all the case law on the meaning of likely and significant, but possible, etc., but that's what we're looking at by way of a threshold test. For these purposes, likely significant effects as interpreted in the case law.
Yes, what we're looking. Yes, my understanding is that the interpretation of likely significant effects is that there are possible significant effects.
Okay. And we obviously have some differences of view. I think there's not so many differences of view now between Mr. Clothier and Dr. Clothier and Dr. Dewhurst as a result of questions I asked him. But putting it this way, Dr. Dewhurst's approach and that of the appellant has been to produce a scheme which doesn't materially affect the hydrological arrangements as a result of extraction and then restoration. That's the approach, isn't it?
I assume that was their aim. Yes.
Yes.
Yeah.
And we know the views of those bodies about whether or not we've achieved that. It appears Dr. Clothier may disagree. Yes? I think he does disagree, in fairness to him.
Yes.
Yeah.
If you're asking me whether Dr. Clothier disagrees, I mean,
that's what I'd understand, whether we've achieved it.
I don't want to speak for him.
No, okay, well, you're relying upon his evidence. But Dr. Dewhurst, for example, has put forward her analysis as to no change in the water quality, no change in the water quantity, and no material changes in the hydrograph arrangements. Yes, some differences in the ups and the downs, but no material effect on the flow. In short, that's
that's Dr. Dewhurst's position, as I understand it. That is correct. Yeah.
Yeah, and Mr. Clothier says, well, I don't know that, or I don't agree. It may be, and I think from the questions you had yesterday in chief, you weren't disagreeing about water quality. Is that right? You weren't agreeing with Dr. You weren't disagreeing with Dr.
Yes.
Dewhurst.
To be clear, sir, what I was confirming, and what I think Mr. Strawn is asking me to confirm, is whether I agree that there are no issues with the quality of the water coming off the site.
Yes.
Yes.
Yeah.
That's right.
The quantity?
Well, the quantity, I think I made clear yesterday in my evidence in chief that if one looks at the overall quantity over the course of a year, I think I use those words pretty closely.
I don't mean to cut you off, but yes, that's what I was referring to. If you're talking about then the hydrograph changes and flow, which I think is the only thing you mentioned yesterday, I wasn't talking about that.
Yeah. Well, as I was saying, yes, if you're referring to the total quantity over the course of a year, then I agree that the total quantum of water on the site minus the 5% that will be used elsewhere will eventually make its way through the springs back into the estuarine environment. Right. Yes.
And it's not going to be my purpose, Andrew, to question you about the significance or non-materiality or non-significance of the differences in flow that Dr. Dewhurst covered in evidence already. I'm not going to do that because you're not a hydrologist. I'm going to focus on how what difference there is between us,
yes,
which I understand to now be limited to a question about the extent to which the flow may vary during the year.
Yes, I think that for the most part, that's a reasonable summary. Yeah.
Okay, right. Now, thinking of hydrology and no likely significant effects, it's not the first point you take in your brief, but logically the first point to consider is what's in paragraph 27, because you've raised it for the inspector, he's going to have to grapple with it.
27 of my proof.
Yes.
Yep, in there.
And this is your suggestion that the hydrological arrangements for the scheme are mitigation which can't be taken into account at the likely significant assessment stage, in short, if I've understood it correctly.
Yes, that is what my evidence was suggesting. Yes.
Yes. You appeared to move a bit yesterday in chief to say that, well, it was based on certain pieces of correspondence. I'm not sure if you're still pursuing
I would
this point.
disagree with that. I didn't move. I tried to explain why I felt that these were mitigation
Are you
measures.
still of that view?
What, that these are mitigation measures?
Which can't be taken into account at the likely significant effect stage.
My view is that there is an element of the mitigation measures which are aimed at protecting the European sites.
That's not an answer to my question, Mr. Andrew. I mean, it's a short point. Are you saying the inspector has to ignore the drainage mechanisms for this scheme when considering the habitat regulations assessment or not?
I'm saying that it is highly likely that he should ignore the most recent changes to the scheme because they were driven by considerations to protect European sites. In other words, the distribution of the infiltration features across the site. I think that is linked quite strongly through correspondence that I cited yesterday from the LLFA and from the Environment Agency, that replicating the distribution into the various catchments, the baseline catchments, is in part necessary for the in order to protect European sites.
Okay, so I think you're saying yes. You're saying they can't be taken into account.
Well, that element of it.
Which element?
The element of the most recent change to it.
Do you mean the restoration scheme?
The revised restorations.
So this point doesn't apply to the operation then? Is that what you're saying?
No, I would agree that it doesn't apply to the operation. If we're yeah, I mean, no, of course. If we're talking about the restoration scheme, it doesn't apply to the operation scheme.
No, I'm asking you. I'm just trying to establish from you. You've raised this point, so I'm hoping you can give a clear answer as to what your position is. We think you're wrong, but I just want to understand what your point is.
Yeah.
There is the scheme has a period of operation when the minerals are extracted.
Yes.
And then it's restored, and then it's in a restored state, restoration. That's what I'm referring to. I know you know the difference.
Yes.
Right. Are you saying that for the first stage of the habitat regulations assessment, the inspector has to ignore all of the drainage strategy for both of those phases, or simply in relation to the restoration stage?
No, I'm saying that if the right, I'll answer the question to the best of my ability. But what I'm saying is, if you, sir, believe that these features during both the operation phase and the restoration phase are nothing to do with protecting the habitat sites, protecting the European sites, then you would be right to take account of them at the screening stage. They are therefore essential features, essential characteristics, and not mitigation measures, as I put it yesterday. If you are convinced that they are not their purpose is not there to protect European sites.
Well,
That answer your
no,
questions?
that's just putting it on the inspector's shoulders. I'm asking you what your evidence is.
Well,
I know that's just formulating the question for the inspector. My question is what evidence are you giving to the inspector if you're going to raise the point? What's your view?
Well, my view, as I said yesterday, I don't know what the intent was. I can't know entirely what the intent was when these things were designed, but I can agree that they are principally for flood attenuation.
Right. Okay. And this notion of that it matters what intention, subjective intention matters, I can suggest is wrong, but I don't want to get drawn down there, Mr. Andrews.
Okay.
Let's just apply some, what I was going to suggest was common sense to it. This scheme can't go ahead without having a drainage strategy, could it?
No, it couldn't. No.
So it's obvious, isn't it, that the scheme as a whole includes whatever drainage solution is going to be put forward and approved.
Yes.
And it would be, and putting another way around, virtually impossible to conceive of the scheme without thinking about where the drainage arrangements are during operation and restoration.
Yes, I would agree with that. Yes.
Okay.
Yeah.
So on any sensible view, the drainage solution and the need to mitigate for, say, flooding of properties in the area is an essential part of the project.
For the most part.
No, for the whole part.
But is that your assertion? Is that a question?
Yes, that's my. I'm not making assertions. I'm putting questions that if they're not clear as questions, then do say.
Okay.
But my question to you is, it's an essential part of this scheme, the drainage solution.
A drainage solution is an essential component of delivering this project. Yes.
Right. Okay. And so far as the lead local flood authority is concerned, yes, they refer to protected sites in their response, as does the Environment Agency, but they require the restoration scheme to mimic the catchments in order to avoid the prospect of different flooding impacts to properties from the restored state, don't they?
No, I don't think that's entirely correct. Because why would they have referred to the habitats regulations and the protected sites?
The same reason the Environment Agency do. The fact that something also can have an effect or beneficial effect on the protected sites doesn't mean that it's not an essential part of the project itself, does it?
If what you're asking me is, can something be an essential part of a project and still incidentally protect?
Well, that's, yes, it can have both effects. Yes.
Yeah.
But it doesn't change the essential nature of it for the project in and of itself.
Change that. Sorry, I'm now struggling.
Let me just put it in really simply then, Mr.
Okay.
Andrews.
Okay.
The lead local flood authority require of the appellant a revised restoration strategy to mimic the current state in order to prevent a concern about flooding, and they would require that in any event. It's their approach to restoration.
Can you take me to the evidence where that's said? Because I think yesterday I was specifically looking at, I can't remember what it is now. I suppose it was their most recent response.
It was now.
I think it was C2 where, although it's not directly their response, it's Stantec have quoted their response, so if that's helpful,
Okay.
we can look at that. So that's
You've got it as D5, I think. That helps you.
no,
You
sorry,
put it
maybe
up on
that's
the
not the right
screen.
one.
Put it up on your screen because I haven't got mine.
That may not be the correct one. Sorry. Is it B102 perhaps that I was referring to yesterday? Let's see. Yes, B102.
B102.
Section 2, Stantec quote the LFA holding objection.
Yes, sorry,
Sorry,
what's
no,
the
I'm sorry.
point?
So yesterday I referred to the second paragraph, which
Yes.
says the concern relating to post-restoration ground profiles is significant given the impacts on the change in hydrology, and therefore the assessment and conclusions within the environmental impact assessment and habitat regulations assessment. It may also affect other submitted proposals.
Yes,
Yeah.
but if you read the first bit, they're concerned about overland flows between the pre and post development situation. And our previous response remain, and our position has not changed. They, as a matter of principle, raised for their approach a requirement to mimic the drainage flows that are currently on site
Yes.
because they're concerned about flooding.
Well, that is their principal concern.
Yes,
Yes,
okay,
because
so,
that's the
all right,
nature
it doesn't matter for my purposes
Yeah.
how you construe it as principle and also being interested in the European sites. But one of their principal concerns is to ensure that the revised restoration drainage strategy mimics the flows that are currently experienced on the site for drainage, for flooding purposes. Correct?
Well, as I say, if you could take me to where that's explicitly
Right,
stated.
that first paragraph, but we can go back if you want to their various consultation responses where they required us to, I mean, it's in the reason for refusal.
You're welcome to take me back there, but I'm not seeing anything obvious apart.
Right. Well,
where they state that this particular change, that distribution around the catchments, is principally for that.
well, they don't say principally, do they? They say it's significant as well. I mean, they don't say as well, but the first point is the first paragraph, and the second that it is significant in terms of European sites.
No, I was referring to principally for flood control.
Oh, I see, principally for.
Yes.
Okay.
Yeah.
Well, that is their principal statutory role.
I accept that, and
okay.
a moment ago I accepted that, but it's not explicit to me, unless you can point me to evidence that they aren't equally in this case. Regardless of their role, they are talking about habitats regulations assessment, which isn't a flooding issue. So they're actually straying into territory which is perhaps outside their remit, we might agree.
That's fine, Mr. Andrews, you're missing the point. It's sufficient for my purposes that one of their principal concerns is flooding, to address flooding, and therefore to mimic the off-site flows.
As an organisation, yes.
Yes, okay. If that's right,
Yeah.
and we can debate it, but I'm not going to go through all their consultation responses, but let's assume that's right, and I can show it to you if we need to. But then taking the test in your own evidence, your own water industry report, paragraph 2.1.31 of Mr. LaHaye's rebuttal. If you turn that up.
I'm sorry, could you give me that number again?
2.1.31. He just quoted from one of your own
Yes.
pieces of
Yes, I
work
recall that.
on this subject.
Yes.
I mean, he's got the eco advocacy test, but if
I can see him.
2.1.31.
Yes, I'm on it.
Essential features of those are essential and separable, even though they may incidentally have benefits of avoiding or reducing the effects on European sites.
Yes, that's what I believe I described yesterday.
Given the
Sorry, I was just going to finish my statement, if I may. Yesterday, I think I explained the distinction that is quoted here. So, of course, I agree with that. It was
I'm
guidance
just
that I
applying.
wrote.
That's fine. And I'm just applying. I'm taking you to. I haven't put the question yet.
Yes, of
I
course.
wasn't asking you to agree with your own text.
Okay.
You asked me if the reference, here it is. On the lead local flood authority's principal role, I don't mind if they're also interested in
Yes.
habitats, but on their principal role, requiring the site to mimic what's there in order to address flooding, they may also see it as significant for the European sites.
Yes.
This is an essential and inseparable part of the project from their perspective, isn't it?
If their principal reasons for it is for flood risk management, then yes, I would agree.
If you say principle, that's good enough for me. But even if it weren't, if provided it's still essential, if they're not going to give us planning permission or recommend grant of planning permission without a restoration scheme which mimics, then it's an essential part of the project. Obviously, I mean that's what I'm putting to you, Mr. Andrews.
So, from my point of view, to try and explain my position, if I may, the scheme was developed over many years and got to a point quite recently where this mimicking of the surface contours was not part of the scheme. It was a late addition based on LLFA advice. So a scheme, and a very well worked up scheme in terms of how far developed it was, could have been delivered without that change.
No, because we wouldn't have got the LLFA's consent.
No, exactly. But the LLFA's comment was partly based on concerns around the habitats regulations assessment.
We've already been through that. Let's assume it was. That it's partly based on it.
I don't think we have to assume
matter.
That. I mean, it's clear in
fine,
the
Mr.
correspondence.
It doesn't. But we're beyond that. We're just saying.
No, but you use the word assume. I don't think we need to assume that. I think it's in their letter. It's clear.
We're beyond that question.
Yeah.
I'm just turning it round the other way. It's also, let's assume, even if it were joint consideration, it doesn't matter. It's essential for the LFA to have a scheme that mimics the water hydrology arrangements because of their approach to flooding. That is the position, isn't it?
As I say, I've asked if you could take me to where they've stated that their principal concern is flooding in this matter.
All right, let's try and keep it within your area then. If that's the case, if it's essential to the LFA for flooding purposes to have a scheme that's necessary to replicate or mimic, then it's an essential part of the project for the purposes of your own test, isn't it?
Okay, so if we're dealing with it in order to get past this point as a sort of hypothetical, you're saying if this is an if then it comes back to what I was saying to the inspector a moment ago, which was if the inspector feels on reading all the evidence and the LLFA's responses that change that they required was even in part, principally or half and half, as you just described it, for the purposes of flood risk control, then I would agree with that. So
right.
Yes, if
you agree.
Yes.
Okay. Well, that's simple. Thank you. Good. Let's just then think about the point you raised yesterday, having raised this point, whether it actually matters. If, however, on your analysis, somehow this could be treated as not essential, but just entirely there for the habitats as mitigation, yes?
Yeah.
Then all that would mean was that one would be into the appropriate assessment stage,
Yes.
but one would have not got any different judgment from Natural England or anyone else because they've already satisfied themselves that there are no likely significant effects taking account of the mitigation. You made this point yourself. It's somewhat of an academic point. Here we all are looking at the...
I didn't make that point in relation to
right,
Natural
okay.
England's response. I made it in response as a general point for this inquiry, but that wasn't in relation to Natural England's response. No, my view on that is that if, and this is quite critical to, crucial to what I'm saying, if, as I believe, as I believe it should have been, that the hydrological issue was taken forward to a full appropriate assessment, and that appropriate assessment was indeed appropriate and given the full treatment that an appropriate assessment should receive, then Natural England would have had more information to make a more informed decision. But because a decision was taken to screen it out, they didn't have the benefit of that additional information and the detail.
Well, no, Mr. Andrews. The Natural England are satisfied. All that would happen on your analysis is you ignore, and I'm not sure how you do this, but hence the problem I was putting to you, but you somehow ignore any of the drainage of this scheme. And you say this isn't part of the scheme. It makes it quite conceptually difficult, which is my point earlier to you. Your interpretation must be wrong. But we try and do that. The inspector says to himself, though, this is just for extraction and restoration, but I can't think about where the water goes at this stage. At the appropriate assessment stage, you then do take into account precisely the same mitigation strategy, which is mimicking, etc.,
Yes.
which Natural England has already concluded has no likely significant effect on any of the protected sites.
Okay. I think I understand your question or statement that you're asking me to respond to.
Well, it's just I'm just putting to you those are the facts, aren't they?
Natural England have considered the mitigation, whether we call it essential features or whether it's mitigation,
yes.
in their response, yes.
Yes.
Yeah.
And they're satisfied. There are no likely significant effects on any of the sites.
They're satisfied based on the information they've received,
Yes.
which only took the assessment through to a screening stage. It didn't go on to a full appropriate assessment where the test is higher, the test and the information that would be brought to bear would have been more informative.
Well, so you assert, but there's no basis for asserting that.
I disagree.
Well, okay, that's the point of disagreement. In fact, they've got all the material. Everyone's got all the material. The inspector's got the same material to make the judgments that have already been made about no likely significant effect, i.e., there's no material effect on the change in the water. Hey presto, no effect on the...
No, I disagree. I don't think that Natural England have all the material. In fact, I think that's part of the problem, is that they'd have, at the time that they responded in any of those letters that you've taken us to, they didn't have the amount of information that's in front of the inspector now.
Well, they have, well, maybe not the amount, because that's just what happens with appeals, is that the information mushrooms. But just stop there a moment, Mr. Andrews. We've already seen that they had the shadow HRA, they had the HRA, they had the representation responses, which I haven't taken you to all of them. We saw one about Stantec on hydrology, explaining how the hydrology works. So what you just said is just wrong. They had all the supporting material.
No, they didn't have the full information. They had what I would consider flawed information,
Well, that's a different point. That's
Okay.
that's just your different judgment on it. But they had the
They
information.
had the information that was given to them.
Yes.
They had the
Which
information that came from the appellant, your client, as part of the application.
Yes.
And that is what they had to go on. There's no I don't have any evidence that they've seen the evidence provided by Mr. Clothier, that they've considered those other scientific arguments, the reasonable scientific doubt that we are casting on that information, which we've been doing so since 2023.
Yes,
So they've seen a one-sided view of the issue.
No, I don't think that's right, actually, Mr. Andrews. They have access to the application and supporting material, and I think I'm pretty sure to your objections, but it's not really the point, Mr. Andrews. They have reached a view as to the effectiveness of the mechanism, the mitigation. So whether it's treated at the likely significant effect stage or at the appropriate assessment stage, there's not going to be a difference of view. I know you differ on the
No, I'll try
detail.
and address your question as directly as I can. I have not seen any evidence in any of the correspondence from Natural England that they recognize the issue that we have in terms of the change to the hydrograph at the springs and how that could potentially affect organisms and habitats that are qualifying features of the European sites through nutrient dilution. I haven't seen that. They haven't appreciated that because it wasn't really dealt with within the information that they received from the appellant.
Well, you're just getting into the debate, Mr. Andrews. There isn't such an effect so far as everyone else is concerned. So you've got
They haven't considered it.
Well,
so
you
say
all right.
they're not concerned with that. But if they haven't actually seen that argument and had an opportunity to consider the evidence behind that argument, then they wouldn't have. They may have reached a conclusion that is lacking in the full information. That happens a lot of the time.
Well, so you say, but Mr. Andrews, I'm going to press on because I don't accept that characterization. I've given you a chance to identify what it is that's different in whether you treat this as mitigation or which is part of the embedded mitigation or mitigation which is then treated subsequently. We're going to go round in circles if we continue to disagree. So I'm going to move on. Okay. All right. If paragraph 23 of your proof.
Yeah. 23.
Yeah.
Yes.
And this is something of a moving target, Mr. Andrews, but your evidence to the inspector was based upon your understanding and Mr. Clothier's understanding, which was incorrect, that during operation, water is diverted to the northwest of the site and flows off.
Yep.
That's just wrong. Yes?
Yes.
And reduced base flows after operation, see Tony's Clothier's evidence, could increase the already unfavourable nutrient concentrations in the Hamble's European sites, was the point you were making.
Mm-hmm. Yes.
It's right here that in your evidence, the point you were raising was a concern about increase in nutrient concentrations.
Yes. Do you mean in that paragraph?
Well, in your proof. That was the issue you were raising.
Well, also changes. I've mentioned changes in salinity as well. So it's
In what?
in salinity. I mentioned that in my proof, I believe.
All right. Where's your? I'll come to that. But which bit's that?
Paragraph 19. I say in the second sentence, in particular, these could affect zones of transition from fresh water to the receiving saline and or more nutrient-rich raw waters near the mouth of these small streams, where they may be qualifying habitats and species of the designated sites that depend directly or indirectly on the existing hydrology, water quality, and salinity.
Okay, so I've got nutrients and salinity.
Yeah, those are my concerns.
Okay, and let's just test it. And so just to be clear, I'm just going to ask you some questions now, Mr. Andrews. Our position is, don't want it to be misunderstood, there is no material effect on water quantity, quality and flows for the reasons we've already expressed. All right? Yes. I'm just going to test the proposition that there is some change of any materiality in the flows in the hydrographs. We don't accept that at all for the reasons Dr. Dewhurst has given. We're just going to test, even if that were the case, whether there's any substance to what you're saying. All right?
That's fine. Yes.
Just want to set the ground rules, because otherwise people then say, oh, well, he's accepted. Right. So, on that assumption, if you were right, the first thing that you raised, the nutrient concentrations, and we were treated yesterday to views about things not expressed in your proof, eutrophication in relation to certain species. You mentioned the lagoon shrimp, I think, and the starlet anemone.
Yeah, I did, yes.
Yeah. Okay. None of which features in your evidence.
No, and yesterday I think the inspector uprightly pulled me up on that.
Well, I'm going to pull you up on it. Don't worry, Mr. Andrews. Okay. But let's just first of all on nutrients, nutrient neutrality. It is, which you raised, of course, the basic hypothesis of your contention is flawed, because the concerns about nutrients flowing into these water bodies and consequential eutrophication is nothing to do with dilution. It's to do with the amount of nutrients that flow. Otherwise, everyone would have a wonderful solution to all of the housing block that's afflicted this country just by pumping more water down the streams.
Right. In relation to the nutrient neutrality issue, in the way in which it's managed, that's right. The focus is on nutrient load going into the site.
Yes, it's got nothing to do. You can't address the problem by diluting it. Indeed, there's evidence that simply spreads the algal blooms. You get the same amount of nutrients.
Sorry, that sounds like new evidence in itself you're introducing.
Well, that is the case, isn't it? I'm asking Mr. Andrews, isn't it?
What's the fresher water spreads algal blooms? That's not something I'm...
You're not, okay, you're not aware of it. Stick with what you are aware.
Well, no, I'm not aware that it's evidence in Mr. Delahay's...
No, because I'm dealing with the way we were treated to this yesterday. So just focus on...
But what I'm saying is I've received criticism for introducing new evidence.
I'm not introducing new evidence, Mr. Andrews. Just focus on my question.
I know the reasons why you're kind of batting the ball back, because you had a serve batted at you yesterday, but
yeah, absolutely.
Let's just stick to what we're doing.
Yeah.
It's not helpful.
Thank you, sir.
You can't address nutrients, the problems with nitrates in water by dilution.
Why not?
Because the problem is the amount of nitrates going into the water and causing eutrophication.
Yes, but the result of that nutrient load is that the concentration increases.
No, well, you say the concentration increases in the water that's flowing into the water body.
Within a body of water, if you put a more nitrogen, a heavier nitrogen load, it's increasing the overall concentration.
Let's try it the other way around, yes. Mr. Andrews. You point the inspector anywhere to where there's guidance or support for the proposition that diluting nitrates is a mitigating or beneficial way to deal with the problems of nutrient neutrality.
I'm not aware. I can't point. No, I can't at this point in time do that. I can't. That's not what I'm proposing, though. I'm not saying it's a deliberate form of mitigation. It's part of the baseline. That's a very important distinction. I'm saying that there is an environment which is receiving diluting waters regularly through these spring flows.
Yes. So point me anywhere that identifies that it's dilution rather than the load of nitrate, not what percentage it is of a water, but the actual load going into the water, that indicates that dilution is of any materiality to this. You point me to any guidance on that.
Well, to come back to a word you used earlier, it's common sense.
Well, I don't think it is, Mr. Andrews, but that's your answer. I'm
So,
asking you first, just giving you fair opportunity because you
Yes.
raised this point.
Yeah.
Identify anywhere that problems of nutrient neutrality is addressed or is affected by dilution.
Sorry, are you asking whether it's nitrogen, the nitrogen issue within waters can be affected by dilution?
Yeah, it's a simple point. I think the suppositional theory is if the flow through this stream containing nitrates contains less water, it's more harmful. i.e., dilution makes it better. That's the supposition, isn't it?
My supposition is that dilution of nutrients reduces the problem. Yes.
Reduces the problem, i.e. mitigates the problem. That's the supposition.
Yes.
Yeah, and I'm suggesting to you that's wrong, Mr. Andrews, because I have been unable to find anything. That's why I'm asking you to identify any piece of guidance or approach of Natural England that supports that hypothesis.
Well, it isn't commonly used or published that it would be used as a mitigation measure deliberately.
Well, why not? If you were right that the problem of nitrates were addressed by dilution, then you would expect it to be identified as a form of mitigation. If you're wrong, however, that the important point is the critical load, to use the air quality term, but the amount of nitrates going into the to the sea, then you wouldn't expect it. So Mr. Andrews, I'm not going to spend a lot of time on this. Hold on.
Sorry.
You've raised this. It's all built upon a supposition. That's all I'm testing. We say it's not correct. But if you want to point to anything that supports this supposition, then identify it.
I think, in answer to your question, I think your premise and your logic is wrong. I think the reason why, if you're trying to find information that shows dilution, water of lower nutrient content being an effective form of active intended mitigation by pumping this diluted water into there, I think there are too many practical difficulties with that as a deliberate mitigation measure. But there's no practical difficulty with leaving a freshwater stream flowing into it naturally in place.
No, Mr. Andrews, don't go off on a tangent.
That's not a tangent. You said you look for mitigation measures where it's been used, and I'm saying
no, I didn't say that.
The practicalities of that are prohibitive, probably.
I didn't. I just asked you a simple question. I'm giving you an opportunity. I said all of this point about eutrophication is based on a supposition that the dilution of the nitrates flowing into the water body is beneficial or mitigation.
That's my understanding.
That's the supposition. We've agreed that's the supposition, and I've asked you to identify anywhere where that's expressed.
It's just my understanding of basic chemistry.
Well, you say basic chemistry. We disagree, but if you, I think I've given you the opportunity, haven't I? I mean, for example, if it's a Natural England document saying if you're going to have an effect on introducing more nitrates, they have to be diluted to a certain quantity, or one of the mitigation strategies for improving water bodies to put more water in the water courses, anything of that kind. I've been unable to find
I can't point you to anything. I can say that that everything in my evidence and that supposition was run past Dr. Clothier, who is a water environment expert, and he agreed with my position on that.
Well, this is about ecology.
No, I'm talking. I think I interpreted your question to be talking about
Would you
basic
want-
chemistry.
Put it another way, any evidence that suggests eutrophication is worse with the same quantity of nitrate, but with different dilution effects. Because that's the basic flaw in your analysis. So the eutrophication that takes place in the water body, you talked about algal blooms.
Yes.
Any evidence that it's worse without more water, i.e. the amount of nutrients will create algal blooms and the diluting them through the streams mitigates that.
I'm sure there's plenty of evidence out there that shows that high nutrient concentrations lead to increased algal blooms, increased eutrophication.
High nutrients?
Concentrations.
Yes. Well, so you say, but worse. I can't, I've given you the opportunity, I'm going to move on. But
I'm
right.
really struggling to see how anybody with even a basic understanding would question the fact that.
Well, that sounds a bit disrespectful, Mr. Andrews, but the reason I put it to you is because there is no such guidance, mitigation strategy, or anything that I'm aware of, which I'm asking you to point to, which talks about dilution of nitrates in a water body having that beneficial impact.
I'm not aware of that as an active mitigation, an intentional mitigation measure.
Or a beneficial effect.
Well, I am aware that it is a beneficial effect because my understanding of how the system works.
I know you were just going back to research, and I'm talking about any guidance documents or anything of that kind.
I can't cite a document to you now
about that,
but because it's such a basic understanding that I don't think one needs that.
Well, so you say. We disagree, Mr. Andrews. If it was so basic, one would expect it to see a feature in the way of addressing.
Not necessarily. If something is so basic and taken as read, it may not feature in literature.
Okay, I'm sure Naturally would be very keen to introduce such a beneficial strategy if it existed. But
I'm going to be retaining existing freshwater flows going into European sites. Yes, I'm sure they would be very.
By dilution, the dilution.
Yes,
effect,
and the dilution.
Yeah, well, okay. Well, let's wait and see if they adopt your. But there's nothing you can point to at the moment.
I can point to the supplementary advice on the conservation objectives, which talk about freshwater flows being important to the European site.
Not the point, is it? We're talking about eutrophication. Okay, I'm going to move on because I've given you the opportunity. All right. And then, of course, in reality, you accept that the scheme is not introducing any pollutants.
Yes, that's right, yeah.
And in terms of the effects that you raised on the lagoon shrimp and the starlet anemone, yes?
Yes.
Forgive us because you only raised this yesterday, but isn't it fair, Mr. Andrews, that both the lagoon shrimp and starlet anemone are occurring in and identified in the Ramsar as occurring in saline lagoons?
Well,
the clue might be in the name lagoon shrimp, but is this something you've looked at before you've thrown into the inquiry?
Yes, they rely on brackish water environments.
No, they do, yes, but they rely upon particular brackish environments, namely lagoons, and the associated.
Yes, they are
Yes.
associated with lagoons.
Yes,
Yeah.
and the where in the Ramsar those are identified, you didn't bring to the attention of the inspector, but they are, aren't they?
Sorry.
In the Ramsar designation,
Yes.
the locations where lagoon shrimp and starlet anemone, I forget that terrible pronunciation of anemone, they are identified as occurring in saline or brackish lagoons, aren't they? In specific locations. Or is this not something you've looked at?
That, I haven't, well, I don't know if what you're referring to specifically, no.
Right.
I use those as an example.
Well, it's not a very good example, though, is it, Mr. Andrews? Because there aren't any lagoon shrimp or starlet anemone in the areas where we're draining into.
You haven't, the appellant hasn't done the surveys.
You don't need to, because it's the qualifying features of where these fauna occur is already identified in the Ramsar designation.
That doesn't mean that they don't occur elsewhere. I mean, they occur. Species will be recorded in a number of locations, but the lack of any records doesn't mean that they don't exist unless you search for them.
Right, Mr. Andrews, we are getting a flavour of this because go back to the tests of likely significant effects, proportionality, and you can throw up as many points as you want and do it in chief, but the inspector has to apply a bit of proportionality here. If you were going, in fairness, to raise issues like the lagoon shrimp and starlet anemone, you would have at least drawn the inspector's attention to the fact that they occur in, and identified to occur in, lagoons behind sea walls of a saline environment, and there are a number of them mentioned, none of which are anywhere near this location.
That may be the case.
Yes. And that would be a proportionate and certainly reasonable scientific approach, wouldn't it?
I think a proportionate and reasonable scientific approach would have also included survey of the...
No, don't answer my question first.
Oh, yes, that would be a... Yes,
You wouldn't look...
qualify that by saying that it is also a proportionate and reasonable to actually do surveys for qualifying features around the outfall.
Only if you're going to have an effect, which we've already agreed. But even then, you wouldn't do a survey looking for a lagoon shrimp and starlet anemone or be concerned about them if it's not the right environment for them. Would you? That's not reasonable or proportionate.
If it's entirely the wrong environment, yeah, that would be...
Where's the evidence that the lagoon shrimp lives or can live?
I don't have access to any evidence at the moment to give to you on that.
Right.
Yeah.
And then on the question of salinity, well, that's linked, I suppose. Can you just help us where you've taken your photograph?
This photograph was taken on the edge of Badnam Copse woodland.
Yeah, I know, but
looking out over the mudflats at Badnam Creek.
Well, I know, but it's a very big area, so I just want to know where it is. Normally, when one puts in photographs, one identifies a viewpoint.
My apologies, sir, for not identifying the viewpoint. The best I can do is point you to Tony Clothier's.
Sorry?
The best I can do is point you to Tony Clothier's maps of where this stream, which emanates from Spring 6, enters the European site, and it was from that position that I took the photograph.
Where? Sorry, just refer me to...
Oh, if we look at Mr. Clothier's, I think it's his evidence. Sorry, Dr. Clothier.
What I'm asking you, just so you're clear, is you've got a map on page 12 of your evidence. Badnam Creek.
Yes.
So I'm just asking you to locate where you took it.
To do that, I would need to take you to Dr. Clothier's evidence. If you look at Dr. Clothier's proof of evidence,
Yeah.
figure 5.
Yes. Very small, but yes.
Okay, and if you look at the spring or groundwater issue
Well,
labels,
rather than take us through it, can you just locate where it is on the map, Badham, the one in your own evidence? You took the photograph, so
I did, yes, and
so where were you?
would you like me to draw a dot on here?
Yeah, that would be excellent if you could. I think the inspector's being invited to go and see it as well. Is that right? Or not? So is it on the site visit itinerary? Okay. Have you got,
Yes, I think it is on the site visit itinerary.
does that help? I'm happy to use that if there's a map. But just trying to work. All I'm trying to ask you to do, Mr. Andrews, is just plot it on the map you've introduced in your own evidence.
Okay, that's what I'm doing. In terms of the site visit, if the inspector is looking at the stream emanating from Spring 6 and following it down to Badnam Creek, he will see the location that I have taken that photograph from. But I mean, I've marked it on my map, but my printout copy is very poor.
If it's helpful, I'm looking at the site visit map, and I'm looking at viewpoints Q and R.
I don't think I've got.
So the question about where am I being taken to tomorrow, which is near Badman Creek,
Okay.
it seems to me that
Where's that?
it's possibly Q. I can't
So
confirm
would you
that.
like me to confirm? I can.
So if you help Mr. Fulbrook as well, I'm just looking at the site visit map.
Sorry, I'm not sure where to find the site visit map.
The site visit map it will be on the inquiry website. It will be. Does it have a document number? L76, Mr. Andrews.
Thank you.
And I'm not taking over here from Mr. Strawn. It's just the point that where am I being taken to tomorrow in relation to Badman Creek? The nearest point seems point Q, and therefore probably the question is a photograph in the vicinity of point Q. So the map looks like that, Mr.
Yes.
Andrews.
All right. Well, I've set everyone off on a hair's running. If that's the same location, that probably answers my question.
Yeah, point Q.
That's
That's right, yes, within the vicinity of point Q on that map.
Thank you. Can I then turn to the question of recreation
Yes.
and try and get through this quickly? Again, the same approach from that we've already. Sorry, sir. The same approach that we've already established, Mr. Andrews, applies here. The Natural England are content that there are no adverse effects with the mitigation proposed, which, if I can summarise and see if you can agree, includes the permissive path through the landscaped area during operation, and then restoration includes an additional meadow area.
Yes.
Yeah.
That's my understanding.
And let's just, for these purposes, just agree some ways of approaching this question, see if we can agree them. First of all, our proposal is for temporary mineral extraction from the site,
Yes.
followed by the restoration, not, for example, residential housing.
But when you say temporary mineral extraction,
Yes.
my understanding is it will be permanent. I don't think you're putting.
No, the extraction is temporary, and then I said restoration of the site.
Oh yes, temporary. Yes, it is
Two-
temporary. I mean,
there are
it's 7
two-
to 13 years.
Two
period.
phases.
But yeah, two
There's
phases.
extraction,
yes.
and then there's
Yeah.
restoration of the site. Yes. Okay. And we are not proposing new housing, obviously.
No, you're not.
So we're not introducing new residential development with the associated
That is
recreational
correct,
pressures
yes.
that come from new housing.
Yes, that's
Correct.
correct.
Okay. The unauthorized use, as it's been neutrally called, but unauthorized in the sense the landowner doesn't authorize the use,
Yes.
could be stopped by the landowner by re-erecting the fences which have been removed.
I'm aware that attempts have been made to do that, and they've failed in the past.
Well, people do break down fences. You're
so,
right.
So, as a premise, that I'm not sure the landowner could do that. Certainly not by erecting fences, because they've been shown to be permeable in that sense.
Okay, but they could erect fences lawfully, and if people knock them down
I assume
again,
so.
then it'll be
I'm not a legal
all right.
professional.
But in any event, it's currently used, unauthorized use, but it's currently used, and that's been taken into account and assessed.
Yes.
But there is no increase in the population in and of itself. So I just wanted to be clear that the policy of Natural England under the Solent strategy, and I did put this on my list, but CD 35 is how it started off, and there's an updated version in 2024, but we could start with CD 35. L35, sorry, CDL 35.
DDL 35, right. Give me a moment just to get that, please. Sorry, my access has just stopped. I'll just get back into it. Sorry, was that L35?
Yes. Let me know when you're there, because I'm conscious of the time. I'm quite keen
Yes,
to
of course.
press on. So I want to. Obviously, you need to get the document.
Yeah. Okay. It's just about open. I'm there.
Great. So this policy,
Yes.
the Solent Recreation, well, it's the Recreation Mitigation Strategy, is directed at addressing the introduction of new housing into the area, isn't it?
Yes.
And what the strategy identifies, just to be clear, since we're in it, is a strategy for management measures within the affected SPA, for example.
Yes.
If you can see that on page 4, the strategy proposes.
Page 4.
Yeah.
Sorry, I will just.
Page 4 of the document. Summary. Yeah, I'm looking at the summary.
Summary. Okay. Yeah. The strategy.
Yep. Paragraph 2, over 60,000 new homes are planned around the Solent up to 2034. I think that's been updated now, but
yeah,
I think there are even more now. It will lead to more people visiting the coast, potentially causing additional disturbance. And the strategy aims to prevent bird disturbance from recreational activities. It does this through a series of management measures which actively encourage all coastal visitors to enjoy their visits in a responsible manner, rather than restricting access to the coast or preventing activities that take place there.
Yes.
And so it then sets out the strategy. You see what they comprise? A number of measures which are all directed to precisely that. We're not in the business, I paraphrase this document, of preventing people coming to the coast and the many new residents that are going to come from the new housing that's proposed, but we're going to have a strategy to encourage them to come to the coast, but to do so in a responsible manner.
Yes. No. I
Right.
agree with that. Yeah.
And that's the way to address the adverse effects on the integrity of the protected sites.
The adverse
That's the strategy.
strategy to deal with
Yes.
housing. Yeah.
So it's fundamentally not based on the proposition that people who go to the coast equals adverse effects on the integrity which can't be accepted.
It's based on the premise that people going to the coast can cause disturbance to qualifying features.
It can, but you have a strategy then of management which avoids that effect.
A strategy which is proportionate to the risk from housing. Yes.
Yes, it's not about preventing people going to the coast. It's about, in effect, managing behaviour and
Yes,
use of
they're
the
management measures. Yeah,
Yes.
managing recreation rather than preventing it.
Yes.
Yeah.
So, insofar as new residents come in, and there are many, many predicted, we've just seen, the strategy is not one of saying, you can't come to these coasts, we have to prevent anyone. To the contrary, it's saying, what we're going to do is fund a number of measures to encourage people to continue using the coast for their enjoyment, but to do so in a way which doesn't disturb the birds.
Yes.
Right, okay. Just none of that's mentioned in your proof, Mr. Andrews.
Why? Sorry, I don't know what your point is.
Oh, your proof proceeds on the basis that if people are displaced from the appeal site into the SPAs, there's going to be an adverse effect on the integrity of the SPA.
There could be.
Well, you say there could be. The premise of this strategy is to address it through measures.
Yes, but that's not denying that there could be a problem. What this strategy does is offer mitigation for a recognised problem.
Yes, okay, so we're agreed. Just that you don't explain that to the inspector. We'll come to the significance of that in a moment. All right, but can we clearly agree, though, Mr. Andrews, that the fact, if it were to occur, people being displaced to the coast for recreational activity is a matter that, so far as Natural England are concerned, can be addressed through these sorts of measures?
Yes.
Yes.
I would agree with that. Yeah.
Right. Good. And that's not just me just summarising the position, because that's explained in the document in more detail. If you just go to, for example, paragraph 2.12, because the inspector will no doubt have encountered other areas like Thames Basin Heath SPAs, for example, where SANGs are a more common mitigation strategy than these sorts of measures. This is a different location. Suitable SANGs are a key mitigation measure at some other special protection areas, but footprint, because you're recommending caution for the Solent SPAs. In large part, this is because the survey showed many people visit the Solent coast for the sea views and the feeling of being beside the sea. 34% stated nothing could be done to make an alternative site more attractive to them. And a subsequent study concluded SANGs may have a role in providing mitigation if they are closely linked to management coasts, are targeted in the right locations, and are accompanied by active promotion of their existence. And so there's if you look in the document, there's some strategic SANGs proposed.
Yes.
But the premise of this document is to address the inevitability of people coming to the coast from the many new houses by measures to encourage them to do so responsibly.
Yes.
Yeah, fair summary?
Yes, that's a fair summary.
Okay. And then just to be clear, 6.12 The scope of this strategy is mitigating the recreational impact of new residential related accommodation. Separate mitigation may be required for other impacts which may arise from new housing. These will be assessed by local planning authorities with advice from Natural England at the planning application stage to identify whether, and if so, what mitigation is required. So just in summary here, this strategy applies to new housing. If you're not new housing, the guidance is recognising the ability to have different strategies in consultation with the local planning authority and Natural England.
Yes, I would agree with that.
Okay.
Yeah.
And that's also replicated, isn't it, in policy DM11 of the Eastleigh Borough Local Plan at CDH 11. Sorry, not on my list there, but if you've got
It's opening, sorry, it's being a bit slow.
policy DM11.
Yes, I'm just, it's taking a while to load.
You've got it.
Not yet.
No, okay,
It's
sorry.
still loading. It's
Okay,
nearly there.
sorry. Yep.
Nearly there.
Sorry, sir. I'm sorry, I'm going over time because
Yeah.
it's taking me a little longer.
Okay, I'm there.
Okay, so I wasn't putting you under any pressure. This is my fault. So DM11, international designations. Second page.
Second page, right, thank you. International designations, yes.
And development which is likely to adversely affect will not be permitted subject to imperative reasons. And then you can see paragraph 3, the council will work with PFSH, Natural England, the Environment Agency, to develop and implement with developers a strategic approach. Within Eastleigh Borough, this will include implementing the solar mitigation, recreation mitigation strategy, requiring contributions from residential developments. So that's the idea that you pay your contribution because you know your people are going to go there. You pay the contribution for funding the rangers,
Yes.
etc.
Yeah.
There's something about New Forest, so I don't need to worry about that. Or alternative agreed site-specific measures to address recreational disturbance.
Yes.
So if you were doing new residential, you would pay your tariff.
Yes.
If you're not doing new residential, but there's a potential for an effect, you can come up with agreed site-specific measures to address recreational disturbance.
Yes.
Good. Well, so far so good. And that then is precisely the approach which has been adopted legitimately here by the County Council and Natural England, which is to deal with any potential recreational pressure from displacement by looking at the site-specific measures that are proposed.
Yes.
Okay, good. So when one thinks about that, the site-specific measures are then require the exercise of judgment as to whether or not they're going to be effective.
They require the exercise of judgment informed by, hopefully by evidence and expertise, yes.
Well, sorry, informed by evidence. I mean, expert judgment is evidence. That's why you're sitting there, Mr. Andrews.
Yes, I'm sorry.
So why would you, I mean, an expert, Natural England's expert judgment of a SANG, if it were proposed for the size of it, would depend upon an expert judgment. If I'm a developer coming on with a residential scheme and I say I'm going to build a SANG next door of this size and dimension with these amounts of walks, someone's going to exercise a judgment as to whether or not it's going to be effective.
Yeah, but hopefully that would, each situation would be somewhat unique and site-specific, and hopefully one would gather sufficient data to be able to make sure that one's proposing as mitigation was appropriate and sufficient.
I don't know what you mean sufficient data. You need to know its size, yes?
Oh, yes, yes.
You need to know
Yes,
its location,
you need to know size, location.
proximity to the people it might serve,
Yes,
the area,
yes,
and how it might link up with other footpaths.
yes.
And
And
you
you
can
might
make-
also need to have some indication, evidence to indicate how people would use it, how they would feel about it.
Well, so you say, and that's why I'm suggesting, Andrew, you don't need that. In most cases, you wouldn't have that.
You say in most cases, what do you
Well,
mean?
if I'm proposing as a residential developer a SANG for my new residence, I'm not aware of any surveys being done to try and test that. You don't even know who your residents are going to be.
Well, there have been certainly plenty of surveys done to inform the solent mitigation
I'm
strategy.
not talking about the solent mitigation. Well, we know what the outcome of
we are
that is.
talking
I'm not
about-
talking about the solent. I'm talking about the site-specific measures here. As in, even if we were proposing residential development with a SANG, the experts can make a judgment on what's proposed with all the facts as to what's proposed. That's how it works.
Yes, I can accept that that is what's done. Yeah.
And that is evidence which can be relied upon by both a competent authority and indeed Natural England. I don't see why this is all controversial.
Well, it depends on how you define expertise. I mean, I make the point I'm not a recreation expert either, but I haven't seen anybody with particular expertise making a judgment on this, on recreational behaviour.
Oh, sorry, but Natural England's made a judgment on it. I mean, they do these things day in, day out, don't they?
Well, they've made a judgment in that they're not objecting, if that's what you're saying, on that
Yeah,
point.
well,
Yes.
they would object if it was going to have an adverse
They
effect,
would,
wouldn't
yes.
they?
If they believed it would have an adverse
Yes,
effect.
and they are expert, and they do this thing day in, day out. I mean, that might be exciting, but pretty much every working day, I imagine they have a proposal as to whether or not something's going to affect the SPA adversely.
Yeah.
Yes,
I take your point.
right, and there's nothing unusual about that. They make these judgments beyond reasonable scientific doubt.
Yeah.
Sorry, wait. They make those judgments beyond reasonable scientific doubt that a proposal will be acceptable or not.
You are correct. That is the usual. Yes.
Right, okay. They don't require surveys, do they?
They haven't in this case, no.
No. Well, they don't for SANG proposals for new housing.
I don't have full knowledge of every SANG proposal that's come about, so I can't answer that, I'm afraid.
Okay. And let's just deal with the principle of surveys. You, I think, fairly recognise, but I just want to pursue it, that if you tried to conduct a survey in this locality of these residents, it would be affected by bias.
Yes, I would agree.
And that's putting it mildly, and it's not meant discourteously to residents, because one of the many features of life is the concept of unconscious bias as well as conscious bias.
Yes, yeah, absolutely.
But one thing people surveyed in the area in respect of a proposal for something they don't like will be affected by bias is answering a question in a way, unconsciously or otherwise, tends them to a certain view.
As a proposition, I can accept that. I don't know that that's what's happened here. I don't know the people who have answered that questionnaire, and I don't know how, if you like, unbiased or biased they would have answered.
None of us know who answered the questionnaire because that's not given.
Yeah.
And in fact, it could be one person many times, couldn't it?
I don't know that.
Well, you can look at the way the survey was conducted. There's no mechanism of knowing or controlling it.
I can't dispute that because I don't know.
Okay, but let's just turn it around. If you were a scientist, Mr. Andrews, and you put forward a article to a respectable journal based on what you called evidence, which was a survey of the very people who have a strong view, i.e. opportunity for bias, you'd be quickly shown the door by that editorial journal, wouldn't you? That's not science. That's the opposite of science.
I take your point, and I think I've agreed that there could be an element of bias to the results.
but it's the opposite of science to conduct a survey which has built into it the proposition of, if not very large amounts of bias, very significant bias. It's not scientific.
It isn't particularly scientific.
No.
Questionnaires, surveys aren't particularly scientific.
No, but if you ask the questionnaire of people who are likely to be biased, that is not scientific.
Well, I think there's no hard and fast threshold for what's scientific, what isn't. I think it's a spectrum.
Yeah, well, that's not answering my question. I've already given you the...
Well, no, you've asked
just
me to
what about...
determine. You've asked me to come down one side or the other.
All right.
To be fair, as to whether it is scientific, I would need to know how you're defining scientific and what the threshold of evidence is for that, and the threshold of bias. Yeah.
Well, if you don't want to offer a view, it's a very simple proposition. We're absolutely convinced. And I think your answers are tending to it. If you would attempted to do a survey here,
yeah,
the results are obviously going to be affected by bias. You would have no way of being able to distinguish those people who are expressing views unconsciously or consciously because they thought it might achieve a result.
I would agree with that.
Yes.
Yeah.
Okay. So that is the first point about whether or not a survey is required. So it wouldn't be required, or it isn't required by Natural England. If you're tempted to do one, you're going to face the bias problem. And of course, the surveys you introduce, and they're inevitably tainted, to use a more neutral term, that's the legal language, affected by conscious or unconscious bias, aren't they?
There may be, yeah.
Yes, okay. The second problem with your surveys is, of course, that they don't actually, neither of them describe what is...
Sorry, they're not my surveys.
Well, the ones you're relying upon. You say the inspector should rely upon them, and I'm just testing whether that's right.
Okay, sorry.
I've dealt with the principle of them. But then there's the survey themselves. Even if you could ask people not affected by bias, conscious or otherwise, which we say you can't, but even if you could, you have to ask the right questions, don't you? A neutral, objective question.
Yes, that would be the aim. Yeah.
Yes, and so let's look at the two documents. L34, I think, is the first one.
Just before we get in that document, how much longer do you think you might be, Mr. Strahan? How much longer do you think you might be?
Sorry, sir. I hope only about 10 to 15 minutes, but
okay.
I don't. Did you want to have a break?
No, we'll get to the end. We'll make a judgment call at that point.
Sorry,
about a break. We just need to think about Mr. Andrews.
Yes, sorry, I've gone on. It's taken me longer than I expected. Sorry.
No, that's
not your fault, Mr.
I'm fine to carry on.
While I was doing that, can you refresh me?
L34.
Yes, I've got it.
L34. Sorry, you do need L34, but I think the first in time was L17. Sorry, you need that one as well. L17.
This is L17 being Survey of Airfield Users 2022.
You said there were two surveys, and this is the only. This is the one I've been able to find.
I said I believe there were two surveys.
Yes.
Yeah, I'm not familiar with this survey. But
oh, okay.
Yeah.
Well, maybe I don't need to spend much time on it, but we can see immediately from this survey that it plainly doesn't ask a fair or correct question because it doesn't identify any opportunity to use the appeal site during operation.
Okay, sorry, as I say, I haven't studied.
Look at the top. It's the second-hand column. If the airfield were no longer available, where would respondents go?
Yeah.
Well, that's not what's proposed.
No, it isn't. No.
No, so that's just not a reliable survey at all.
Yeah, if I've given the impression I'm relying on this survey, I'm not, because I'm not familiar.
Okay, well, I just have to deal with the evidence in front of me. Okay, so then let's go to L34. Thank you for your answer on that, but L34.
I did have that.
And
Smart marketing, yes.
yeah. And again, as I've made, Mr. LaHaye's made a number of points about the survey, which I don't need to go through, but just the question 11.
What page are we looking at, please?
46 of 53. You got it?
No, I haven't. I'm sorry. It's mine's saying it's 58 pages long as a PDF.
Page 51, question 11. Sorry, it's, I'm told it's might be.
51.
Oh, I got the wrong.
Thank you.
Not L43. L34. Thank you. Thank you very much.
Yes, I've got
What
it.
page?
So it's at near the bottom of the page.
Exactly.
Question 11.
Yeah. If access to the airfield was reduced to a single 2 to 3 metre wide footpath with a 5 metre high mound of earth on one side and a fence on the other, would you still use it? That's the question.
Yes.
That's not what's proposed either, is it?
There are elements of it that are proposed.
Yes, but obviously a significant element is left out, as indeed the HRA.
I think I make the point in my evidence that it's probably not the best description of what's proposed, but it certainly contains elements of what's
But
proposed.
it's just not a fair description, is it, Mr. Andrews? If you were interested in walking your dog, for example,
Yes.
you would be interested to know that there's a, whatever it is, 2 to 3 metre footpath, but set within a landscape area of 2.1 kilometres in length, in which your dog can freely roam.
Is that the case?
Yes.
That dogs will be allowed to freely roam across the
Yes.
full
Why not?
corridor?
Why not?
Well, is it stated anywhere? I mean, there's a permissive path that doesn't give, which is.
Well, do you want to turn up the landscaped, the plan for, sorry, you can look at it in a number of places, but the plan itself is CDB 61, I think it was on my list. Tell me when you got there.
I'm familiar with the plan, if that's helpful, so please do carry on.
Yeah, the footpath's running up on the right in a landscaped area.
Yes.
It ranges from 70 metres wide, 40, 41, 36, 36, 55, 43, 56, all the way up to point C. Then it goes down to, I think, about 28 to 30 metres at the top part of the site.
Yes.
Which I'm sure you can do your own calculations, but I'm told is about 7.8 hectares.
Okay.
And there's no mystery about this because it's in the council's HRA. They describe it as a permissive path within a landscaped area.
Yes.
Which is what Natural England were looking at.
Yeah, I'm not denying that there is a permissive path within the landscape area. What I was uncertain of, and you can correct me on this, is whether dogs would be allowed to roam free across the full of the landscaped area.
Well, yes, they are. But I mean, is that something you weren't aware of, or you had a question about?
Is that stated anywhere?
I don't know, Mr. Andrews, but what's the basis upon which you made your judgment that this is not an acceptable location? Are you assuming dogs have to be on leads?
Well, I don't know. That's the problem I have, is I don't know whether the people walking and their dogs will have to be restricted. What's shown as the permissive path, as the footpath,
in a landscaped area.
In a landscaped area. So I don't deny that people have views across the landscape area. I wasn't aware, and if you can point me to it, that people would be allowed to let their dogs run free through that landscaped area. It might have a nature conservation value whereby you wouldn't want dogs running free because they could disturb the wildlife, for example, because you're using it for wildlife mitigation.
I think it's in our evidence, but I'm reluctant to search around for it unless it's critical. Does it therefore change your view? If it is available for dog use, can we agree it's a large landscaped area, which first of all is nothing like what's described in question 11?
I would agree that it is a well, it's what it is. It's a landscape corridor either side of the footpath.
Well, corridor, it's, I mean, the inspector will see what's 70, 40, 50 meters look like, but
Yeah, I would describe that as a corridor.
okay,
yeah.
corridor. Well, fine. It's not what's described in question 11, is it?
I think question 11 is probably not the best description of that. If I'm honest, yes.
Yeah. Okay, that's fair.
Of course.
Well, it's fair. It's not. It's an understatement, I would suggest. But I'm happy to take your answer. Fine. And then just a couple of other things. In your proof of evidence, you've shown footpath linkages. Figure 5.
Figure 5, yes.
Yeah. And it's just that it's not the correct picture, I don't think, is it? You've left off the rail trails, for example.
Sorry, I've left off the
Rail trail.
The rail trail.
Have you walked around the area? There's a very long rail trail. I think it's the site of the former railway. Bits of railway paraphernalia appear occasionally, like a.
Yeah, these are public rights of way.
Well, I know, but I think the rail trail is a public right of way, or at least if it's a permissive path. Or
It might be, but then it wouldn't have been shown on this map layer. So what I've shown here, with the best will, best faith, in good faith, is a map layer showing public rights of way.
just look up CDD 14, the document I put on my list, please.
Sorry, is that something I should have open already?
Yeah,
Which one is it?
CDD 14.
14. Sorry, I'll have to reopen. Trails to explore. Hamble by.
Hamble Peninsula Trails. In fact, I think so. You can get this map at the Hamble station when there's a billboard as you come out of the station. But
It's not the same as my figure 6, is it? I'm just opening.
I don't know. It does look like it is. Or, yeah.
It's yes.
Figure 6. So
I am familiar with
CDD 14, that does show the linkages. If you locate our site, it's going to create the linkages along the bottom is the rail trail, points 5 to 6.
Yes.
The bottom end of the site. There's a current footpath on the edge of the site, but within our proposal during the operational phase, you're going to have that footpath, permissive path, through the peel site in that landscaped area. And then, of course, at point 9, it continues all the way round to give you access onto where it joins Hamble Lane, where you can then cross over and access the other trails moving to the Royal Victoria Country Park, for example.
Yes.
So it's not simply a 2.1 kilometre walk in a landscaped area. It's one that will connect up with a much wider network where you can walk, including the Royal Victoria Country Park, where dogs are also encouraged.
It will lead there, yes. I mean, whether or not Royal Victoria Country Park is suitable in the minds of most dog walkers, I don't know. I mean,
Although there
my
were lots of dogs there when I went there, but
talking to talking to local residents, it's my understanding that there are issues with Royal Victoria Country Park in terms of being able to let your dog off because there are children, there are ball games going on, there are barbecues, that kind of thing. So people feel more constrained there.
Well, we'll let the inspector judge. He can go and
Yes,
see it. But
of course.
yes, I again, we go back to what local residents say. I appreciate why they might say that, Mr. Andrews, but an objective judgment to be made about the opportunities for recreation in this area.
Yeah.
By any stretch of the imagination, they are significant, aren't they? With our permissive path and the landscaped area, linking up with the rail trail, linking up with the Royal Victoria Country Park, a spot for choice if you're a dog walker.
Well, the site already does that. I mean,
I appreciate
only it offers a lot more land to roam across.
That's not the point,
So-
Mr. Andrews. Yes, of course, there's going to be a reduction in the area, of course, because that's the purpose. But in terms of the ability to continue to walk your dog as a mitigation strategy, site-specific, you're still going to be spoilt for choice, objectively speaking.
I wouldn't say spoilt for choice.
Okay, well,
that's a very, you're asking me to make a very subjective decision, and I'm not a local resident. These things, I don't know whether people.
I'm not asking you to be a local resident, Mr. Andrews, and that's the fallacy of your approach. Natural England are the appellant, the county council, are making an informed judgment based on what's proposed as to whether or not it offers a reasonable mitigation strategy to avoid pressures.
Mm-hmm.
And the reality is, and the inspector will be able to do this, is that I know what people say now, but that in reality, they will be able to continue to walk their dogs and other exercise and access a very wide area.
Well, I don't. Do you mean when you say access a very wide area? Do you mean beyond the site?
Yes.
Okay.
It links
sorry.
up. Yes.
Yeah.
That's
Well,
one of the advantages. You don't have to crawl through a fence on the Hamble Lane thing. It's going to be a dedicated permissive path to link up.
Yeah, I mean, my response to that is that all of this network outside of the site exists, and it will continue to exist. But what you're doing is reducing the area within the site over which people can walk and roam, significantly reducing it. So this is all about displacement. So my feeling is, yes, you're providing mitigation, and there may be, and that may well reduce the displacement, but there will still be, there is still the risk of residual displacement because you're shrinking the area.
Okay, we can have an argument about that. I don't intend to, but these are the facts. A judgment then, expert judgment is made. Nothing wrong with that in principle, is there? So Natural England's entitled, for example, to say we're satisfied
Yes,
that this will mean no adverse effect, aren't they?
They're entitled to do that, yes.
Yes. And just to complete this picture, going back to the solar recreation mitigation strategy, even if people are displaced, that is not, as we agreed, equal to an adverse effect because of the measures that already exist to encourage responsible dog walking, etc.
No, I think that might be a mischaracterization of what we didn't agree that the people displaced from Hamble wouldn't have an effect. What we agreed,
that's not my question, Mr. Andrews.
No,
Even if they are displaced and go to the SPA,
yes,
the SPA has in place specific measures to deal with the ever increasing number of people that are welcomed
only in proportion to the projected housing, which is how the tariff system works.
Yes, we're not housing, hence why we've got our own strategy.
So what I'm saying is that there is, okay, if you separate out the housing, to my understanding, the solent mitigation strategy is set up to deal in proportion to the amount of housing development that is coming forward, and therefore proportionate contributions go towards paying for that management. As more housing comes in, more management is required, therefore more is paid for. You're not proposing, I don't believe your client, the appellant, is proposing to pay into that pay any sort of tariff. Instead, please let me finish. Instead, and I'm just summarizing what you said, you've gone for a bespoke mitigation strategy on the site. And what I'm saying is that instead, the bespoke mitigation strategy involves essentially reducing access from a 62 hectare site where people are free to roam all over and connect into local footpaths, down to a corridor which at its widest is about 70 meters, and takes them through at the edge of the site.
Right.
So there will be some residual displacement, I believe.
Right. Yeah. Even if residual displacement does occur,
Yes.
the Solent mitigation strategy is not suggesting that people coming to the SPAs is a bad thing. They are and have put in place measures, ranges, etc., to ensure appropriate conduct.
They
Correct?
haven't put in the level of management measures to recognise the extra number of people who will come from the site, who would be displaced from the site.
Okay, we don't consider that to be necessary, a tariff for our scheme. Natural England doesn't consider it necessary, bearing in mind bespoke mitigation strategy. But at best, your concern about displacement would be met by a payment of an appropriate tariff on your analysis.
I think that would be in keeping with the other, yes, that would be in keeping with how it's mitigated for housing.
Yes, okay.
If
Well,
is,
I understand.
If there is a residual effect, the size of that residual effect should be somehow, I know it's a very difficult thing to measure, but there should be a recognition of that in terms of additional mitigation.
Well, it's helpful to know because it's just where the end point of this. We obviously don't accept that's necessary. Natural England hasn't identified it. But where your objection leads to is that if there is residual displacement concern, it could be met by a payment of a tariff.
Yes.
Yeah, okay. Thank you very much. Thank you, sir. Sorry for that's it.
That's it. Thank you. That completes your cross-examination. Thank you. That's what I wanted to do here. I'm very conscious the witness has been here 2 hours, Mr. Fulbrook. I'm also conscious of the burden that places upon him in terms of contact, etc. I'm mindful, I think it's important that we have a break. He's been sat there actually about 3 hours, if truth be known, because he was here before I was here this morning. So he sat there patiently. Are you able to manage that?
Well, I was saying it might help you to know I've only got 3 short questions by way of re-examination, so I think we could deal with it very quickly.
Brilliant. In which case, that's really helpful. We'll go straight into re-examination of Mr. Fulbrook.
Thank you. So, Mr. Andrews, it was put to you that nobody suggests pumping more fresh water into an SPA or whatever as by way of a mitigation strategy.
Yes.
I just want to give you the opportunity to comment further on that if you want. I mean, why might people not be suggesting doing that as mitigation? And is there any difference between that and what's being proposed in this case?
Yeah, well, I think I tried to explain that my response to that is that it would be an impractical form of mitigation. If it was used as a deliberate form of mitigation, it would involve pumping quite over time what are quite large quantities of water. I mean, if you, in order to get that dilution factor. Now, when I say large quantities, I'm not talking about any more than comes out of the site, but combined, the springs lead to streams which flow over months and months. All added up, that's quite a large amount of diluting water. And to replicate that artificially as some sort of mitigation strategy would be potentially use up a valuable water resource. If you were to say pipe it in, it would involve additional infrastructure to divert water into those areas to sort of intentionally dilute it areas, and it would probably have quite a high carbon footprint as well and be very expensive. So I don't agree that because it's not used as a deliberate mitigation strategy, it means that dilution isn't important for localized nutrient issues, if that answers the question. They're different things. What we're talking about in this in this case is removing a natural source of dilution. It's very different to introducing it as a form of artificially as a form of mitigation. It already exists. The infrastructure is there. Nature has provided the infrastructure. it's a different, it's comparing apples with pears.
Thank you. And I mean, it may be that there is no answer to this, but if you were to pump large quantities of fresh water into an SAC, could that have adverse ecological effects, perhaps, as well as beneficial ones, if it even could?
In theory, it could, yes. I mean, anytime you make a change to a natural system or a semi-natural system, you would have to be cognizant of the potential impacts. Yeah.
Thank you. So the second point really is that I think you are attempting to take us to part of Dr. Clothier's proof where he has photographs sort of superimposed on a map. I just thought I'd give you the chance to say anything you wanted to say about that. So Dr. Clothier's proof at the, well, it's not the very back, but towards the back, it's, if you have a PDF, I think it's PDF 26, it's right after these other photographs. There's a sort of landscape. I mean, it looks like this on the paper version.
Yes.
Maybe nothing to say about this. I don't think we actually went to it. I think you were trying to go to it. We didn't go to it. So I just thought, if you wanted to say anything about it, now's your chance.
Yes. Let me zoom out to an appropriate scale. Yes, that's right. I mean, admittedly, Dr. Clothier's mapping is much more comprehensive than mine, and I mean, that was very much in response to the question as to where I took that photograph from. But yes, Dr. Clothier has numerous photographs which are quite specifically located onto a map on here, including in and around the area where I took my photograph on the same day. So, there is evidence there.
And I think this helps us to understand about the way in which the streams interact with the SPA or the Ramsar.
Well, that's right. I mean, the photograph that I put in my proof is there to show how that point of interaction, if you like. So figure 3 in my proof is the stream flowing out of Badlam Copse, as we've said, flowing across the mudflats, the designated mudflats, and entering into Badnam Creek, which itself then flows through even more designations, both national and international designations, including Linksgrove and Hackett Marsh's Triple SI, which was purported to be north of Badnam Creek. So it's quite a key spot, and in fact, I'm glad it's being visited so that the inspector can see for himself the nature of that location.
Thank you. And then just finally, right at the end there, you accepted that residual displacement effects could potentially be mitigated by the payment of a contribution to the Solent mitigation strategy. I think that's what I understood your evidence to be. Has there previously been any offer by the appellant or any suggestion of making such contribution to your knowledge?
Not that I'm aware of.
Thank you. And those are all the questions I have for Mr. Andrews.
Grateful to that, Mrs. Fulbrook. Thank you. Right, it's just gone 12 o'clock. I'm mindful to say we'll take a break for lunch rather than a break and come back. Where that's left us, I think, now is that undoubtedly we are going to be pushing highways evidence to June. I don't think there's any way we're going to deal with, bearing in mind we've got Mr. Delahaye, and it's taken us nearly perhaps just over half a day to get through Mr. Andrews' evidence. I think the rest of the day is going to be taken up wholly by Mr. Delahaye. That means we need to think about the availability of highway witnesses. We've got capacity in the programme. My current thinking is that what we would do is when we resume on the 24th of June, we will deal that day mainly with highway witnesses, with the Lisa Kirby Hawks, on behalf of the council's planning evidence that afternoon, because that's the shortest part of the planning evidence. The Wednesday morning we would deal with the planning evidence from the appellant and the Rule 6 party, leaving the afternoon of Wednesday for closings. But what all that means, what I'm really saying is, can you check the availability of respective highway witnesses to come back on Tuesday the 24th of June, because that's when we could accommodate that in the programme.
It helps your have
Brilliant.
Yes, sir, we can.
Good. So what that means is that although we're out of programme and sync with the programme, we're not out of control. And that's important. All right, that's helpful. What I will do, it's going to happen. It's going to happen. So next week I'll issue a revised programme that reflects that. So what I'm thinking now is that when we resume on the 24th of June, after all the housekeeping things that have cropped up over the last few months, we'll go into the highways evidence as we would have done today, from the Rule 6 party witness and from the appellant. Then we'll deal with the council's planning evidence that afternoon. The morning of the Wednesday will be planning evidence on behalf of the Rule 6 party, planning evidence on behalf of the appellant, and then we'll do closings in the afternoon. I will have a long lunch as I can to enable you to complete your close. I'm sure you've started most of them, but I'll give you as long a lunch as I possibly can to enable closings to be done later that afternoon. And when I say later, I'm not looking straight after lunch or early. I'm looking really to give you a couple of hours to get your closings into shape, if you're comfortable with that. Say so you'll be comfortable with that, Mr. Lewis. Right, thank you. Then it's gone 12:05. Let's have 45 minutes for lunch. Can we resume at 12:50? That gives 45 minutes. Okay, at that point then the inquiry is adjourned and we'll resume at 12:50. Thank you. 10 to 1. This afternoon we'll dedicate entirely to the evidence of Mr. De La Haye on behalf of the appellant dealing with ecology. I did say in my opening announcements that some witnesses, I will allow some questions from interested parties who's either spoken or indicated that they are going to speak. So at the end of cross-examination from Mr. Fulbrook today, because of the interest in ecology, and that flows from hydrology, that's culminated into the ecological concerns, I will permit some limited questioning from members of the audience who fulfil that criteria, have spoken or registered an interest to speak, to ask questions of Mr. De La Haye. Just a reminder that I said on Tuesday that such questions is not about restating your case, it's not making a statement, it's not repeating questions that Mr. Fulbrook may have already asked, it's anything that you think is missing, that you want to ask a question of, but just be mindful that if it strays into things that's being asked, or it strays into making a statement or restating concerns, then I will have to cut that off because I'm obliged to do that as part of the process. So just be mindful, I'll enable that facility to people should they so wish. You might not want to, but I will enable that at the end of today. Just before we start, is there anything of housekeeping that I need to be aware of? Mr. Strong?
So
Mr. Fulbrook?
just one question. I think you said that today, this afternoon would be dedicated to hearing from Mr. De La Haye, and I ask only for the benefit of Mr. Whittingham, who's behind me. I think it is unlikely that we will finish in time to
Absolutely.
hear him. Are you content for him to be released for
Yes.
the remainder of the day?
I've already emailed the case officer to say that I will try and actually get that revised programme out tonight.
Okay.
Mr. Whittingham is highly likely to be giving his evidence on Tuesday the 25th of June. Go on.
No, I wasn't going to interfere with that at all.
But just straight away, I'm going to be derailed.
No, I'm just alerting you that I think I'll be shorter in examination in chief than I timetabled, although I've already been longer in cross-examination. So,
Right.
but I'm hoping to make some time back. I'm
Yeah.
not sure that would necessarily.
It's probably not going to
Perfect.
help us, is it?
But
Because
I didn't want to be shorter and then for you to say, oh, if I'd known that, then I. So it rather depends, of course, how long Mr. Fulbrook might be as well.
it's probably highly unlikely, Mr. Fulbrook, even if we were to have a foreshortened evidence in chief, bearing in mind that we've got a lot of things to get through, I don't want to leave any highway witness hanging for 2 months in a perjury situation. That would not be appropriate. So
Yes, and I have said I think I'll be an hour and a half with cross-examination. My learned friend graciously admitted it's not always possible to stick to those time estimates. I may be less as well, but I may be more.
Yeah.
I can't do more than say I hope it will be an hour.
And I think, bearing in mind the complexity of the highways issues, even if we were to start some of that evidence, we're probably going to be here well past 6 o'clock. And that's probably not fair to any parties present.
I should say, while we're on the topic and Mr. Whittingham's present, is that he did mention to me the possibility perhaps of seeking to agree some kind of statement of common ground on highway, using
That
the
would be
time to
brilliant.
agree some kind of statement of common grounds on highways that may reduce some of the time and it may clear up a couple of matters, reduce some of the time that is needed for the evidence in June. So
That's an incredible helpful situation, Mr. Fulbrook. And both highway witnesses are here. So they can get their heads together should they so wish, and I'm sure the council can find them a space to do that. So if that dialogue could be started, that would be enormously helpful to making June proceedings very efficient.
I totally agree, sir. And although I appreciate not everything in the existing highway statement of common ground would be common ground, it could at least form the starting point for working out what's not in dispute and what is in dispute, and build from there.
Absolutely. If not, at least look at some of the modelling and
numbers.
agree some baselines. That would be really helpful. Thank you. Helpful suggestion. Anything else from a housekeeping perspective?
No, save I think Dr. Clothier has now his statistics on rainfall, and I think he's in the process of arranging for them to be printed and produced, and we'll obviously make sure we do that.
Brilliant. As long as we've got them before the end of today, that'll be fine. Mr. Lewis, anything? Just a reminder about that 106 agreement, whoever's doing it. When we've completed re-examination of Mr. Delahaye, we'll go through the arrangements for the site visit tomorrow and who was attending the site visit and some of the matters relating to that. And then we'll proceed as per programme for Friday. But I've already alerted the case officer, who's watching actually all the time anyway. So John knows exactly where we are in the programme, and he knows that we're going to be having a revised programme. So I will do that tonight, and hopefully then it'll be able to be on the council's website first thing tomorrow morning. Thank you. Right, having said all that, if there's nothing else, Mr. Strong, could you please introduce your witness to the inquiry?
Thank you very much, sir. And so you'll need for this session Mr. Delahaye's proof of evidence. There's a rebuttal. There's also a separate summary of the rebuttal. And we had a number of documents open earlier. Hopefully you might have some of those still to hand. Thank you. So you are Danny Delahaye.
Yep, I am.
You're an associate ecologist and you lead the Habitats Regulations Assessment Team at Tetra Tech Limited. You've been a professional ecologist for 15 years and you hold a Bachelor of Science degree in environmental biology.
That's correct.
And Mr. Delahaye, you prepared a proof of evidence and as part of that proof of evidence, there is a, to use the jargon, without prejudice addendum to the existing shadow HRA, which is a bit of a mouthful, but in essence, an addition to the appellant's shadow habitats regulation assessment, but put forward on a without prejudice basis. And that is attached to your proof of evidence, is that correct?
Yes.
And that sits alongside the previous shadow HRA that was formed part of the application, correct?
That's correct.
And your evidence also sits alongside the council's habitats regulation assessment, which we went to earlier. Is that
That's
correct?
correct.
Thank you. And so if you're content with this, I'm going to ask Mr. Delahaye to read what is in fact his proof, but it's a very short proof, and then ask some further questions, if I may. Not. So, Mr. Delahaye, can you start at paragraph 1.2.1 of your proof?
Yes. My proof of evidence principally addresses a statement of case for the dismissal of appeal presented by the Hamble Peninsula Defence Group, which is a Rule 6 party, and the without prejudice addendum to the Shadow Habitats Regulations Assessment as provided in Appendix A. Section 2.2 of the HPDG SOC
Statement of case. Yeah.
contends there are reasonable scientific doubts that the proposed development will have an adverse effect on the integrity of the sites by reason of the hydrological impacts of the proposed development during the operational phase of gravel extraction and in the final proposed statement, and or the displacement of informal recreation use of the site, which will arise as a direct consequence of the proposed development. This proof of evidence should be read in conjunction with others submitted by the appellant, including that dealing with the hydrological issues. There are no remaining objections from the Minerals and Waste Planning Authority to the proposed development in terms of its ecological effects or in relation to the issues relating to the Habitats Regulations assessment. Natural England withdrew its objections subject to appropriate mitigation being secured, and that is the Natural England letter dated 25th October 2024 and core document reference D6. Hampshire County Council, as a competent authority for the planning application, are satisfied that the proposed development will have no adverse effect on the integrity of sites, alone or in combination with any other plans or projects. This has correctly taken into consideration at the screening stage where material, the use of embedded mitigation inherent to the project design, so the attenuation ponds and infiltration trenches and swales. I have reviewed the information provided by CEMEX, the HPDG statement of case, and the supporting documents by Andrews Wildlife Consultants. Core document reference L13 and L14. I disagree with the contentions of the Rule 6 party statement of the case that no adverse effect to the integrity of the Solent habitat sites from the proposed development has not been demonstrated beyond reasonable scientific doubt. I refer to the Shadow HRA for the application, Chapter 7.3 of the LC Ecological Services 2023 Shadow Habitats Regulations Assessment, core document B79, which is the Shadow HRA, with regard to the displacement of illegal recreational pressure. I agree with the conclusions reached in the Shadow HRA, which I adopt, but I do not repeat again in proof of evidence. I also refer to and adopt the without prejudice addendum to the Shadow HRA assessment, which is in Appendix A. Again, I do not repeat the analysis of this proof of evidence. I do not repeat that analysis in this proof of evidence. Beg your pardon. Hydrogeology. The Shadow HRA has demonstrated that the use of the drainage measures proposed, which provide for, amongst other things, conveyance of water between attenuation features, swales and infiltration ponds, is embedded mitigation and is entirely consistent with case law to take account of such embedded mitigation in considering whether there is a likely significant effect. I agree with the Shadow HRA for the reasons that have been identified in this document. The conclusion is reinforced by the revised restoration design core document reference C1 intended to replicate the existing conditions on the appeal site. The without prejudice addendum to the Shadow HRA assessment has shown that even if the drainage measures were treated as mitigation for the Solent habitat sites, there would still be no likely significant effect on the Solent habitat sites from the proposed development. And without prejudice to that, the proposed development would not lead to any adverse effect to the integrity of the Solent habitat sites. I refer in this respect to the issues already addressed by Rachel Dewhurst in her proof of evidence on hydrogeology matters. I note the technical note, Hamble Airfield, updated design for the proposed quarry, Stantec 2024, core document, reference C2, deals with the use of SUDs and the proposal to mimic current groundwater flows. I consider that the competent authority can be satisfied as to the absence of any likely significant effect or any adverse effect on integrity in relation to water flow and salinity beyond reasonable scientific doubt. Recreation. The Shadow HRA contained an appropriate assessment in relation to the potential for the recreational pressure to occur at the Solent habitat sites in consequence of the proposed development. It stated that the proposals could potentially displace existing local residents using the site for informal recreation. Displaced recreational activity could potentially impact on birds along the River Hamble within both the Solent, the Southampton Solent Water SPA, Ramsar, and the Solent Maritime SAC. Embedded mitigation in the form of a substantial permissive footpath running along the northern and eastern boundaries of the site operational and post-restoration phases, and a community access meadow in the far northeast of the site, post-restoration only, will provide considerable areas for informal recreation throughout the lifespan of the project and in the post-restoration phase. The shadow HRA explained why there would be no adverse effect to any of the solent habitat sites from recreational pressures. I consider that the shadow HRA is correct for the reasons that were given. I also refer to and adopt the additional commentary within the without prejudice addendum to the shadow HRA, which further reinforces the shadow HRA's conclusions. I consider the effect of recreational pressure would be negated by the provision of the permitted footpath during operation and the recreation area after restoration, and no adverse effect, either alone or in combination with any other plan or project, would occur, and the conclusion is one which I have reached beyond reasonable scientific doubt. I note that in paragraphs 6.10 and 6.14 of the shadow HRA, the author used the language to express the conclusion as being one of no likelihood of an adverse effect. It is clear to me that the use of this terminology was intended to be a definitive statement of no adverse effect to the integrity of the solent habitat sites, either or alone in combination due to the implementation of mitigation identified, as this is clear from reading the conclusions. I note the criticism of this terminology by HBDG. I can confirm that I have no doubt that there would be no such adverse effect on the integrity of any of the solent habitat sites, even if the displacement of unlawful activity from the appeal site to the solent habitat site were to occur. This is entirely consistent with the finding of the original shadow HRA. It is my professional opinion that the shadow HRA and the without prejudice addendum to the shadow HRA assessment demonstrate that no adverse effect to the integrity of the solent habitat sites will occur for the reasons given in those documents. I am satisfied that it has been demonstrated beyond reasonable scientific doubt and that the proposed development will not lead to an adverse effect to the integrity of the solent habitat sites. I do not believe there is any basis for the proposed development to be refused on the ground of these contentions.
Thank you very much, Mr. DeLay. And sir, I wasn't going to take you through the shadow HRA addendum, but it's there at the appendix. I take it as read, if I may. Can I, with your permission, just ask Mr. DeLay some supplementary questions arising out of the evidence you've heard? I'll try and keep them brief. Mr. DeLay, first of all, you will have heard me go through the Natural England correspondence with Mr. Andrews and the chain of consultation responses beginning with CDG 10 through to 13, and then the other one that's separated, CD D6. Do you recall me going through those with?
I do recall you going through them, yes.
Yeah. And I asked Mr. Andrews a series of questions about them to the effect that Natural England had both been consulted, considered the applicants' various shadow HRAs and the council's HRA, and were satisfied that there weren't any adverse effects, and in case of hydrology, no likely significant effects on the protected sites. You recall that?
I do recall that, yes.
I think Mr. Andrews agreed that was indeed Natural England's position, and there was no suggestion that they hadn't had enough time from the correspondence. You recall that?
I do recall that, yes.
Are you aware of any evidence that the Natural England has in any way been hampered or subject to resource pressure or inability to consider all of that material in order to reach their judgments?
I have read similar documents that Mr. Andrews has read, and I have not been able to find any evidence in it that would suggest that they were unable to respond due to lack of time or resources.
Thank you. And Mr. DeLay, just again from your own experience, if Natural England did have any concerns about this project in terms of either hydrology or recreation or indeed anything else. What's your experience? Would they remain silent or object?
My experience is that Natural England has a statutory nature conservation body for appropriate assessment will respond if they think there is going to be a likely significant effect or an adverse effect to integrity of the site. That's my experience.
Thank you. Then can I move, Mr. Delay, to the topic of the likely significant effects or otherwise of hydrological matters on the protected sites. That's and the first step is one that I asked Mr. Andrews about and you've covered in your evidence, and that is, can you assist the inspector as to whether or not the I'm going to call it the drainage strategy, sir, but anyway, the drainage part of the proposals are or are not essential parts of the project, as opposed to mitigation that can't be taken into account for the habitats regulations assessment first stage. It's a long question, but I hope you understand the issue.
Yeah. So it is my experience that mitigation that is embedded, therefore its primary purpose is not to provide mitigation to the habitat sites, is commonly apparatus like SUDS, which primary purpose is to convey water, attenuate water, and stop flood risk. So this would be well within the realms of embedded mitigation.
Thank you. And for the inspector's note, I think you've covered that issue in your proof of evidence and also in your rebuttal. In the proof, it's in the shadow HRA, I think, isn't it? The shadow HRA addendum. And that's at section 2, page 10, is that correct? So this is your appendix to your proof within the addendum. I think your microphone's gone off. So
apologies.
Yeah,
it is within section 2. Yes.
Thank you. And Mr. Lay, you've drawn attention to the People Over Wind case, the eco-advocacy case, as providing assistance on the difference between measures that can be taken into account as opposed to mitigation which can't.
I have done, yes. These are case laws that provide instruction on how we should consider, on what we should consider to be embedded mitigation and what is not embedded mitigation.
And the passage at 2.1.5 you've drawn the inspector's attention to, I think from the eco-advocacy case. You can take into account at the screening stage features of the plan or project that may have the effect of mitigating a harmful effect on the protected site, may be taken into account where it's clear on the basis of objective considerations that those features were incorporated into design as standard features irrespective of any effect on the protected site concerned. And just pausing there, Mr. De La Haye, can you just explain your understanding of the drainage measures as to whether or not they're being required by the lead local flood authority in any event?
It is my understanding from reading the documentation provided by the hydrology experts that the primary purpose of the SUDS is not to protect the habitat site. It's there because it's required to move water, hold water, and allow it to infiltrate back into the site. It is not there to mitigate against an impact on the habitat sites, and if it does, it is an incidental. It's incidental of its primary purpose.
Thank you. And the other part of your evidence in your rebuttal proof, you revisit that, just for the inspector's note, 2.1.29 through to 2.1.32. Oh, sorry, it's carries on actually. 2.1.34, I think. Is that correct?
Yes, that's correct.
However, without, and I emphasise without prejudice, it seems important, you've gone on to consider the position in the addendum as to whether or not it would affect the conclusion on adverse effect on integrity if you were to discount it from the likely significant effects stage and then deal with it under the second stage of an appropriate assessment. Is that correct?
That's correct. That was the purpose of the without prejudice addendum.
Thank you. And you've explained in that, without us going to it, that it wouldn't alter the conclusion. Have you heard anything from Mr. Andrews or Mr. Clothier that affects that conclusion?
I've listened to the evidence and I haven't heard anything that would alter that.
Thank you. Then turning to the issue of hydrology or hydrogeology, you have based your evidence on the assessment from Dr. Rachel Dewhurst, as I understand it.
That's correct, yes.
And she gave evidence yesterday, I'm losing track of the week, to the effect that there would be no changes or no material changes in quantity or quality, or indeed no material effects on flow. And you remember the discussion about hydrographs and her evidence about that?
I do remember this conversation, and I do understand from the evidence provided by Dr. Dewhurst that there will be no material change to the flow.
And you've obviously, in light of that, considered the position in relation to the likely significant effects, and indeed, without prejudice, adverse effects on the water going into the various protected sites, and reach your conclusion. You've also considered the position, even if there were a change and some sort of effect, a change in flow of any kind, including, I think, to the maximum extent of the water, all of the water from the site. And you're satisfied that that in itself wouldn't cause any likely significant effect or adverse effect on the protected sites, as I've understood it.
That is my understanding, yes.
Thank you. Can we just a few miscellaneous matters that have emerged from Mr. Andrews' contrary contention? We know the position. I'm not going to take you through Natural England's position and the other bodies, but it appears, Mr. De La Haye, that a couple of things have arisen. First of all, Mr. Andrews expresses concern about nutrients and in particular eutrophication that can occur from nutrients going into the SPA.
Yeah.
And he is contending that if there were to be a change in flow, such that water going in to the bodies via some of the springs were contained less water at particular times, that might give rise to a adverse effect in terms of eutrophication. I'm trying to summarize his position, I hope, relatively fairly. Well, I hope I'm doing it fairly, but I hope he accepts it relatively fair. But anyway, taking on board everything he said, but
Yeah.
you recall that.
So, my understanding is that the proposed amendment will not impact on or will not change the quantity and quality of water entering the habitat sites. The issue that this will lead to a change in the dilution of the nutrients within the SPA, and whether or not this will have a effect or negative effect on the SPA is well, it's such a small amount of water entering. So even if we accept that there is a change, which we don't, if that there is a change in the nutrient loading from the development, it's unlikely to lead to a change in the nutrient loading within the river channel, within the habitat sites.
Thank you. And I think it was being suggested, I put to Mr. Andrews that his concern about concentration, do you recall that?
Yes.
It boiled down, I think, to this, that if the water in the coming off the springs were at a lower volume than it might otherwise have been, accepting it varies all the time, but if it were of a lower volume, the nutrients in the, I think it must be the SPA, would become more concentrated. It can't be in the stream itself, I don't think, because we'd be only affecting the flows rather than the concentration.
So we're talking about the impact, whether it will cause a dilution of impact on the.
I assume when it gets to the SPA.
Yeah.
Can you just, I just want to get your assistance on whether nutrients are mitigated by dilution in the way he appears to be assuming.
So I've worked on nutrient neutrality projects throughout the country, and I have not been able to use dilution as a way of reducing nutrient loading. So my experience is that it wouldn't be a suitable mitigation technique for that reason. I'm also question whether or not if there is a. I also question whether or not if the dilution effect will have a real application on the conservation objectives of the qualifying features within the SPA or the Ramsar side.
Okay. Well, on that point, we then move to the lagoon shrimp and the starlet anemone. And I think I got some answers about that, in fairness to him. But can you just help the inspector whether either of those faunae are present in any of the locations that the inspector is considering?
I'm just finding my notes, I apologise.
Sorry, take time.
So the two species in question, the lagoon sand shrimp and the starlit sea anemone have very specific habitat requirements. They live in brackish lagoons, and the location of the brackish lagoons within the habitat sites that are near to the proposed development can be located because they're described within the Ramsar citation, and there's 3 sites that they exist in because they are the correct conditions. One of them is in Key Haven, Lymington, which is in Hampshire. The other one is Gilkicker Lagoon, which is near Gosport, and Brading Marshes, which is on the Isle of Wight.
Any of those close to where our water is coming off the site?
None of them are close to the site, and nowhere. There seems to be nowhere else that they have suitable habitats for them to live in.
Thank you. And then I think the other expressed concern was about change in salinity, Mr. De La Haye.
Yeah.
And I know, of course, again, making it clear without prejudice, your position is that there isn't going to be a material effect in flows, etc. But just taking against ourselves the proposition that Mr. Andrews is putting forward, that there might be changes in the hydrographic flows, i.e. more a higher peak and then a less of a tail, so the water comes out slower or faster. Do you recall that?
Yes, I recall that, yes.
Can I just get you to help the inspector as to whether that would have any likely significant effect on any of the conservation objectives for these sites in terms of salinity or otherwise?
Yes, I've got some notes on salinity. I just need to open up the correct document, which is in my within the Shadow HRA addendum, which I've just closed by mistake. I apologise.
No, okay, I've got a hard copy. Sometimes easier. Take your time. Let us know when you're there.
Sorry.
Otherwise, I might not meet the expectation I've now set for myself and others.
So it's section 3.1.34 of the Shadow HRA addendum.
1 point.
3.1.34.
I'm not sure. I don't think I've got that.
Can you just check that? I don't think we have a 3.1.34.
in the without prejudice addendum to the existing shallow HRA.
Yeah. Mine goes up to 3 point. I got section 3.1, which is the hydrological impacts of the proposed development. And then 3.2 is likely significant effects alone. 3.3 is appropriate assessment alone.
So it's in the appropriate assessment alone section at the bottom of the page, which on my version, which I've just downloaded, is 3.1.3.4. And it's
Maybe, is this beginning the River Hamble?
yes.
Well, that's 3.3.5. I don't know, your numbering's gone astray, but maybe that's a different version. But 3.3.5.
Okay. I apologise for that. I don't know what's happened. So in this section, I talk about the salinity in the regime within the estuary, and how it changes throughout the water system, and basically the point of this section is I'm trying to say that the river, the salinity regime in there is very high, approximately 35 practical salinity units, and therefore decreasing it from a little bit of incoming water from sites is unlikely to change it significantly from that.
And just bear in mind, I think what we're dealing with here, Mr. LaHaye, is not actually a change in, well, it's accepted, I think, by Mr. Andrews. We're not changing the volume of water, fresh water coming in on an annual basis, but he's just dealing with what he says would be times at which the flows have altered.
Yeah.
So you might get more after rain and then it peters off quicker than it's currently. That's his contention. Does that affect any of your conclusions,
No.
if that were to occur?
If it was to occur, if we're being extremely precautionary on how we're assessing the information, it's my belief that there would be no significant effect.
And he says, I think, well, it's about maintaining fresh water to the mud flats, or, for example, there's a picture of some of the mud flats.
Yeah.
And that if you had those differences in flows, that could have an effect. Again, can you identify for the inspector whether you consider there would be any such effect if there were difference of flows to, for example, the mud flats, or a bird feeding on the mud flats, or whatever it may be?
So if we were considering if there was to be a significant effect to the qualifying features using the mud flats, so the overwintering birds, if we had fluctuations within the if there were to be fluctuations within the water coming into it, and it was a necessity for them to use the water as part of their structure and function, because of their highly mobile behaviour, they would be able to move to alternate areas. And so whilst there might be a reduction or fluctuation in the flow, it wouldn't be considered to be a significant impact when you look at their conservation objective as a whole.
Have you been able to identify any other effect, assuming, again, still assuming against ourselves that there are changes in flow of any kind? Have you been able to identify any other impact or effect, likely significant effect on any of the protected sites?
No, I haven't.
Okay. And then can we turn to, if you need a hard copy of your proof, we've got one available, so let me know. We'll see how we get on. Can we turn to recreational issues?
Yeah.
And first of all, I just want to really just touch on some things that have emerged from the answers from Mr. We agreed, or he agreed with me, that the SPAs in this area are different from SPAs in other areas where, in fact, the response, the mitigation strategy isn't to exclude people from the SPA, but recognise the increase and to have measures to manage those people who are going to come. Is that a fair summary of the strategy in this location?
That is a summary of the mitigation and the location, yes.
He also agreed that the policy in the strategy and indeed the local plan for non-residential development is for the local authority in consultation with Natural England to consider alternative strategies.
Yes.
And that's what had been done here. And we went through the permissive path and landscaped area during operation. We didn't go through the meadows, but then there's an additional meadow area. I put some numbers to him. I'm sure you, maybe if necessary, you can get together and agree the areas if it's controversial. But I think the landscaped area with the path is, I put to him 7.8 hectares. And I think the measurement of the additional meadow area is another 3.5 hectares. But perhaps you can confirm whether or not that's right and agree those figures with him.
That is the figures that I have. I have a figure of 7.5, 7.8 and 3.5, the two different areas.
And then just dealing with the question of assessment of that as a mitigation measure and effectiveness. The inspector has information about the size, the location, the relationship with other housing, the relationship with other walks, and you covered a lot of those in your evidence. I think it was originally being said, well, you need to do more, you need to have surveys. Can I just ask you, Mr. DeLahaye, can one make an assessment of the effectiveness of that as a mitigation strategy based on those physical characteristics that you've identified?
Sorry, I didn't quite get the start of that question.
Yes, the inspector has before him the details of the location, the size, the proximity to houses, the way it interacts with other paths in terms of the permissive path and landscaped area. And I'm just putting to you whether with that information, a competent authority can make an assessment of the effectiveness of it as a mitigation strategy.
So the competent authority, which is Hampshire County Council,
Which was.
Sorry, I apologise. Yes, which was the competent authority, have assessed the permissive path, and through their own appropriate assessment, have come to the conclusion that it is a suitable mitigation area to prevent displacement out to. They have also consulted with Natural England, who have also agreed that it is a suitable alternative mitigation strategy.
Do you need to do a survey to make that judgment?
No.
And I asked Mr. Andrews about the two surveys that do exist and the potential issues with them. First of all, can I ask you, Mr. DeLahaye, could one carry out a scientific survey of residents in this area which would be unaffected by issues of bias?
It's my opinion that you would struggle to get a answer that would not be biased by the people who are using the site at the moment.
And secondly, Mr. DeLahaye, I took him to the two questions that were put in the two surveys. One saying removal of all activity, and the other referring to a 2 to 3 metre path in between a 5 metre bund and a fence. Do you recall that?
I do recall
Are
that, yes.
either of those actually accurate portrayals of what's proposed?
Well, the initial survey, which didn't give an option of what the alternative, the use of the alternative permissive path was inaccurate, because it didn't give the people who filled it out an opportunity to use that, or put that as they would use it if it was provided. The second question, which talks about a 3 metre path, is not providing the full picture of the permissive path which will be provided once construction is undertaken. The permissive path is not 3 metres. Well, the path is 3 metres, but it's 3 metres within a wider landscape. The wider landscape will be managed. It will be landscaped, and it will provide a safe area for people to walk their dogs. So it's a different question than the one that was asked.
Thank you. And finally, Mr. Leahy, even if people are displaced from the airfield to the SPA areas, or any of the SPAs, as a result of the development going ahead, in your view, does that matter or create an adverse effect on the integrity of the protected sites, given the management strategies that are already in place?
No, because the purpose of alternative green space is not to prevent everyone, or not to mean that everyone would use it. It's simply there as an avoidance strategy. So there undoubtedly will be people who will use, and probably already are using, areas outside of the permissive path. However, in the area with the permissive path, or the area outside of the permissive path, there is a in-place mitigation strategy that deals with controlling access and managing people's behaviour, and this would provide in combination with the permissive path a suitable mitigation strategy.
I think a point you made in your proof of evidence, of course, that some of those users will be living in housing which have already paid to the fund, as it were, for any housing constructed after 2009. I think it was Mr. Holmes who talked about the mass development that's occurred in Hamble since then. That might be leave aside the adjective, but housing that's occurred since 2009 would have already paid for, as I understand it, anyone living in those houses per household into that fund. Is that correct?
That's correct. There is a requirement set out with a zone of influence, which is 5.6 kilometres from the habitat site. So any development will be required to pay into the solar mitigation fund through recreational. A development developer scheme.
Thank you very much, Mr. Leahy. I don't have any further questions. I don't know whether I've come in under or by time, but I was trying to catch up a bit.
I think you have come in time. I think you have come in time. It doesn't help us, but you have. Thank you.
It's empiric, actually.
All right. Would you like now to come into your cross-examination of Mr. De La Haye?
Yes, thank you,
Mr.
sir.
Fulbrook, thank you.
Good afternoon, Mr. De La Haye.
Hello.
I have a list of documents. I can't promise that it's a complete list, but it may help you to know that I am intending hopefully to take you to the shadow HRA, which is core document B79, the HRA, which is core document E15, the Environment Agency's response, which is core document L30, and some of the responses from Natural England. I think it's G10 and G11. Core document L59, which is some information about the recreational use of the site. Core document L34, which is the survey. I'm afraid there will be others, including your proofs, but that hopefully gets us a bit ahead.
Thank you.
So I want to start with just a few questions on the law, and appreciate that just as Mr. Andrews is not a lawyer, you're not a lawyer either, so please understand my questions in that context. But I just want to understand, obviously Mr. Andrews was taking some additional points of law on habitats regulations assessment, but I want to understand what's common ground between you, if you like. So I wonder if you could turn up Mr. Andrews' proof of evidence. And turn to paragraph 8 of that.
Sorry, I'm still getting there.
That's okay.
Sorry, his proof of evidence, was it?
Yes, his proof of evidence, paragraph 8.
Sorry, I opened up the summary.
That's okay.
Apologies.
Sorry, did you say you only have a summary, or you?
I know, I've opened up the summary.
Oh, right, that's fine.
Sorry,
That's fine,
I'll be
that's fine.
2 seconds, Emma.
I think it might be helpful if we
Yeah.
could perhaps have hard copies of the proof, well, probably actually the rebuttal and everything else, actually. As many hard copies as you can in relation to proofs of evidence. Just for the avoidance of any doubt, I think, to aid us. Okay, I'll just give Mr. Delay just a moment, Mrs. Waldron, just to
No,
just
of course.
to show
Yeah, that's absolutely
what
fine.
he's just been given in terms of hard copies, and then at least he knows to go to those rather than go back to the screen. I wouldn't shut your screen, Mr. Delay,
Won't open now, will it?
but
Yeah.
okay, thank you for that.
Hello, sorry.
No, that's fine. So paragraph 8 of Mr. Andrews' proof of evidence, and there he lists some legal principles. And I just want to take you through those briefly. I mean, I hope they're not controversial. And if you don't know the answer, because you're not a lawyer, that's fine. We can make submissions on that in due course, can't we? First, I think it's obvious, and we're here partly because a competent authority can't grant planning permission for any development which has been assessed as being likely to have an adverse effect on the integrity of a European site. And you understand that that's correct as a proposition of law?
I understand it's a position of law.
Yes, thank you.
But
Sorry?
But we have, the competent authority have found that there is no likelihood.
Well, they haven't, because the inspector's yet to make his decision about that. But there's a caveat to that, of course, which is that you can grant permission in those circumstances if there are imperative reasons of overarching public interest. And I just want to be clear, for the avoidance of any doubt, that it's not being suggested by the appellant that there are imperative reasons of overriding public interest that would justify granting permission if the inspector were to find that there was an adverse effect on the integrity of the protected sites.
No, we haven't looked at the overriding reason of public interest, because we have found there's no adverse effect to integrity of site.
Okay, thank you. Now, with proposition B is where there is a likely significant effect, you need to carry out an appropriate assessment. And if you look at C, that tells you what an appropriate assessment has got to do. So a few statements here, but it's got to ascertain that there will be no adverse effects on the integrity of European sites beyond all reasonable scientific doubt. So that's your understanding of the threshold that has to be passed in order for an appropriate assessment to be accepted. Beyond reasonable scientific doubt.
I understand that it's beyond reasonable scientific doubt, yes.
And where you're doing that assessment, that has to be based on the best scientific evidence in the field, correct?
Correct, yes.
Yeah. And that assessment, it cannot have gaps or lacuna
Yes.
in it. And it's got to contain complete, precise and definitive findings capable of removing reasonable scientific doubt.
That's
Yes?
correct, yes.
Yeah, excellent. All right, so we're on the same page in relation to what the inspector has to be satisfied of in order to grant permission and allow this appeal in this case. Now, as to the relevance of Natural England's views on this, there was a lot of discussion between Mr. Andrews and my learned friend about the relevance of Natural England and the proposition of law that the inspector needs to give significant weight to Natural England's view and must have cogent and compelling reasons for departing from that. I don't think it's quite simple as that, but that'd be a matter for submissions in due course. So let's just take that proposition. Obviously, the inspector needs to consider Natural England's views in this case. I mean, nobody here is disputing that. But when considering and weighing up Natural England's views, the inspector's got to ask himself some questions about it. So I just want to put those to you. So the first of all, the inspector's got to think, well, what information did Natural England have in front of it? That's going to be relevant to, how far the inspector's going to be willing to agree with Natural England, isn't it?
That's correct, yeah.
Yeah. And also it's going to be relevant for the inspector. He's got to look at what level of reasoning Natural England has provided for its conclusion. How has it explained its position? If it's just made an assertion without any explanation, that's not particularly helpful to the inspector, and he can't perhaps give it as much weight, can he?
If Natural England give their advice, that is then acting as a expert opinion, is it not?
Well, I understand that, but if Natural England just say simply, no likely significant effects on the, no adverse effects on integrity, they just say that as a result of hydrological change, for example. Say they just said that, and they don't explain why they said that, then the inspector can't really understand why Natural England have reached their view, can he?
Well, the view of Natural England will be driven by the information they have been provided.
Yes, but understanding why they've reached that view, you're going to have to look at what Natural England have said, and that's all going to be relevant to the weight that the inspector gives to Natural England's position in this case, isn't it?
Well,
I'm not sure it's law in that sense. I'm prepared to allow that because I think it's really asking the witness understanding as to what other things matters that Natural England take into account. And I understand the question in terms of when they provide a response, how much can one read into that as to what they have taken into account? I think the witness has got enough professional judgment on that to give a response, but I don't think at that point we're straying into law. I'm sure you will pull us up in if you are straying into that, but at this point I don't think we are.
I'm happy for any questions to be asked. The point about the law is when you get into the question of reasons, there's a whole body of case law about. Excuse me. Sorry, not. Yeah, I got stuck. All I was flagging up, so there's a whole body of case law about reasons. So, for example, as committee reports, committee decisions made where they grant planning permission, their reasons are taken to be the material that's put in front of them. And Natural England have the shadow HRA, the HRA, and all the information referred to. They don't need to set out again their reasoning in the precisely the same way as a committee doesn't when. So that's what, and there's law about that. So I didn't want this to proceed on a.
And I don't think we are, and I think probably Mr. Hayward have said that, but you've said it on his behalf. So I'm prepared for that question to be asked again. But I appreciate the caveat that you put in there, Mr. Strong. Yeah,
sorry, I didn't mean to. I won't interrupt you. Whether he would have said that, I don't know, because I think the law on that is actually it's embedded in various case law. I doubt he's aware of, but I'll leave that.
He's a professional witness. Has been here many times, I think. So I think he's big enough and capable enough to answer that question, I think. But I understand the reason why you asked the question. I understand your caveats, but I don't think it's an unreasonable question for just to give a professional view as to how England works from somebody who provides information regularly and responds to that information to and from Natural England.
So my question is, the inspector's obviously faced with what Natural England have said. The amount of detail that Natural England has given him and the reasoning it's given to support its position is going to be relevant to his understanding and the weight he can give to what Natural England has said, isn't it?
Sorry, can you say that again?
Yeah. So the inspector has information from Natural England, has advice, if you like, from Natural England, and he's got to weigh that in the balance in terms of whether he's going to follow Natural England or whether he's going to disagree with them.
Yeah.
That's so far so clear, I think.
Yeah.
In deciding, how much weight he's going to give that advice in the balance, if you like, he'll want to understand why Natural England have reached the view that it has. Does that make sense?
Yes.
And so the more information he has about that, perhaps the more weight he can give it. Does that make sense?
It does.
Thank you. And the less information, the less weight. Does that make sense?
But I think in this case, the previous competent authority before it had adequate information to make a decision.
No, I'm just asking about Natural England. That's all I'm asking about.
And then Natural England will judge their decision on the same information because they are able to look at the same amount of information.
I don't think this is perhaps going. Thank you for your answer. I mean, I think we've accepted that the level of reasoning is relevant to the weight, and I think that's where I want to go. And I'll leave it there. Thank you. Unless there's anything more you want to say, I don't want to cut you off. But at the end of the day, of course, well, first of all, it's undoubtedly the case that this inspector, having heard live, he's read all the information that Natural England have, and he's heard or hearing live evidence about the issue. He is better informed about the evidence than Natural England was. That's fair, isn't it?
Sorry, can you say that again?
Again, yeah. This inspector, not only does he have all of the information that Natural England had,
Yes.
he's also hearing live evidence about these issues, and it's being tested and questioned. So he has more information, than Natural England had when they gave their advice.
That would seem to be the case.
Thank you. And of course, the inspector is perfectly entitled to disagree with Natural England if he thinks that they're wrong in this case, isn't he?
If he has reason to, yes.
Okay. Just a couple more bits of context. I think we're already in Mr. Andrews's proof. Paragraph 13 of his proof, he quotes from the Habitats Regulation Assessment Handbook. You got that in front of you. The quotation, not the handbook.
Yeah.
And he says, in relation to potential small-scale effects, the Habitats Regulation Assessment Handbook, which is recognised as best practice guidance on HRA, states that quite apart from the need to take account of possible in-combination effects, small-scale effects should not automatically be assumed to be insignificant. Such an approach might lead to a failure to adequately take into account the characteristics and specific environmental conditions of the European site. So to take from that clearly, according to the guidance, small-scale or maybe localised effects on sites should not automatically be assumed to be insignificant. Would you agree with that?
That is what the guidance says, yes.
Do you agree with that?
I would have to consider it on a case-by-case scenario.
So I think you are agreeing then. You don't automatically dismiss something because it's small or localized.
I wouldn't automatically dismiss it.
Thank you. All right, and then just about the relevance of the Dutch nitrogen case and what you do where a habitat or a site is in unfavourable condition. So in your rebuttal, you refer to it, and I wonder if you could turn that up for me. It's at paragraph 2.1.20 of your rebuttal. And in that paragraph, you quote from the judgment in the Dutch nitrogen case, which says this: in circumstances such as those at issue in the main proceedings, where the conservation status of a natural habitat is unfavourable, the possibility of authorising activities which may subsequently affect the ecological situation of the sites concerned seems necessarily limited. And so, I suppose, the point is that where you have a site, such as some of the protected sites here, which are in unfavourable condition for nitrogen, for example, if you are doing something that makes that even slightly worse, there's a very limited prospect that that's going to be acceptable. That's what you take from that case, isn't it?
Yeah, that's correct.
Okay, thank you. And now I just want to ask some questions about the shadow HRA addendum and how that came to be produced, if I may. So, that has been produced, designed. So, that has been introduced, as I understand it, without prejudice. So, I take it, I think, from that it's your case that it wasn't required, didn't need to produce it. Is that right?
That's correct, yes.
Right. But we've just discussed that the standard for appropriate assessment is whether there is reasonable scientific doubt, and the standard for screening is even lower. It's, is there a possibility of effect, or should we even bother to check? So I guess if you look at it this way, if you had any doubt about whether the existing shadow HRA and HRA were sufficient, if you had no doubt...
That's not the purpose of a without prejudice addendum, though. The purpose of the without prejudice addendum is to examine the 4 points that were provided within it. So it's simply to provide more information. It is without prejudice.
But somebody somewhere obviously thought it's worth doing this. It's worth spending the money to do this. And if they thought that, then presumably they had some doubt about the adequacy of the information that had already been provided.
As far as I'm aware, there's no requirement for us not to provide information if we think it would help the inspector make a conclusion.
No, I know, I'm just trying to understand. You say on the one hand we have no doubt, and everything we had prior to this addendum was fine enough to satisfy there was no doubt. But on the other hand, you say, well, we are going to provide some more information, and I just want to understand, if you had no doubt, why do you need to provide the additional information?
Because the additional information was provided to provide answers that we thought would be helpful.
Right, so there were, if you like, unanswered questions.
No, that's not what I said. I said we thought it would be helpful to provide the answers. We didn't think they were unanswered.
Okay. Moving on, just to some questions about the distance of these protected sites from the site we're concerned with. It wasn't put by my learned friend to Mr. Andrews, but there's some slight dispute between you and Mr. Andrews about how far away, what the nearest point, the nearest distance between the site and those protected sites is, and that's all dealt with in Mr. Andrews' rebuttal. Do you disagree with the measurements he's provided in his rebuttal?
The measurements that he used using magic show that the site, the habitat sites are nearer than the shadow HRA showed. However, this will not have an impact on the assessment.
So to be clear, except you say it won't have an impact on the assessment, but you do accept that the distances he's provided are correct and the distances that were provided in the shadow HRA, for example, were incorrect.
Using the mapping methods that he used, it showed that it was a different distance than the shadow HRA, yes.
Yeah, but that's not answering my question. I mean, are you saying he used the wrong mapping methods? No, so he's right. He's right about that.
Yep.
Thank you. So your view is it doesn't make any difference, but the inspector can record that the documents that you provided did, in fact, overstate the distance between the site and the neighbouring protected sites.
Yes.
Yeah. Okay, want to move on to hydrology, now hydrogeology, and I think it's really important to understand where we are now with the hydrological evidence. And yesterday afternoon, I asked Dr. Dewhurst a number of questions about the flow, the rates of flow, how this development will affect the rates and nature of flow into the springs, which then feed into the protected sites. And it suggested by Dr. Clothier that the result of this development will create more peaks and troughs in the flow, if you like. Rainfall, quick discharge, then nothing, compared with the baseline state, which is that the aquifer discharges more slowly over a longer period of time, sustaining a more continuous flow in the aquifer. That's the sort of gist of Dr. Clothier's evidence on that point. Do you recall that?
Yes.
Yeah. Now, Dr. Dewhurst's evidence to me was that she had no way of knowing how different the hydrograph, which I'm using as a term to describe that effect, no way of knowing how different that would look following the development. I should ask, were you present during Dr. Dewhurst's evidence yesterday or not?
Yes.
Yeah. So that's what she said to me. Do you recall that?
I do.
No way of knowing. And then she said to me that, therefore, she did not specifically know how the hydrograph would be affected by the development. Do you recall her saying that?
Can you say that again, please?
She then said that she did not know specifically, because she had no way of knowing how different the hydrograph would look, no way of knowing, she then said that she didn't know specifically how different it would look.
I think that's what she said, yes.
Yeah. And then, I mean, in fairness, she was re-examined and added the caveat at that point that she didn't think that she didn't believe, and I took a careful note of what she said, she didn't believe that the effect would be material. Do you recall that?
Yes.
Thank you. Now, forgive me for being pedantic, but it is important in contexts where you have to be sure about something beyond reasonable scientific doubt. Someone merely stating that they believe something won't be material, when they've already accepted they've got no way of knowing what the change will be, it is not sufficient to get rid of any reasonable doubt about the magnitude of those effects, is it?
So if we consider the evidence that's been put forward by the hydrology team at Stantec, I think that Miss Dewhurst said she didn't believe was not really what the evidence is saying. So the evidence is saying that the hydrological regime is closely mimicked or mimics the existing hydrological regime. And therefore, in doing so, the issue that there is a a different response, so changes the hydrograph, is not going to cause a material or significant effects.
I just want to understand the division of labour between you and Dr. Dewhurst. Because Dr. Dewhurst was one here yesterday giving evidence about the hydrological effects of the development, and we heard that and we went through that just now. Are you trying to say she's wrong, she should have stuck to what was in the written evidence?
I'm not saying she was wrong, I'm just saying what I understand.
Okay, fine, but she's the expert on the hydrology, the inspectors.
But you asked me what she was thinking, I told you what I was thinking.
Fine. Yeah. And the inspector decided what weight to give to your views on hydrology compared with Dr. Dewhurst, can't he?
That's his job, yes.
Yeah, okay. Bear with me 1 moment, just want to make sure I've got a record of everything that's been said. I mean, just to push this a bit further, obviously, the inspector's got to base his appropriate assessment on the best scientific evidence in the field, hasn't he? He's got surely the best scientific evidence is the evidence that Dr. Dewhurst accepted, that there is no, there's no way of knowing how this development will affect the hydrograph.
I'm not a hydrogeologist. I don't know. I don't know whether I should be answering that at that stage. That feels like we're going back over what you spoke with Dr. Dewhurst yesterday.
I appreciate that. But I suppose the difficulty is that you're basing your ecological evidence on Dr. Dewhurst's position. So I just want to highlight what Dr. Dewhurst's position is, and then take that forward into how that applies to your evidence on the ecology. But I appreciate it's not necessarily helpful to continue to ask you what Dr. Dewhurst said, but the inspector's got note of that and be a matter for submissions in due course. But in addition to this question about effects on the hydrograph, if you like, the rates of flow, things, and Dr. Clothier's evidence, which Dr. Dewhurst did not agree with, but was that there may be changes to the direction in which some of the groundwater will flow. So where it might have flown into Spring 1, it might be moved to Spring 2 as a result of the development. As I said, she didn't agree with that, but that's his position. As you understand, do you understand that?
I understand that's what they said, yes.
Thank you. Okay, fine. Now, talking about the springs, and obviously we spent a lot of time looking at them yesterday, and there's no dispute that there are a number of springs that are fed in the site and flow directly into the protected sites, both to the east and one spring to the west. Have you conducted any survey of those springs yourself?
Have I, as an ecologist?
Yes.
For what would I be conducting the surveys on?
To look at where they emerge into the protected sites, and to look at what habitats and species are in that location that may be affected by the flow into those springs. Have you done that exercise?
No, and I wouldn't undertake an exercise on it because the outcome of the hydrogeology information is that there will be no change of quality or quantity of water, and therefore there will be no reason for me to undertake further assessment.
We need to be careful, I think, with terms here, don't we? Because there's a difference between quantity and quality. and, for example, rates of flow. So, for example, where you have a slow rate of flow which sustains a more continuous stream over a period of weeks or months, that's not a question of quantity or quality. That's something different, and that's where there's a particular dispute. So I
Can I
understand.
revise my answer then? We don't. There is no change to the quantity and quality, and no change to the rates of flow that would be significant.
Okay. All right. That's your view, and not helpful to go over what Dr. Dewhurst's view is on that, is it? But I think that's slightly different. Well, I'll make submissions on that evidence. It's not helpful for us to go over it again, but she said she had no way of knowing what the effect would be.
Your microphones. Just put your microphone back on, please.
She said she didn't know what the difference would be between the two hydrographs, and then asked about whether that difference would be material. She said no material difference or no material effect, which is what Mr. Fulbrook put a moment ago to Mr. LaHaye, but not the second time around.
She said that she didn't believe that there would be a material effect, and obviously we've been through this, so I'm not going to go over it again.
I've recorded what she said,
Exactly.
and you've recorded what you said.
Exactly.
Yeah, so
Exactly.
there's a record there
Yeah.
of what you said.
Yeah. So I suppose the key thing is you didn't do the survey because it was your view that there would be no material effect on the quantity, quality, or the rates of flow. That's why you didn't do a survey. That's correct.
That's correct.
Thank
yeah.
you. Right. Fine. So I suppose what we have to do now is proceed on the basis that that view is wrong, and that there is, or there, you cannot rule out beyond reasonable scientific doubt the possibility of an effect on, for example, the rates of flow. So we'll proceed on that assumption. Appreciate you don't accept that assumption, but if we could proceed on that basis, then I can ask you some more questions if that's okay.
Yes.
Thank you. All right, so turning to the sites themselves, the relevant sites, I think it's helpful to go to your proof. And page 17. Actually, before I do that, sorry. The current hydrograph, so the rates of flow into the freshwater springs into the European sites, that would be, I suppose it'd be fair to describe that as the current natural state of the land, because the field is broadly undeveloped, and that flow is what you might say is the natural flow. It's not been altered by man, for example.
Okay.
Do you agree with that? Is that fair?
I think that would be a fair assessment.
Thank you. All right, so now if we just turn to page 17 of your proof, and just I want to focus in particular on the conservation objectives for the SPAs and the Ramsar sites. Page 17, obviously you've put the high level objectives, then what you call the site specific objectives in there. And I want to go through those, if I may, with you.
Yep.
And obviously on the assumption that there is, or you can't rule out an effect on the hydrograph, which I appreciate you don't accept. So turning to water quality nutrients for habitat sites, you see that? And the objective is to restore water quality to mean winter dissolved inorganic nitrogen levels at which biological indicators of eutrophication do not affect the integrity of the site and features. So the first point to make is an acknowledgement that these sites are in an unfavourable condition as far as nutrients are concerned. That's right, isn't it?
There are some triple SI units, isn't it, which are in an unfavourable condition, yes.
Yeah. And so the principles that we discussed in relation to Dutch nitrogen, where very unlikely that you'll be permitted to do something that's going to make that worse or impede the recovery, would apply to this.
It would be very unlikely that we'd do something that would make it worse. And underneath Regulation 63, we're not required to restore it. We're just required to make sure that we don't provide an adverse effect,
or impede its restoration as well, I think.
Well, if we're not causing adverse effect, we are by definition not impeding it, are we?
Well, that may or may not be the case. Anyway, I don't think it's helpful to go into that in much more detail here. But the point is that I suppose this question of diluting nutrient concentration, I mean, I just want to understand your position on this further. You have water coming through the springs from the site, and I think it's accepted that that's fresh water which doesn't have a high nutrient load, and that's going into, let's just take the Hamble for example. That is flowing into the Hamble, which has a higher nutrient load. Now, there is going to be some degree of dilution. Nutrient load is the wrong word, I think, of concentration, nutrient concentration. There's going to be some dilution of nutrient concentration as a result of that freshwater input, isn't there?
If there is, because of the high nutrient loading within the river, it would be very difficult to understand what that would be. So it would be insignificant.
So you say if there is, but I mean, I think it must be the case if you're putting water with a lower nutrient concentration into water with a high nutrient. You might say it's de minimis, it's nothing. We'll get to that, okay? But there must be some kind of diluting effect going on.
Okay, if I accept that, yes.
Well, do you accept that? Because I just think that seems obvious to me. There must be some kind of effect. We'll come to the extent of it, but there must be some kind of effect. It must be some kind of effect.
Then there will be some kind of effect, yes, but I don't think it will be a significant effect.
And my understanding for your conclusion it's not a significant effect is that if you're comparing the proportion of fresh water that's inputted via these spring-fed streams with the overall quantity of water in the Hamble, and that's what you're using to work out whether that there's no significant effect. Is that my understanding? Have I understood that correctly?
Sorry, I didn't hear you for a second.
That's fine. That's fine. I understand your reasoning for that to be that you've compared what is said to be the very small contribution that these springs make to the overall quantity of water in the protected sites. And on that basis, it's not a significant diluting effect. That's how I understand you've come to your conclusion.
Well, I've considered whether or not there is going to be an actual effect to the conservation objectives of the qualifying features within the.
Yeah, but I'm asking, have you reached that conclusion? And I think you've reached that conclusion. You say basically that
I haven't, because we are working on the evidence that we've been brought to this hearing, which said there is no likely significant effect.
Yes, but if you've conducted this without prejudice exercise, and you'll say your evidence in chief was that even if there is some kind of significant change to the hydrograph, to use the short term, it's not going to be a significant effect. And it's that conclusion I'm just asking, I'm just testing, if you like. The basis for that conclusion is because the contribution that these springs make to the overall body of water in the protected sites in relative terms is very small. Is that why you say that?
Sorry, occasionally you put your hand in front of your mouth, and I'm a little bit hard on hearing.
That's absolutely fine. Let me move this closer to my mouth and be less wavy with my hands, though, if I can. And I'll ask again. It's absolutely fine. So your evidence in chief was that even if there is a significant effect to the hydrograph, to use a shorthand, the rates of flow in the streams, there's still no significant effect to the integrity of the European sites. That was your evidence in chief, wasn't it?
No, I'm not sure it was. I didn't. We didn't say the two significant effects in there are not correct from what I understand.
Material then.
Well, we don't think there's significant effects. Yeah.
I understand that.
Yeah.
I understand that. But you also said that even if there was, so let's. I'm separating the two things
Yeah.
here. So a material. Let's say if you are wrong and there is a material effect on the hydrograph, right, the rates of flow.
Right.
Yeah. If you're wrong, I understood your evidence to be in that case. There's still no adverse effect on site integrity. That was your evidence.
There's no significant effect. Yes.
No, the test is whether there's an adverse effect. Yes.
Yeah.
Right. And the reason, I understand that, but the ultimate stage is whether there's an adverse effect.
Sorry, there's evidence that's been given as to whether or not there's a material effect to the hydrograph. Even if there's a material effect to the hydrograph, there's evidence that that still doesn't give rise to a likely significant effect at the screening stage. So you still wouldn't move to an appropriate assessment. And then there's evidence that even if you treated this as a likely significant effect, there is no adverse effect on integrity. So they're two different stages, and I'm not sure which one you're asking about.
Well, we can come to the relevance of mitigation, but I think to save time, the ultimate question for the inspector is whether there's an adverse effect on site integrity, because
A significant effect at all. You only ask that question if there's actually a likely significant effect, and that's the structure of the regulations.
yes, I do understand that that's the structure of the regulations, but I think we're well, I'll take it in stages then if necessary. So
I think the only way you can do it is take it in stages to come to that conclusion on the basis of the stages that's in the legislation and just outlined by Mr. Straw, because I think that then there can be no suggestion that we kind of strain into stage 2A when there isn't a stage 2A. So you can only do that, I think, by taking it through stages.
well, that's helpful. I accept that. Thank you. So let's take stage 1 then. Assuming there's a material effect on the hydrograph, you say there's no likely significant effect, no possibility of effect on the site integrity. And as I understand your reason for that, or I understand your reason for that, is that the proportion or the proportion of fresh water that is contributed by these springs to the overall body of water in the protected sites is so low. Is that correct?
Well, no, because we're saying the effect that it causes. If we assume there is an effect, yeah. So the hydrological regime is set up to mimic the current situation. So if it is a slight change in the hydrograph, it's still mimicking the situation, and therefore we're not going to have a likely significant effect.
I think that's just a bit circular, isn't it? I'm asking you to assume there is a material change in the hydrograph because the setup doesn't mimic that. Okay.
Hmm.
If there is, what is the basis on which you then discount likely significant effect on the protected sites? And my understanding is it's because you say even if there's a material change, a seasonal variation in flow, the contribution of fresh water that these springs make to the overall protected sites is so low. If I've misunderstood that, then that's fine. But that's how I understand your evidence.
Can you? I'm sorry. I'm struggling with the fact we're doing this as if we're saying there's an effect. So.
All right. Well, we do have to go through this exercise to some extent, don't we?
Yeah.
Because
I'm apologising for being for
I've no
brain.
doubt it's my questioning that's the problem, and not you. And so I'll try to make it clearer. we are looking at the question of dilution of nutrient concentration. That's where we started a long time ago. Again, my fault. Assuming that these, you said that could be some kind of effect, but you say it is a de minimis effect. Basically, it's negligible. The contribution that these springs make, if you like. So I suppose I can put it perhaps more helpfully this way. I think it's my understanding that if the flow from these springs were to stop temporarily or flow less regularly, for whatever reason, you would be saying that there's no likelihood that that could have a significant effect in terms of nutrient concentration on the protected site. Is that right?
The nutrient concentration within the site is going to be constantly replaced because it's a river system. So if it stops, it's going to be continuously diluted by other incoming water.
Yes, I think we're getting there, and that you're relying on the site as a whole.
Yes.
And the level of water coming into that.
Yes.
To basically reach the view. It doesn't really matter what's happening in these particular streams. Is that what you're doing?
Yes.
Right. Thank you. That's helpful. I'm sorry. That's my fault. It took a while to get to that point, but that ignores, doesn't it? That site-wide approach ignores the possibility of localized effect, which you have said can be a source of significant effect.
But it does and it doesn't, because the effect of it being within an estuary environment or a river environment is it's constantly replaced.
But in the area around where these springs are coming out, in the area where they're coming out, you've accepted there'll be some kind of effect. There's fresh water, if you like, with lower or no nutrient concentration entering into an area of water with a higher nutrient concentration. And around that intersection, there will be a degree of dilution of nutrients, a localized dilution of nutrients around that section. Does that make sense?
Yes.
So there could be, if that spring flow stopped, a localized worsening of nitrogen concentration, because the dilution effect, that localized dilution effect, would stop. Yes?
Yes, but it's also tidal as well, isn't it? So it's going to be constantly replaced.
It is tidal, but the flow into the river is not tidal, and so there will always be a section where you have fresh water flowing in, won't there? Yeah. And to be clear, you have not done any surveying of those sites where that localized effect might happen. So you don't know what effect those springs are having.
We would have no reason to undertake it because we are certain there is no likely significant effect. We're not required to undertake the survey if we think it's not going to provide any additional information.
Okay. And a consequence of that is that we don't have any information about what's going on and what habitats are potentially reliant on that localized effect on nutrient concentration, do we?
Because we don't think we have to, because there would be no reason for us to give more information than we're required to.
Okay. All right, so that's the first one. The rest will be much shorter, I'm sure. Looking at page 17, the site objective to maintain the natural freshwater flow and volume into the estuary. Now, you accepted that the current state of affairs, if you like, can be described as the natural state. So if you have development that changes that flow of fresh water, in some way. So it might change. We're not saying necessarily it changes the overall quantity or the overall quality, but it might change the rate or the seasonality of that flow. And that would not maintain the natural freshwater flow into the estuary, would it?
So we are saying there is no change to the quantity, and the change to the flow would be immaterial and therefore insignificant, and therefore that would maintain the natural freshwater flow from the small stream into the habitat sites.
Okay, but if there was a change to the rates of flow in the stream, that would not maintain the natural freshwater flow, would it?
But it's the likelihood that there is a constant flow the whole time is slim.
Okay, but, well, you say that, obviously, but don't know that. The point is, if you're changing it, you're not maintaining the natural flow. If you're changing, except you don't accept, you say there's no change, but if you change it, just let me finish. But if you change it, you are not maintaining the natural freshwater flow, are you?
The conservation objectives are all to do if we cause a significant effect to the qualifying features. So if we're not causing it, we're not impacting on the conservation objectives, aren't we?
But you've said your evidence is the way you work out if you're having an effect on the conservation features. If you look, is if you look at the conservation features objectives, and you look at the natural guidance, the site-specific guidance, which tells you how you go out meeting those objectives. That's how you reach that view, and that's what I'm taking you through. So we're looking at the site-level objectives, and I suppose you should be asking yourself, am I meeting these objectives or not? And the question to you is, if you are reducing or changing the flow from these springs into the protected sites, you are not maintaining the natural flow, are you?
But we are. We are not changing the flow into a significant amount. Therefore, we're not affecting the conservation objectives.
I understand that, and we just have to entertain a slight counterfactual world here. If you were to change the flow, all right, if you say you're not, but if you were, you would not be maintaining the natural freshwater flow into the estuary, would you?
Only if the flow was changing in such a way that it would cause a likely significant effect.
But the way you work out there's a likely significant effect is you've got to look at the objectives first, haven't you? So you look at what's the effect of this on the objectives, and then I think, having looked at that, is there a likely significant effect? So you're getting ahead of yourself, aren't you? The question is, what's the effect? You're not meeting, if you're changing the flow, you're not meeting this site-specific objective because you're not maintaining the natural flow. That's if you're changing the flow.
I don't know, but we're saying, so the evidence that we're providing is saying we're not changing the flow.
All right. I'm not getting very far with this. I'm going to move on. All right, and then so same point really about natural physiochemical properties in the water. The physiochemical properties of the water will depend to some extent on what's flowing into it, won't they?
Yes.
Yes. So, again, these springs, they're flowing into the water. If you change the nature or rate of the flow into these springs, you are locally, perhaps, but you are affecting the physiochemical properties of the water.
So, if we are assuming that we are changing the natural physical chemical properties of the water, which we are saying we are not changing the quality or the quantity of the water, and it led to likely significant effect, or we thought it's going to lead to likely significant effect, then we would not be maintaining the natural physiochemical properties of the water, assuming that we were.
Okay, I mean, I just want to pick up the question of likely significant effects in case it comes back, if you like, to bite me. Clearly these objectives are relevant to determining whether you have a likely significant effect, aren't they?
If we're changing the properties of the water.
Yeah. Okay, thank you. So you make an assessment of significance, and obviously to make an assessment of significance, you do have to have evidence, don't you, about what habitats might be affected and what the extent of that effect might be.
Well, if you know you're not causing a likely significant effect from the proposed development and the water that flows from the proposed development into site, then you know you're not going to cause an effect.
Yeah, but just step back with me a minute. To make the judgment about likely significant effect, okay, let's leave this development behind, just to make a judgment about whether there's a likely significant effect. You need to understand what habitats could be affected by the change, whatever it is. Does that make sense?
Yes.
And you need to understand what the magnitude of the change might be. Yes?
Yes.
Yes. Okay, thank you. All right. Maintaining the availability of fresh water on mudflats within feeding and resting areas. Now, we've seen pictures in Mr. Andrews' proof, for example, that demonstrate that these springs flow into the Hamble, flow into Badnham Creek, and they flow across into tidal mudflats.
Yep.
That's right, isn't it?
Yep.
So these springs do provide fresh water on mudflats in feeding and resting areas, don't they?
In theory, yes.
If these springs are affected so they don't flow for as long, for example, so they stop flowing more quickly, then that availability, the availability of fresh water, will be reduced. So let's say hypothetically, in the current state, the springs flow for 6 months of the year. I don't know whether that's right or not. I'm not asking you to reach on that. But as a result of this development, they only flow on average for a few weeks a year.
Mm-hmm.
That would affect the availability of fresh water on mudflats within feeding and resting areas, wouldn't it?
Well, if we're talking about the qualifying features that would be impacted being highly mobile waterfowl, then a shortage in water one area unlikely to cause a likely significant effect against the conservation objectives because they would be able to move to another area if there was an effect. So they would move around anyway.
I suppose to understand that to have no reasonable scientific doubt about that, I mean, I think probably as a proposition, I think Mr. Andrews accepted that as a proposition, pretty right, but you need to understand, in terms of understanding the effects, the availability of other similar areas for drinking, for example, wouldn't you?
You could make a judgment on the by looking at available data.
Okay, but you haven't looked at that data.
No, because there is going to be no likely significant effect. Therefore, no necessary reason to undertake further surveys.
Okay. And just in relation to salinity, similar point really is that the fresh water going into the protected sites will have an effect on the salinity levels locally where it enters the, say for example, the Hamble or something, Southampton water, won't it?
It will have an effect on the salinity.
Yeah, locally.
Well, it will change it. Whether or not that will be an effect is.
Surely a change is an effect.
But it's,
Do you understand?
so you would have to look to see if there was species in there which conservation objectives were a whole. But as we are considering there's going to be no change.
Yeah. Yeah. Okay. Well, that's fine. So, if you thought there was going to be a change, you'd want to look at what species might be affected, but you haven't looked because you don't think there's going to be a change. Is my understanding.
It's not that I don't think it is. It's that the information that's been provided draws that conclusion.
Okay. Thank you. Right. I might be able to cut some of this down, so bear with me 1 minute to make sure I don't ask you unnecessary questions. I just want to ask about the reliance on the Environment Agency in the HRA, if I may. So that's core document E15. Sorry, actually, before I do that, I'm sorry. I just want to ask you about in combination effect. So you might conclude that there's no likely significant effect, but that's not necessarily the same as concluding there's no effect. Or you might conclude there's no adverse effect. That's not the same as concluding there's no effect. And any residual effect, you obviously still have to look at in combination with other plans and projects. That's right, isn't it?
If you think there's no effect at the screening stage, there is no requirement to undertake an in-combination assessment.
Yeah. Okay, but if you think that there's any kind of residual effect, or if there could be a residual effect following appropriate assessment, for example, you would need to consider that in combination with other plans and projects, wouldn't you?
The way of approaching it would be if there is an effect that is not large enough on its own to cause an effect, but it's de minimis, you would have to undertake a screening in combination assessment at screening. How that's not what we've concluded.
Yes, you've concluded there's no effect at all, so you've not gone on to do that next step. That's right, isn't it? But if there were to be some doubt about whether you were right, even if the inspector thought, well, I'm not sure if it goes all the way on its own to make a significant effect or an adverse effect, he'd need to know what could it interact with other plans and projects and other effects to make an in combination effect, wouldn't he?
That is the general practice, yeah.
Okay. So to the environment, so to the HRA first of all. So that's E15.
Sorry, can you say that again, please?
That's right. Core document E15, E15, and when you get there, it's not actually paginated, but if you're looking electronically, it's page 5 of the PDF.
E15.
E15, yeah, E15. This should be the HRA, the Hampshire County Council HRA.
Okay, I have it open.
Yeah. If you go to PDF 5, which is, it talks about assessment of likely significant effects, talks about the SPA and Ramsar sites. That's right, page 5 of the PDF. E15, E15. Do you have that, Mr. Delahaye?
Yes.
Yes, thank you. So there's obviously, if you look at the second bullet point on that page, deals with, sorry, that's disturbance. So I'm looking at, it's the penultimate bullet point under the SPA's hydrological changes. You see that?
Yeah.
And it says, hydrological changes including water quality, flows, abstraction, nutrient, no likely significant effect alone or in combination with other plans or projects. And then it says, this has been confirmed in recent correspondence with the Environment Agency, doesn't it?
It does, yes.
So to understand the conclusion that's been reached in the HRA, you need to understand what the Environment Agency has said, don't you?
Yes.
Yes. Thank you. So let's look at that then. That's core document L30. Once you've got that, Mr. Hay, I'll just give you a moment to read what they've said rather than read it. It's quite a long passage, so take a moment to read that. I'm just going to ask you about some of the conclusions that they have reached.
L30.
Yeah, L30.
What's that not coming up?
This was probably not one of the ones I gave you on my list, so I apologise.
Dated 17th April 2024.
That's the one, yeah. Just take a moment to read that. You just let me know, Mr. Delahaye, when you've had a chance to read it.
I've read it.
Thank you. So, I suppose the first point is that the Environment Agency, its remit doesn't extend to habitats regulation assessment. That's Natural England's remit, isn't it?
That's my understanding, yes.
Yeah. And indeed, they say they defer to Natural England as the lead authority, don't they, in their statement?
That's what the letter says, yes.
Yeah. It also says that the hydrological assessments could have gone into more detail. So it says, we've reviewed the hydrological assessment, and whilst the document could have gone into more detail, given that, as we accepted, an appropriate assessment must contain complete, precise, and definitive findings, an assessment that could have gone into more detail, well, the hydrological assessment was obviously fed. So my learned friend says this is not an appropriate assessment, but obviously the standards that apply to appropriate assessment must apply, if you like, even more rigorously to the screening, because you have to be certain. So with the screening, I mean, unless you are satisfied you shouldn't even bother to check something, then you need to look at it. So I don't really understand the point that's being made there.
I think, correct me if I'm wrong, and you will probably correct me if I'm wrong. This is a consultation by the Environment Agency. It's not part of the HRA in that sense, although they refer to it. It's not doing that job as consultation on the HRA. It's particularly for the Environment Agency's concerns. So as a starting point, I think that's what I probably need to say. You can qualify that if you think Mr. Strong, because I can understand. I understand where you're going, and I understand the reservations. But I think we just need to get the kind of ground rules in place as to the purpose behind various documents at that particular time. So I'll let Mr. Strong come in, and then we can carry on. I think.
That's the question was put to Mr. De La Haye when doing an appropriate assessment, and then a question followed. This is not only is this a consultation response on the planning application, but in fact the HRA on hydrology concluded no need for an appropriate assessment because no likely significant effects were being identified. So that's all I was intervening on, because this isn't so far as all the statutory authorities are concerned, there isn't a requirement to do an appropriate assessment. That's all I was making clear.
That's fine, and I'm just trying to understand the basis on which that conclusion was reached. And so as Mr. De La Haye agreed, when you read the HRA, it refers to what the Environment Agency has said. And so to understand what the HRA is saying, you need to look at what the Environment Agency is saying. And of course, all of these documents, the hydrological assessment, the environment assessment, are part of the evidence base which informs the HRA that's been undertaken. Do you accept that, Mr. De La Haye?
Can you say that again, please?
Yeah, that's fine. These documents that I'm referring to, so the Environment Agency consultation response and the hydrological assessment to which it refers, these are part of the evidence base upon which the HRA has been produced. Do you understand that?
If so, this would have, if this was used within it, it would have been to use the argument provided by the Environment Agency is not the same as considering what the Natural England say, because they obviously the statutory body. But we would normally, when writing habitat regulation and receiving advice from Environment Agency, we would consider it.
Yeah, and that's part of the evidence base which you use to reach the conclusion that you state in your HRA, isn't it?
Yes.
Yeah, and that's what we have here. That HRA has used the Environment Agency's comments as part of the evidence for its conclusion that there's no likely significant effect from hydrology. Yes.
It still would have reached the conclusion of no likely significant effect without the consultation from the Environment Agency, though.
Well, I don't know how you can possibly say that with any certainty, because it specifically says this has been confirmed in recent correspondence by the Environment Agency. It must be relying on the Environment Agency to some extent, surely.
But it can still rely on it and not be completely dependent on it.
Okay, so you're saying, obviously, appreciate you didn't write this document, so it's difficult for you, but you're assuming that had the Environment Agency not supported or not said what it did, wouldn't have made any difference to the conclusion in this report. Is that your view?
Yes.
So it doesn't matter what the Environment Agency said?
That's not what I said.
Okay.
I said it still would have came to the same conclusion.
Okay, all right. I don't really know the difference, because if they would have reached the same conclusion anyway, does it matter what the Environment Agency says?
You would always consider the views of statutory bodies when you're writing HRA.
Yeah, because you're very keen to, the inspector considers the views of statutory bodies, aren't you? Making their conclusions, they are important.
The natural and is very important when you're writing HRA, yes.
All right, but let's say the Environment Agency then, is that your point?
Less so than the Environment Agency. Sorry, I did not.
Well, you seem to be saying that the Environment Agency's comments were important and made a difference, but also saying on the one hand, but also saying it doesn't matter what they say on the other because they would reach the same view. So I'm just trying to understand that.
I didn't say it doesn't matter what they're saying. I'm saying the conclusion would have been drawn without this letter.
All right, then it didn't really matter. I mean, I just don't really know. Either it matters or it doesn't. I mean, if they would have reached the same conclusion without the Environment Agency, then what the Environment Agency says doesn't matter. Surely.
Well, no, because they're two different things.
Okay, well, let's not get bogged down in that. Just want to let's assume that the Environment Agency's comments were part of the evidence base on which the HRA was based. Let's assume
The shadow HRA.
No, I'm talking about the HRA.
Okay. Right. Yeah.
Yeah. Let's assume that. All right. As evidence supporting an assessment taken under the habitats regulations, it needs to be the best scientific evidence in the field, doesn't it?
Yes.
Yeah. So, right, thank you. Let's just take that. And that evidence has to be capable of supporting a conclusion that you can rule out the possibility of any likely significant effect if you're doing a screening assessment on the protected site, doesn't it?
Because you're putting the law again, the best scientific evidence available relates to an appropriate assessment, not the likely significant effect stage. We're here dealing with an HRA which is making a judgment on whether or not to go down the route of an appropriate assessment. If you go down the route of an appropriate assessment, then you follow a different path. But we're not, it's kept on put. The questions keep on coming as if what's being undertaken here is an appropriate assessment. I don't want to interrupt my own friend any more than necessary, but it just won't help in the end to get answers on a false basis.
Well, I mean, if I may just respond to that with 2 points. I mean, the first is that the case is being put without prejudice, that even if you do an appropriate assessment, you get to the same result. I understand that, but no doubt the same evidence would be relied upon in that case. The second is and this might be a matter for submissions, but I cannot understand if my learned friend is going to put the proposition that any lower standard of evidential certainty or evidential quality would apply to when you're screening something out, because the whole purpose of the regulation is to rule out adverse effects. You screen something out because you can look at it and immediately say, there's not even a possibility here, so we don't need to look further. But that doesn't mean to say you can reach that conclusion on the basis of shoddy evidence, and that you only actually look at the evidence in detail when you're doing an appropriate assessment, because if you did that, you would of course miss a number of potential effects. So perhaps my friend can help me there, but that I don't understand. If that's the proposition he's making, I don't believe it's correct.
Yeah, I'll let you come back on that, and then we'll move on, I think.
So I was going to suggest it's a matter for legal submission, but just to be clear, there's a basic difference between satisfying yourself, you don't need to go further, and doing an appropriate assessment where you do go further. And clearly you don't have to do everything you would do as an appropriate assessment at the LSE stage, or there wouldn't be any point in the LSE stage. So, I mean, of course, the tests that you apply at the appropriate assessment stage are then best scientific evidence available, etc. But you're entitled to say, I've got enough here. You could go into more detail if you want. Maybe we go into huge amounts of detail. Do I need to? No, I'm satisfied. That's the end of it. If, on the other hand, you say, well, go into more detail, actually, I still don't think I know the answer, then you go through the appropriate assessment. If that helps, since you asked me to help.
Does it help?
It does help. I suppose the end goal is the same. Okay, the end goal is there has to be no reasonable scientific doubt about the possibility of an adverse effect, and that will apply. Ultimately, that's where you get to, because the regulation itself doesn't divide itself between screening and appropriate assessment. Ultimately, you have to get to a point where there's no reasonable scientific doubt. You might be able to get there quickly by looking at the screening stage and saying, is there a likely significant effect? Or you might need to take longer about it by doing an appropriate assessment. So I accept that, but the ultimate goal is the same.
Yeah, if it helps me, the matter that I need to be reassured about is was the reason for screening robust?
Yeah.
And that's what I need to get to. So if we think about that to some extent from both parties, that helps me understand the next stage of your argument, I think.
Yeah.
And I think that's where you're going to, and perhaps we jump beyond into appropriate assessment before we got past the screening base.
Okay, yeah. Thank you, sir. I'll proceed with my questions, and I appreciate the discussion. It's helpful, I hope, to you and to me and to others. All right, so talking about screening assessment then. This screening assessment, let's assume it's partly based on what the Environment Agency has said. The Environment Agency has said they could have gone into more detail, but they're satisfied. They say, we believe, so let me just check. We believe that the scale of impacts will be small and not sufficient to have any detrimental impact on the designated site, although we defer to Natural England. Yes?
That's what's written, yes.
Yeah. Merely saying that you believe something's not going to have an effect is not a declaration of certainty. There's no effect.
Sorry, can you say that again, please?
If you just say you believe something's not going to have an effect, that's not the same as saying you're certain it's not going to have an effect, is it?
Well, it could also be saying that they believe based on their professional assessment.
But they don't say that. They just say we believe.
So but that's still at the screening stage is offering an opinion. Yeah, that is that they believe that the impacts will be small and not sufficient. It's not a correct way to write a habitat regulations screening assessment, but this is not a screening assessment. This is a consultation advice.
Okay. Well, I'm going to move on. I suppose if it helps, my proposition is that the screening assessment cannot have been adequate because, first of all, it's based on an assumption that there's not going to be any material hydrological effect, and that assumption is flawed.
But it's not based on an assumption.
Well,
it's based on the evidence provided within the hydrological reports. That's not an assumption. That's professional.
Okay. If that evidence is wrong, then follows that the screening assessment is wrong, doesn't it?
If that evidence is wrong, it could mean the screening assessment is wrong, but you would have to rescreen.
You'd have to rescreen, yeah. Okay, on the assumption that there was a change. And also, it's flawed because if there's a change, and if you were to rescreen, you'd then want to look at what habitats might be affected, and there's not any evidence of that either. That's never been done.
But that doesn't mean it's flawed. That means you're assuming on your opinion that it's flawed. The screening assessment is backed up by hydrological evidence provided in the hydrological reports.
Yeah, and there's a dispute about that evidence. I mean, that's right.
Sorry, I can't hear you when you've got your.
There's a
hand.
dispute about that evidence. Yeah. Okay. I mean, I think I want to make clear I'm putting our case to you, and I think that's clear. I hope that's clear what our case is. I don't want to get bogged down too much more in what the HRA said or the SHRA said, because it's obviously depends on the inspector's got to reach his view on the evidence that he's heard in the course of this inquiry. So I want to touch very briefly on the topic of mitigation, but not for very long. And then I'm going to hopefully move on to natural England and then recreation more briefly. Okay. So mitigation, a lot of time has been taken up by whether the HRA relied on mitigation or whether it didn't. And there is a disagreement between you and Mr. Andrews about that. And I don't think it's productive to go through all of that again with you, because you've given your evidence in chief about it, but to record there's a disagreement between you about it. And so really I just want to put one point to you about it out of fairness and then move on, if I may. So your rebuttal, paragraph 2.1.31. Just let me know when you've turned that up.
Can you say this? Sorry.
Yep, your rebuttal, paragraph 2.1.31. in your rebuttal. Have you got that, Mr. Delay?
Yeah.
Yeah. So this is where you quote from the eco advocacy ruling, and about the differences between essential features, if you like, and mitigation. So essential features are those that are essential and inseparable from the project, even though they may incidentally have benefits of avoiding or reducing effects on European sites. Mitigation in this context involves a certain combination of additionality and intention to protect a European site. So I suppose if you have done something in addition to what you would ordinarily have to do with the intention of protecting a European site, then that is mitigation for the purposes of screening. Is that correct? Have I understood that correctly?
If you are doing something additionally to provide mitigation, that would need that would mean it's mitigation, not embedded mitigation.
Thank you. And then, so if I just take you to B102, core document B102. Which is a technical note, response to the LLFA, and you looked at that before. It's the it's page 2 of that. Actually, the pagination is a bit weird, but it's, if you got it electronically, it's the 4th page of the PDF where it's quoting the LLFA holding objection. Do you have that?
I can see it, yes.
Yeah, so just the second paragraph of that, they say the concern relating to post-restoration ground profiles is significant given the impacts on the change in hydrology, and therefore the assessment and conclusions within the environmental impact assessment and habitat regulation assessment. It may also affect other submitted proposals. That concern then led to changes to the post-restoration ground profiles, didn't it? That objection.
The objection did, but not the fact that they changed it to deal with the habitat regulations.
But I don't want to spend too long on this, but the reason why the LLFA thought that objection was significant was because of the impacts on hydrology and habitats, isn't it? That's what they say.
Concern relating to post-restoration ground profiles is significant given the impacts on the change in hydrology.
And therefore the assessment and conclusions within the environmental impact assessment and habitats regulation assessment.
That's the opinion of the LFA,
Yeah.
who is a body that deals with flooding.
Okay, I mean, I put it this way, I suppose. If the inspector reaches the view that those changes to post-restoration ground profiles were made additionally and with the intention of addressing concerns about impacts to European sites, then they would be mitigation measures. If the inspector reached that view, he'd consider them to be mitigation measures, wouldn't he?
So the primary reason for the suds on the site is to convey, attenuate, and allow infiltration of water. So the LFA is dealing with flooding. So the fact that they've talked about habitat regulation assessment, landscape strategy, and EIA is not within their remit. As far as I'm aware, the LFA holding injection was to do with modelling of the modelling process, which I think Dr. Dewhurst talked about yesterday, which I don't really want to get in because it starts straying out of my field of expertise. But I don't see anything in there that the LLFA are saying other than there needs to be change to the hydrology.
Okay, well, a lot of time is spent on this issue. I wanted to get a comment on that. I don't want to pursue it any further because the inspector will have the evidence in chief from various people. So I'll move on from mitigation, if I may. Just then to Natural England. There in one moment. So so it's right that Natural England did raise I suppose the first point about Natural England is that do you accept that their advice on this was based on their understanding that there would be no material change in the hydrograph on the site?
Natural England drew their conclusion from the information provided in the hydrological reports.
And okay, all right. But those hydrological reports, to be fair, did not include what Dr. Dewhurst told us yesterday. That there was no way of knowing what the change to the hydrograph would be, no way of measuring it, and that she didn't believe. And I appreciate she subsequently said she didn't believe the change would be material, but those statements were not considered by Natural England, were they? Because they obviously weren't here to hear that evidence.
But my understanding of the hydrology is that it still wouldn't lead to an increase, change in the quality, quantity, or the material change in the flow. Natural England are a professional organisation who have a ability to make a informed decision on the information that they were provided. The information they were provided allowed them to agree with the then competent authority that no adverse effect to integrity of site would occur. That's the only conclusion I can draw.
Yeah.
Because I wasn't working for Natural England.
No, and we've been through the evidence about whether there would or wouldn't be changes, so I'm not going to go through that again. But it's right that Natural England did raise a concern about hydrological effects of the development, and that's in its consultation response 3rd of March 2022, which is called document G10. So can I ask you to turn that up, please? Page 5 of that document. G10, yeah, G for golf, 10. Do you have that, Mr. Delhay?
I do.
Yeah, so page 5, they deal with hydrological impact. They say the water environment and flood risk chapter of the ES notes that the designated sites along the foreshore of the River Hamble and Southampton water are associated with brackish and estuarine waters, which will be negligibly affected by any small reduction in groundwater flow as a result of the on-site works. We will draw attention to the Lintsgrove and Hackett's Marshes SSI, which shows a natural transition from unimproved pasture through salt marsh, and therefore could potentially be impacted by changes to groundwater flows. So they highlight a slight concern about Lintsgrove and Hackett's Marshes in that consultation response, don't they?
I can see that, yes.
Yeah, thank you. Right, and then there's then a letter from Stantec dealing with that, and that's called document L32.
Do you want us to look at L32, Mr.
Do I want to?
No, do you want us to look at L32?
Yes, please. I'm sorry. Yes, That's right. I think in fact
You just mentioned it passing. I didn't know if you were going to take us to it.
Yeah, no. Well, in fact, it's not my L32, so it might not be
helpful then.
Yeah, so it might not be worth going to that. But this is dealt with also in Mr. Andrews' proof, so I'm just going to turn up the right part of that.
So we're going to Mr. Andrews' proof.
If you want, to save you all the time, I'll just check where it is in Mr. Andrews' proof.
The actual Stantec response to that.
Yes, L31. I was nearly there. Core document L31, page 6. If you tell me when you've got there, Mr. Delahaye.
I have the page open, the document open.
All right, page 6 of the document. All right, so are you on page 6, Mr. Delahaye?
Yeah.
Yeah, okay, so under hydrological impacts in the first paragraph, this is what Stantec said to Natural England. A relatively small component of groundwater flows anticipated to the northeast. The SSI is also to the north of Baddenham Creek, which is where we would expect groundwater emanating from the northeastern corner of the site to discharge. Therefore, we do not consider that the site development will have any significant impact on this SSI. So what Natural England is being told is that actually the SSI is to the north of Baddenham Creek, so there's no effect on that Baddenham Creek. Yes?
I understand what you're trying to say, but there is, in the Natural England document that you have gone, so you've shown us G10. Mm-hmm. I am certain within the other documents they talk about Baddenham Creek and the SSI, and they are happy there will be no likely significant effect. They say that when they have further information provided by the appellant.
That's right, they say that, well, this is the information they've been provided, as I understand it. They're told Baddenham Creek's not in the SSI, just trying to chart it through. They're told Baddenham Creek is not in the SSI, and then if you go to G11, which is when Natural England come back, core document G11. And page 3. So have you got page 3 of G11, Mr. Delahaye?
I have.
So Natural England referred to a letter from Stantec has been provided, and this states that the relatively small flow of groundwater towards the northeast would enter the Badnham Creek and flow into the Hamble. This would prevent any impacts occurring at Linsgrove and Hackett's Masters Triple SI, which lies beyond the creek. Yeah, so they accept what they've been told. The Triple SI is beyond Badnham Creek, and they say, all right, well, given that, there's no concern with the Triple SI. That's what they say, isn't it? So that's what they say, isn't it, Mr. Delahaye?
Sorry, I was just reading the paragraph underneath.
That's fine.
Yeah.
Yeah. Okay, but of course that's not right, is it? Because Badnham Creek is in the Triple SI, isn't it?
I'll have to have a look at my.
Yeah. Well, you've provided a map in your rebuttal on page. Well, it's just after paragraph 2.1.54.
There is a map, wasn't it? Yes.
Yep. Now, Badnham Creek is the blue. If you look at the map, there's a blue line that starts in the top left hand corner.
Yeah.
Blue River, if you like, goes down across the site. The blue line represents the low tide mark of Badnham Creek, and then the yellow lines around it represent the high tide mark, don't they?
The blue lines represent the creek, and the I would have to look that up on magic.
Yeah. I mean, even if you take the blue line, right?
Yeah.
That is a large part of that is within the Triple SI. This is your map. You've marked the Triple SI in the hatched area. A large part of that blue line is within the Triple SI, isn't it?
Yeah.
Yeah. So when Natural England said Badnham Creek is not in the Triple SI, that was incorrect. And so Natural England's withdrawal of concern about this issue was based on an incorrect factual premise, wasn't it?
So there are parts of the Badnham Creek within the which are shown within the map within the Triple SI boundaries. I'm not entirely sure of where the incoming flow is in relation to that. It's still of our opinion that the change of flow and quantity is not going to be, the quality and quantity is not going to be significant and not going to lead to a change of the hydrological regime.
I know that's your opinion, Mr. Delahaye, but we're just trying to understand why Natural England's reached the view that they have, and I think you can't deny that when Natural England said or were led to believe that Badman Creek is not in that triple SI, that was factually incorrect, because it is.
That is, we're assuming that Natural England didn't look at the maps themselves, their magic maps, and have a look themselves.
Well, it must assume they hadn't, because had they looked at it, they'd have looked and thought, "Oh, there it is. It's in the triple SI," because it clearly is. So we can only assume that they didn't look. It is objectively in the triple SI, isn't it? So factually, Natural England is incorrect.
So I'm just reading the previous document. So it would appear from the mapping that there is a inconsistency on the location of the creek within the triple SI.
Right. I don't quite know what you mean by that. Are you trying to say the map's wrong, or?
I'm not saying that the map's wrong.
Yeah. So the map's right. The creek is in the triple SI.
It appears to be so, yes.
Yeah. And so when Natural England say the creek lies beyond the triple SI lies beyond the creek, that's incorrect.
That appears to be incorrect, yes.
Thank you. I mean, that really concludes what I want to say about hydrology. I appreciate I've taken a very long time to do that, and that you've been sitting there for a while. So I'm going to go on to recreation, and we'll do that more quickly, and I'll make every effort to do that. But I just want to check that Mr. Delahaye is okay. He's been sat there for a while.
I'm fine, thank you.
So if you're content, I'll proceed on to hydrology. Yeah, no, yeah, we'll do that all again. No.
What I'm going to do, if it's an assistance, I think once we've completed, I'll ask for any questions from people who wanted to speak, and then I think even though we will be impaired, I think I'm going to have to take a break because he's been sat there a while.
Yeah,
so
I understand that, and I accept responsibility
if that's okay.
Yeah, that's fine, sir. So recreation, in fact, is what I'm going to go on to. Just want so I suppose the first point is that one of the reasons why it's asserted that there will be no adverse effect on integrity from recreational disturbance or recreational displacement is because of what is being provided on the site under the development. So I just want to look at that briefly, if I may. So I suppose, first of all, I want to understand a bit about the current use of the site. So can I ask you to turn to core document L59. Do you have that, Mr. Delahaye?
I do.
Yeah. So this is obviously something that has been produced by local residents. The second paragraph says, this paper shows the significant use of the airfield currently shown by the established trails and network of pathways across the site. One of the aspects most recognised of the airfield users is the 60 hectares of free, open, rugged, natural space where people and dogs can roam free on this network of pathways. So that's what local residents say about what they like about the site, okay? And then if you turn a few pages, you get an aerial photograph of the site.
Is this the back page or the thumbnail that's at the top of
It is
the third page?
not the thumbnail, but it's, if you go a couple more pages to the 5th electronic
yep.
page, yeah.
Page 5.
Yeah. Do you see that, Mr. Delahaye?
I do. Yes.
Yeah, so, and I mean, that sort of bears out what local residents say about the site, because you can see it's an open space. There are a network of paths crisscrossing the whole of the site, aren't there?
There are paths
Yeah.
throughout parts of the site, yes.
Yeah, so that's how it's currently used. I don't think necessarily dispute that that's the way in which the site is currently used for dog walking and local residents for recreation. Yeah. Sorry, you nodded your head, but that's...
Yeah, sorry,
yeah.
We're disputing its use for recreational, not disputing its use for
Yeah,
recreational
thank you.
activity.
Yeah. So that's what there is now. So I want to just look briefly at what is being proposed. So first is B61, core document B61. That is the operational plan, I think. We got that, Mr. Delahaye?
It's just loading on.
Oh, thank you. It's got a lot of layers, I imagine. Just give me a nod when it's loaded.
It's now loaded.
Thank you. All right. So this is what we're getting during the operational period, and you see along the perimeter, particularly on the eastern side of the site, and also parts of the northern side and a little bit of the western side, a orange dashed line.
Yep.
And that, if you look at the key, that is the extent of the proposed permissive path, yes?
It's to the extent of the path, but it's not the extent of the habitat that is available.
Well, I just want to be clear about that, because the permissive path as far as the local residents understand, and I know there's concern about unauthorised access to parts of the site that people don't have the right to be on. The permissive path, the right to walk on the site, is restricted to the path itself. There's no right for people to roam in those landscaped areas that I'm aware of, or that's indicated in any of these documents. It describes the line of the path, and that's it.
There is a landscape area around the permissive path, which would be able to be used for recreational activities.
Well, you're saying that, but I'm just, and my learned friend put that, but I want to understand what the evidence for that is, because the permissive path, your rights are restricted to that path. If you deviate from that path, you're trespassing. So,
but the idea of this path is, which makes it a great amenity, is it legalises the access. And it provides a permissive path in which they can walk their dogs or walk without a dog. And it has a fenced off area to prevent the dogs straying. It has some retained vegetation and some landscape vegetation. So it's designed to provide a great place to walk and designed to provide connectivity between the south east end and the north end up at near the railway station. Therefore, although it may say it's a permissive path, the idea is that it's a recreational amenity that will allow people to enjoy and use it.
All right. Well, I mean, I think I can't say any more than obviously if there can be some kind of evidential confirmation provided that the right for the public to access that area goes beyond the designated permitted path, then obviously it would be helpful to see. At the moment, my clients haven't seen it. So our understanding on the evidence is that the permissive path is the extent to which people are permitted to go, and beyond that they might be able to see the landscaped area but not go on it without trespassing.
Wishing to interrupt you, but I weren't quite sure if you were suggesting that you're inviting the submission of further evidence in the form of, say, technical note. You seem to suggest that, but you stop short of it. It could be provided. Is that what you're asking?
Well, I mean, I suppose the point I'm putting to Mr. Delahaye is there is no evidence that confirms that.
Except that, but you seem to invite.
Well, I'm not
if
inviting.
I were to be,
I'm not inviting anything.
Right, that's fine.
What you invite, I suppose, is a matter for you, sir. But the proposition I'm putting to Mr. Delahaye is there is no such evidence.
Well, there is evidence within the Hampshire County Council HRA where they talk about the dimensions of the path, and it's the dimensions of the path are presented within the document that you're looking at. There is no evidence in it that they will not be allowed to walk outside of the permissive path. There is evidence within the fact that the appellant is trying to provide a alternative mitigation strategy. And to me, it seems clear that that would include allowing people to walk within it. The idea of having the permissive path is there's an area that is going to be maintained and managed, so it provides easy access for people. I have found nothing within the documents I've looked at that suggests that there will be no, that they will not allow people off the permissive path.
So you've made an assumption that people would be allowed off the permissive path, but you can't point to me to any document that says people would be.
It's not an assumption. It's based on the information that I've seen.
well, I think on this, just to be clear, because we probably need to get this right, and I understand the question, reason why you're asking that question, absolutely. But as I understand it, there will be an element of this strip that will be surfaced, or have some kind of walking route. Then there's an element of landscape, come made of grassland. And I think the point's been made that if people were to stray off the path and into this meadow grassland, would that constitute trespass? And it might be just helpful to clear up any misunderstanding as to how that use could be, that we have some form of note that clarifies how that strip might be used. I don't want to take away your case, because I understand why you made the point, but you put a doubt in my mind now as to whether or not this is going to constitute trespass, perhaps unwittingly. And I think that's something that I think I need to probably be clear in my mind. So I think, with respect, I think I'm going to ask the appellant to provide us a little note on that. I don't see any reason why that can't be done tomorrow. Or is it? It's not a big note, is it?
No, it's not a big note, sir. And just to be clear, it is intended to be capable of use in the way you've described.
Yeah.
I've never understood it to be anything other than that. If you look on the plan, there is the purple dotted hatched line. If you go across to the quay, that's where the proposed stock-proof fencing is, and you'll see the only element where, for example, stock, which will cover dogs, is if you go to the bottom at E. So you'll be able to see to the left of that, the area that would take you to the west side of the site is intended to be not for use it's intended for nature use. And the reason being because that takes you up past people's back gardens and of course ultimately to the access way into the site. So that will be still laid out for nature conservation purposes, but not intended for public access. But the whole strip, starting at the 70 metres and then fluctuating with what's intended to be a main path through, is always and has always been intended to be both the path and the ability to use the landscaped area. But we can confirm that in the note, but I don't want by doing so to be accepting that wasn't clear already. But my lone friend puts it in that way. Don't think everyone else is.
And it would have been my understanding based on other schemes, but I can accept the point that it's not specifically clear. It's probably inferred with some degree of judgment, I think. But it might be helpful because I don't want to go down the line of thinking, well, there's a path here, but as soon as I stray off the path, we've got some other issues that might crop up. So just to clarify that, I'm sure that wasn't the intent.
No, that's not the intention.
I'm sure it is.
I don't think we would have any success in trying to prevent people from straying from the path.
But nonetheless, I think if there's an element of doubt, and there is, then it might be helpful just to clarify that, whether it's a modification to the plan or just an explanation on some key text or something that just confers the intent of that particular route.
Yes, well, we can certainly do that, and we could even reflect it in the condition.
However you wish to do it, but I think and I don't want to take your point away because I understand why you're making it, but I can't leave the point hanging either because it throws up something that is crucial to this particular plan, crucial to the operation, crucial to condition, but more importantly, crucial as to how people use it, if indeed this were to be permitted, because it throws an element of doubt there. So I think we'll clarify that doubt.
So I don't object to that, and I think I hope you all appreciate it's very important to the local community to know that, have that certainty.
That's the primary reason why I think I interjected. I wouldn't normally interject, but you've thrown something in, and I thought I cannot have that point hanging.
Yeah, it's fine. But so leaving that to one side then, while we get clarification of that, there are other features of this proposed operational plan that we need to know about. So obviously it varies in width, and I think the maximum is 70 meters to the south, I think. Yeah, in the southeastern corners of the area where the path goes, is 70 meters is the maximum width, but it does vary, doesn't it?
Sorry, did you ask me a question?
Yes, the width is varying, so 70 is the maximum width, but it is in some places significantly narrower than that.
Yes, that's right. Within the permissive path, the widest area is 70 metres, and there are different areas.
Yeah, and if you're a resident walking along the permissive path, obviously there's going to be some kind of landscaping, but it's right to say that any landscaping will take time to be established.
Yeah.
Yeah, so trees aren't immediately going to spring up from the ground. So there'll be a period where this is not particularly attractive. Do you accept that?
I think having walked it, it's always going to retain a character of its own. No, okay. I think it'll be unattractive.
Part of the character will be a 3 to 5 metre bund running, if you're walking from south to north, on your left-hand side the whole way up.
There will be a bund, yes.
And you wouldn't be able to see over that bund, would you?
If it's 3 to 5 metres high, no, you won't be able to see over it, no.
No. So the kind of open nature of the space will be somewhat diminished by the bund, won't it?
Well, there will still be ample area within the permissive footpath for you to walk and enjoy the habitats within it.
If you are walking on the footpath, you've obviously got the bund, you've got the fence on the other side. during the operation of the quarry, you will obviously be hearing the sounds of the quarrying going on, won't you?
I'm not. I'm not aware on the operational noise. I'm not a noise expert. So.
Okay. Okay, fine. I mean, I think it's reasonable to assume you will hear something of the quarry when you're walking right next to it, and that might, again, diminish your understanding of that space.
Well,
Your understanding, your enjoyment, sorry, that space.
I believe there is mitigation in place to reduce the noise, but I'm not an expert on noise, and I don't understand the mitigation on noise regarding the working protocol.
Fine. So to be fair to you, you can't say whether it will be noisy in that location or not noisy, because you're not privy to that sort of level of detail. It's not your expertise. Is that right?
Well, I don't think it's a question I can answer fairly.
Yeah, that's fine.
Yeah.
That's fine.
So,
Yeah. That's fine. But I suppose you making a judgment in assessing the suitability of this space as a replacement for the existing airfield, but you've made that judgment without any understanding of how noisy it will be during that period. Is that right?
I understand there is mitigation for noise, which is the purpose of the bund, but I don't want to be drawn into specific questions about noise.
Okay. Okay. And then I think, probably out of fairness, we want to take you to. We obviously have the restoration plan, the reference to which it's currently escaping me. We may not need to go to it, but I mean, basically, the restoration plan is the paths plus a meadow in the northern part of the site. C1. Let's go to that then. Let me know when that's loaded. It's probably take a while.
It's loaded up.
Thank you. I mean, so you've got the permissive path still indicated there, and in addition, you have the meadow in the northeastern corner.
Yes.
Yes. I mean, and obviously you can see that meadow is considerably smaller than this, open space that's currently available on the site, isn't it?
It is.
Yeah. So there's a significant qualitative difference in the space that's available now compared with the space that will be available post restoration.
There will be a sizable legal area to use. So it's 11.3 hectares, split between the 7.8 hectares of the permissive footpath and the 3.5 hectares of the meadow. So it provides a legal way for people to undertake recreational amenity, whereas at the moment it doesn't. It also means there will be a management and maintenance plan put in place to ensure that the site is managed in a way that will preserve the ability for the amenity activities to be undertaken.
Okay, I mean, I appreciate you will provide a legal route, but the fact is, and it's been accepted as a fact, is that people use the whole site, legal or not, and it's not illegal to trespass, but lawful or not, okay, people use the whole of the site at the moment, and following restoration, the amount of the site that they will use will be considerably less, because that's all that will be available for use. That must be correct, just looking at this plan.
Well, it is correct, yes. It's not. it's not a small amount of mitigation though. It provides a large space which will, when the restoration process has been put in, will be a part of a much larger green area. So
Well, to understand how effective it is at mitigation, we need to have some understanding, some detailed understanding of how the site's currently used and how it might be used were this scheme to be implemented, wouldn't you?
well, if we were undertaking a housing development here, and we were proposing putting in a bespoke mitigation plan that we would run past Natural England and the competent authority, we wouldn't undertake a assessment of the people using it at the moment.
No, because if you were providing housing, I mean, you can't assess, you can't ask the people who might live in your house where they'll go for their recreation because they're not, you don't know who they are.
No.
But here you do have you have an area which you know is used for recreation. So in theory, you could first of all ascertain how many people do use it, and you could ask them, what would you like about it, and what would you do if you didn't have it, or if it were replaced with the scheme that we're providing. You could do that, couldn't you?
We could, but we wouldn't be certain that the results we got would be unbiased at this point. And what we're providing is something that is based on a professional judgment that will provide a amenity, an alternative amenity.
Yes, you have exercised a professional judgment, so you say. But as I say, you could if you wanted to. Well, I'm going to go around in circles. You say you couldn't provide an unbiased survey, for example, but never. Well, you could, for example, have somebody there recording how many people are there using it per day. You could do that in an unbiased way, couldn't you? You could work out the extent of use per day because you could just observe that.
But would that ultimately change the mitigation strategy?
Well,
Yeah.
if you knew that, say, as is suggested, that some 650 people, well, the survey says that, without going into lots of detail, if you knew that some hundreds of people used it every day, then you would have information about the number of people who would not be able to use that space and might have to go elsewhere were you to take that space away from them.
So it's 7 point. It's going to be 11 hectares, and if we were providing a SANG under SANG guidance, it's 8 hectares per 1,000 people. So we have an idea that this would support, if we're following that conclusion, of over 1,000 people. Therefore, our judgment is that it would be a suitable mitigation.
You have an idea, but what you could have, and in fact you do have, because the survey has been provided, do you have evidence of how many people do use it at the moment? So you could, if you wanted to rely on that, and we say you should, reach a judgment about how many people are going to be displaced, an informed judgment about how many people are going to be displaced by your development.
We could use it, but we don't think we'd get an unbiased result from it, and therefore, if we are going to get an elevated figure, we don't know how much use that would be. We have based the mitigation measures on a professional judgment that have been endorsed by the Hampshire County Council and Natural England, Natural England have people who look at alternative natural green space all the time, and they have expressed no concern with that. I think there is sufficient information provided by this, and the evidence provided by the fact that the competent authority and the statutory nature conservation body don't have a problem with it, that we are providing an adequate alternative mitigation.
Well, at the moment, if you like, the only evidence you've got about how many people use the site and where they might go are these surveys. You don't have any other evidence. I mean, we'll get to the point whether you need to produce them or not, and you say you don't. But the only evidence that the inspector actually has about it is the survey evidence that has been provided on behalf of my client. That's right, isn't it?
Well, you're saying your evidence is accurate. We are saying we think it is biased, and we're also saying the evidence that we are providing through the fact that we have it endorsed by Natural England and the Hampshire Council is adequate evidence.
All right. Well, you in the HRA, there's a conclusion, obviously, that there's this mitigation being provided, and then there's an additional statement in the HRA which I want to come back to. And so the HRA is core document E15. So if you turn to that, and it's PDF page 7.
Which HRA are we looking at, sorry?
The County Council's HRA core document E15, E15.
Sorry, my computer's not loading it up. Could I have we got a paper copy of it?
No, I've no objection, Seb.
No. Perfect, thank you.
Do you have that paper copy now, Mr.
Yeah.
Yeah, thanks. I'll just let you pour yourself some water. We are nearly there. I've taken a lot longer than forecast. No more than 10 minutes, sir. So, Mr. Delahaye, it's not paginated, but if you turn, so it's in the stage 3 assessment, on the sort of second page of the stage 3 assessment, at the very bottom, there's a subsection, which is headed Considerations regarding the magnitude of the predicted recreational impacts.
That's correct.
Yeah, and so what it says is there is a considerable availability of alternative public rights of way in the immediate area surrounding the site, which run through land that is a substantial distance from the local coastline and national site network sites. These local routes are not directly linked to the coastal area. The reduced likelihood that the majority of the existing recreational activity on site displaces to the local coastline as a result of the development, especially as this reduced the likelihood that the majority of the existing residential activity on the site will displace the local coastline as a result of the development, especially as the majority of the existing unauthorised use consists of local people taking daily exercise and dog walking. It can be assumed that the preference is for routes immediately available to the area. Do you see that? So that is an assumption that's been made in the HRA, isn't it?
Well, it's an assumption based on the mitigation strategy that's been put forward. So it's only an assumption in the fact they've worded it that way. We've looked at the local amenities, the recreational amenities, and come to a conclusion that there is this is a suitable mitigation site that has interconnectivity with adjoining areas that provides local walks.
Well, they assume that because there's interconnectivity, they assume that people will use areas not closer to their home and not next to the national site works. That is an assumption that they've made.
Well, the whole premise of using alternative natural green space to act as a SANG or ANRG is that you're not going to prevent everyone going to the coastal sites or the national site networks around it. There is nothing within the documentation about it that says this. It's providing an avoidance strategy where you take the people in the locality to it and it attracts people from further into it to use it. And some people will still go to the designated sites. It's not a provision to prevent everyone going to the site. There's already people who will be using it, and there is a mitigation strategy set out in the areas around it, in the Solent, that does not look to prevent an increase in number of people coming. It looks to prevent access, and it looks to prevent change people's behaviour.
That's not an answer to my question, Mr. Delhay. The question was, there is an assumption that it does rest on an assumption that people will use the routes immediately available to them and not go to the national. So they will prefer to do it. That is an assumption. It quite clearly states that it is an assumption.
So, regardless if it's an assumption or not, or it's not based
Well,
on...
is it an assumption or not? Because I'm saying to you it is an assumption. It says it's an assumption. So yes or no, is it an assumption?
Well, it says they assume, but are they assuming based on the information that is being provided?
So it says they assume, so they are assuming. So it's an assumption.
It says it can be assumed that the preference is for routes immediately available to the area.
Yeah, but the question is, do you accept that that's an assumption or not?
They've written that, yes.
Yes, okay. Thank you. But actually the evidence from the survey that we have and that Mr. Andrews has detailed in his proof is that people will want to walk their dogs on the coast. That's where lots of them will want to go. That is actually logical, isn't it?
But that's because part of your survey talks about a 3-metre path where you're assuming that they're not allowed to go off it. So it doesn't sound like an attractive or viable places for people to walk. It doesn't give people the option that they could walk the dog in a dog-friendly, which is fenced off to prevent dogs straying, and has a landscape and managed area for them to walk in. It simply doesn't provide them that option.
But if you look at, well, first of all, that is the view of local residents, and actually, if you look at, the Hamble Peninsula, this idea that your walk place is immediately close to you, the coast is close to you. The Hamble Peninsula is surrounded by coastline, and so if you're wanting, as people say they do, and you may say it's biased, but it's not unsurprising that people want to walk their dogs in an open, natural space with open views, that they would then, which the site currently provides, they would think, okay, well, the next best thing is the coast. That's logical, isn't it?
Well, if you want to walk to the coast, then you're going to walk to the coast. But the issue you're trying to allude to is that's going to lead to an increase level of disturbance is not what the mitigation strategy is set up around the Solent birds rescue.
But you've just said that if people, I put to you that people like the site because it's open and natural, open views, that gets taken away, all right? What you're replacing it with is different, okay? People, it's not surprising that people think the next best thing is the coast and they'll go there. And so there will be some additional recreational disturbance in the coastal areas.
But again, there's only disturbance is an actual thing. So if the mitigation strategy is put down to say, well, we are not preventing an increase in numbers, which they're not trying to do. They're trying to control access and behaviour. Then it's already going to be controlled.
All right, so the mitigation strategy, and I hope you can draw up now, the mitigation strategy is obviously the provision of, when we went to it, but if you were a residential development adding to disturbance pressure in the area, you'd be expected to contribute to the mitigation strategy, wouldn't you? Yeah, but in this case, you are, I think, accepting, or we'll suggest, or Mr. Andrews' evidence is at the very least there's some residual increase in people going to the coast, but as a result of your development, but you are not contributing to the mitigation strategy, are you?
But if these people are coming from a residential property, they will have already contributed to the mitigation strategy.
Only if it's a newly built residential property or one that's built since the mitigation strategy was imposed, not ones that have been there a long time.
But then they are considered within the baseline of the population numbers, and that's why they don't have to pay a mitigation fee.
But that baseline, as Mr. Andrews said, was sort of established on the basis, first of all, of surveys of people living in the area, presumably asking them, where do you go to walk your dog? Do you go to the coast? And at that time, the people who were using the airfield will say, no, I don't, I go to the airfield.
Where did he get that information from?
Because
the original survey was done in part by post through randomly generated numbers that were put through a postcode.
Okay, well, I'll ask you the question because you will want trying to satisfy the inspector beyond reasonable scientific doubt here. Can you say that? I mean, it would be logical that those questions would have been asked of people to take into account their effect on the coast. And people who live in Hamble at the moment and use the site, their answers would have been influenced by the fact the site provided an alternative for them, wouldn't it?
I don't know that.
You don't know, but okay, you don't know. And the second question then, and you may not know the answer to this, is that the surveys presumably would have included some consideration of the actual state of the designated site. So what condition, the condition of the designated sites, what condition are they in to work out how much more recreational pressure can they absorb, etc. Would that be something you'd expect them to have done?
They are looking at that, yes.
Yeah, and so if at that time, obviously the site existed providing, if you like, mitigation, because it would have provided an alternative for people who would have otherwise gone to the site. So the consideration of that baseline of the site's condition accounted for the existence of the site, didn't it?
No, I don't agree with that. I think the Solent bird awareness mitigation strategy is based around a increase in population, which they look at the population of the local area, and they're forecasting it to increase. And they are not saying that the increased, they are not saying they are trying to prevent it. So when they looked at the initial, when they conducted the initial surveys and did postcode surveys, they would not have included, are you going to a site nearby? They would have been asking what's people's preference to go to the original site, to go to the Solent habitat site was.
But just to go back to my question, forget what people say they'll do, just looking at the condition of the site at the time the surveys are done, presumably it might be the case that had the airfield never been used for recreation, the site would have been in a worse condition because because more people would have been going to the coast. So the use of the site is factored into that baseline understanding of the condition of the site, of the protected sites, isn't it?
I don't understand your question.
That's fine. As I was asking it, I thought that would probably be the case. Sorry, sir.
It's just how much longer. I'm very conscious.
This is my last
3.5 hours now.
It's my last question, sir.
All right,
Thank
okay.
you. Yeah,
I'm not trying to cut you short because we can take a break and come back.
but it is my last question, and that's fine. Save for one proposition, which I'll put to Mr. Anderson, which you won't agree with, but just for sake of fairness, I'll put it in. The point is about the surveys that are done to support the solar mitigation strategy. Part of that must have involved a consideration of what condition the protected sites were in at that time. Do you accept that?
No.
So you say for sure that didn't happen.
Hang on. 1 second. So the questions that were asked in the 2010 survey, the Solar Disturbance and Mitigation Project, that informed the baseline, asked general questions about your visits to your coast, identifying specific coastal locations that you visit, and about your household. It didn't ask about conditions of the coast.
But that's the survey. But as part of the consideration of the solar mitigation strategy, presumably somebody actually went and looked at the protected sites and looked at what condition they were in.
We know what conditions they're in.
Well, yeah, okay. So somebody at the time, okay. Well, you only know if you've been there. I mean, you can't.
Yeah. So someone knows the condition of the designated sites.
Thank you. So that person who looked at the condition of the site looked at it at a time when the airfield, the site we had, the airfield was being used for recreation. Yes?
Yes.
Yes. So had the airfield not been available for use as recreation, there would have been more people using the coastal areas, and the condition of the protected sites might have been worse because of that.
It may have been worse, but they already have a large number of people on there, and they already have a large amount of set footpaths, the controlling of the access. So it may have been worse, but it is likely that the number of people who are using it wouldn't have an impact on it.
Okay, so and finally, I'll put it to you that the inspector, on the basis of the material he's got, can't be satisfied that there's no adverse effect on site integrity as a result of disturbance, pressure, displaced disturbance arising from this development, can he?
Sorry, I couldn't hear you again.
That's fine. So I put it to you that on the basis of the evidence that he has before him and that he's heard, the inspector cannot be satisfied beyond reasonable scientific doubt that there will be no adverse effect on the integrity of the protected sites as a result of this development, can he?
I don't agree with that.
Okay.
I think there is evidence provided within the application already that shows there is a suitable mitigation strategy, that has been endorsed by Natural England and accepted by Hampshire County Council as a competent authority.
That was my final question. Thank you for bearing with me, Mr. Delahaye.
Thank you, Mr. Fulbrook. Just very quickly, and I'm very conscious we'll probably all need a break. I did say if there's anybody who's ready to speak or has spoken who want to ask a question of Mr. Delahaye, they can do. Does anybody want to ask any questions?
Can I go for a break first, please?
You can, because there's nobody putting their hand up for the question.
Good. Okay.
All right. I'll check again when we come back. I think Mr. Delahaye wants a break, but I'll check again. But I'm working on the assumption that nobody wants to ask him a question. Thank you very much. At that point, it's 4:20 just gone. If we can take a 15-minute break and come back in this room at 16:40. So we're adjourned to that point.
And Mr. Dillehay
Yeah,
shouldn't talk. Oh, sorry.
Mr. A, you need to be mindful of go to the toilet first, Mr. A. was resumed. When we broke, rather quickly, I did say that I'd just give anybody a chance who's ready to speak, who or has spoken, who may want to ask questions of Mr. De La Haye, that they can do so. You don't have to do so. You might have already been satisfied from what you've already heard, but it's your opportunity to ask any questions should you so do wish. Does anybody wants to ask any questions? In which case, thank you for that. I'll give you that same opportunity on the highways evidence as well when we return back in June. Those are the kind of two crucial matters that the main matters relate to. So I will come back to that again with the appellant's highway witness in June. Having said that now, I think we'll go straight into examination in chief and then, re-examination, and then it's been a long day. And then I'll just wrap up on some things that's just a little bit of housekeeping and then matters for tomorrow's site visit and roundtable session. Thank you.
Thank you, sir. Mr. De La Haye, you're nearly there, but just a few questions from me. So I'll just deal with them in the order they came. You were asked about the distances from the site to the habitat sites, protected sites. Do you recall that, Mr. De La Haye?
I do recall that, yes.
And can we please turn up Mr. Andrews' rebuttal? Page 2. Let me know when everyone's there. Yes?
Yep.
You were asked about these distances.
Yep.
Could you just go over the page? I think if these are considered important, we might as well be accurate. The first one is the distance said to be measured to the Solent and Dorset Coast SPA. Yes?
Yep.
The line that's been measured on my map doesn't actually reach the SPA.
No, it doesn't.
It appears
It's
to...
short.
Sorry?
It's short.
Right. So, and perhaps, if you want the accurate distances, perhaps you and perhaps Mr. Andrews and Mr. De La Haye can agree on what the actual distance is. Should be capable of agreement.
Absolutely,
yeah.
It's a point that can be easily resolved, I think,
right.
Because it is a point of difference. Perhaps it would be helpful to have a little note on that at some point in the next day. Well, not day or so, but in the next week.
I'd hope they could come to some common ground on
yeah. It's not beyond the wit of man to do that.
It looks to me that might be at least 20 or 30 meters short. But let's just deal. I mean, let's call it 300 or whatever. Let's say it's 300 meters. It doesn't particularly matter for the purposes. Just go back to what's stated on the HRA, because I think it's been put to you that it's inaccurate.
Yeah.
Can you just read what it says? The site is within 300. Well, it says within 320 meters of 3 statutory protected sites. And if the distances are 280, ranging between 280 to, it may be in the region of 300, I don't know. Is what is stated in the HRA accurate or inaccurate? Are all the sites within 320 meters? You don't need to go to the HRA.
Okay.
It's in Mr.
Okay.
I think it's in Mr. Andrews' rebuttal proof. Just above paragraph 6, he's quoted from the HRA. And I think it was put to you that what was stated is inaccurate. And I'm just asking you whether that's correct. Are all the sites in question within 320 metres?
All the sites within from this map and the one over the page, so page 3 and 4, all the maps within. All the maps, all the habitat sites are within 320 metres of the development site.
I think the Solent and Dorset coast, the distance to the river Hamble is 410 metres, and I think he's putting 272, so that might be the difference. I don't know. But I'm just really dealing with the question whether the HRA is inaccurate. So perhaps I'll leave that for them to agree the distances, and then perhaps Mr. Lay, just to ask you the question, does it make any difference to the analysis in the HRA as to whether the sites are 270 metres, 290, 300 or 410 for the purposes of any of the assessments that are going on?
Not for the impact pathways that we are considering at the screening assessment.
But we might as well give you the accurate numbers if it's going to help your report. I mean, clearly, Mr. DeLahaye, I don't think these are, for example, walk distances.
No, they are not walk distances, no. They are, as a crow flies.
Yeah. Thank you. So that's that. The next, sorry, my computer's gone off now as well. I have it. You were then asked a number of questions about nutrient concentrations. Do you recall that?
I do.
And it was put to you that there would be, if you had a lower amount of water going into the SPAs, you potentially have a different concentration. And you made various comments about it not being material or significant.
Okay.
But just taking it one stage further about those questions, they were put on the basis of if you have a slightly lower flow, you may have a slightly low dilution. Slightly lower dilution, slightly less dilution. Do you recall that?
I do recall being asked that, yes.
Does it make any difference whether there's slightly lower dilution in terms of the effects of nutrients in the way you were describing in evidence in chief?
It's
what I'm asking about is the nutrient levels. If they are slightly less diluted, and I know you've given evidence that it's an insignificant difference, but I'm just picking up on this idea.
If it's slightly more diluted, then the issue will be if the dilution has a effect on the amount of nitrates within the water course, and it's if they are diluting it, they're not removing the amount of nitrates, they're just making it more dilute, and the problems of nitrates are spread further throughout the water course where they're held.
Thank you. Third question, different topic. You were asked a series of questions about conservation objectives, and I'm going to deal with this compendiously if I may, sir. But you were taken to, in your proof, some targets and aims of the in relation to the sites. We don't need to run through them all, but the questions started with mean winter dissolved in organic nitrogen levels, moved to natural freshwater flow, on to natural physiochemical properties, etc.
Yeah.
We were asked a series of questions. On each occasion, the question was put, if there is a change, there is an effect.
Yes.
And you at one point challenged that. Can I just get you to amplify what you were challenging?
Well,
And I can ask you the question, if there is a change, and I know you only said, does that mean that there's going to be an effect for the purposes of the habitats regulations looking at likely significant effects?
well, just because there is an effect, it doesn't mean it's significant. And part of the screening assessment would be look to see if the effect is a significant effect. And if we can be confident that it's not significant, then not significant when we're looking at the conservation objectives with regard to the qualifying features, then we don't need to take it any further than that.
And has anyone identified, either in the documentation or in the evidence that you've heard today, today and yesterday, yesterday, anyone identified for you an effect which approaches something which you would describe as a likely significant effect on any part of the sites?
For hydrology?
Yes.
Yeah.
I mean, the effects of the water.
Yeah.
Sorry, I'm dealing with hydrology. Yes.
Yeah.
So sorry.
Well, from the information that we have been provided from the hydrology team, there is no reason to believe that there will be a likely significant effect because of the fact that the hydrological regime is mimicked. There will be no change to the quantity and quality of water, and no material change to the flow of the water.
And even if you entertain Dr. Clothier's idea that there's going to be some changes in the hydrograph which are greater, or other changes in some water not going to the same places, have you been able to discern, what are your view, any likely significant effects arising from that?
My view would be that there would be no likely significant effect.
Thank you. Then please can we move to a different topic, which was the role of the Environment Agency letter in the County Council's Habitats Regulation Assessment.
Yeah.
At CDE 15 was the document you were taken to. And the passage that you were questioned about was the reference to the EA, I've lost it now, but perhaps you can remind me which page it was on. All right. It's Apologies, sir, I've lost it. It's the, I think it was, no, it was stage 2. Oh, yes, it's on page, no page numbering. That's my problem. Page 5 of 9.
Of which document, sorry?
This is the County Council's HRA CDE 15.
Oh, sorry.
You were asked about the penultimate bullet point under Solarton Southampton Water SPA and corresponding Ramsar site. Have you got that?
Sorry, I'm
Page 5 of 9.
Page 5.
At the top of the head table, head, top of the page, it says assessment of likely significant effect, proposed development alone.
Yeah.
You got that?
Yeah.
My
sorry.
recollection is that you were asked about the penultimate bullet point
Yeah.
of the first paragraph. Hydrological changes, including water quality flows, abstraction, nutrient, and then these words, no likely significant effect alone or in combination with other plans or projects.
Which I agree with.
And then it says, this has been confirmed in recent correspondence with the Environment Agency.
It does.
And I think the suggestion was put to you that the county council were in effect making their conclusion based on the Environment Agency rather than your position was that they made their own decision and that it was confirmed by the Environment Agency's analysis.
That's what I take from reading the letter, yes.
Thank you. And then if we deal with the, sorry, I hope I'm moving rapidly through the top, well, whether it's rapid or not. Next topic, the question of whether you can take into account the mitigation at the likely significant effect stage. You were asked about that. And you were asked about the eco-advocacy approach.
Yeah.
Just for clarity, in your rebuttal, and so I hope you can trace this through your notes, but in your rebuttal, you were taken to (2.1.31). Yeah.
Yeah.
And the question, as I recollect, and I didn't interrupt, but because I'd already interrupted too many times, but the question was put to you at 2.1.31 that these passages were read out, the ones in italics, as being the eco-advocacy ruling. But I just want to confirm whether or not that's correct. Before one looks at the paragraph you were taken to, section 4.1.2 in the passages appear to be referring to Mr. Andrews' UK water industry report and his interpretation of the eco-advocacy approach. But I just want to clarify which it is.
I believe from reading that paragraph that I was that these sentences are taken from the UK water industry report, and that these are quotes taken from the eco advocacy ruling, not from the original source.
Not from the
Original source.
They're taken from the eco-advocacy or from the UK water industry report?
I think reading the paragraph again, they're taken from the UK water industry report.
That's what I thought. That's what I said. We can always check that, but that's my understanding. So the question of additionality and intention, are they eco-advocacy concepts or ones from the authors of the UK water industry report, this idea of intention?
I couldn't answer that without looking, I'm afraid.
That's fine. Well, we can probably, so you can check that in due course. Good. Okay. But as to the question of whether or not the measures are using this test essential features of the plan or project, you're asked about the lead local flood authority's position on that, and you were taken to that quotation of a response. Could you just go, please, to G3, CDG3? See if we can shed some light on what you're asked.
I've got it open.
You got it? doing better than me because I haven't. Say when you've got there. You've got there.
Of course it is.
Sorry, sir, have you got there? This is the Lead Local Flood Authority's response, 19th of December 2023. Back to the council, I believe. And I just want to go to their comments about the drainage strategy on the second page. 1, 2, 3, 4 down. Current proposals for the restored site are shown to have a different profile to the existing site, which means that the adjacent ditch networks would receive disproportionate amounts of runoff from the restored site. This is not considered acceptable, and the restored site should be profiled to mimic the existing site. This was highlighted in our responses of 7th of Feb, 16th of December, 30th of January, and has not been addressed. So I don't want to go through all of those responses, but I just wanted to get your view as to whether the Lead Local Flood Authority is requiring the mimicking of the strategy for reasons of habitats or for reason of preventing disproportionate amounts of runoff to other parts.
It is clear within this paragraph that the Lead Local Flood Authority is asking that the amendments to the scheme are undertaken to prohibit the disproportionate amounts of runoff from areas of the restored site. It is clear to me that this has not been undertaken to prevent impacts to the habitat sites.
And you can see the bit that then later appears in the quotation is 2 further paragraphs down, also identifying the significance to the HRA and EIA. But separated, I think, in the paragraphs in the original response. Yep.
Yeah, I can read it. Sorry, I'm just
Thanks.
reading it.
No, that's fine. I was just drawing to your attention. Good. Then, yes, different topic, Mr. Tillehay. You were then asked at some point about the location of Badnam Creek in the Triple SI. Do you recall that?
I do.
Can you just go to your rebuttal proof of evidence? You were taken to your map, but not to the paragraphs which appear around the map. Is it your rebuttal? Yes.
Yeah.
They begin at, I think, 2.1.50. No, actually, it begins a little earlier. 2.1.48 on the preceding page, which explain your introduction of the map. Could you just please refresh your memory of what you were saying in your rebuttal about the map? There's quite a few paragraphs. It goes right over the page to 2.1.56, I think. But you might just need to refresh your memory. let me know when you're.
I've read it, yes.
Thank you. Can I just ask you whether you've changed your view on anything you've said in those paragraphs?
So these paragraphs point out a series of questions that we asked about Mr. Andrews' proof of evidence. The pertinent point being that the points being that when we were talking about it earlier on, we were talking about the fact that we don't think there's going to be a change to the site, so it'd be irrelevant regardless of where this site is. And the position of the creek is irrelevant because there are other influences on it that would, such as the tide, that would have an impact on the SSI. And therefore,
you don't need to summarise it all. My question is whether you've changed your views on what you've said in these paragraphs.
Yes, I have. I've. My opinion that the position of the SSI is not as relevant as I may have made it out to be. That it is.
When in the paragraphs or in your answers, right?
Sorry, in my answers today, not in the paragraphs that I've written.
Right, but let's just take it. So, are you saying you stand by what you said in your rebuttal, or you change it?
I stand by what I say in my rebuttal.
Right, but can we just deal with this point? I think the suggestion is being made. Well, Natural England have made an error about where the SSI is in relation to Baddenham Creek. I think that's the contention. Can I just ask you this, Mr. DeHay, in light of the conclusions that have been reached for the HRA for all parts, namely no likely significant effects in terms of the change in water quality, quantity and material flows, what would be the if Natural England, for example, have made a mistake here and therefore haven't expressed a view? Can I just get your view as to what the position you would advise the inspector to be on whether there is any likely significant effect on the SSI based on what we know? Sorry,
I couldn't hear what you were saying.
Sorry. Oh, so sorry. I think the suggestion is from the Rule 6 party, Natural England have not understood where the SSI is, and they didn't appreciate that Baddenham Creek, some parts of Baddenham Creek go in and out of the SSI. So that's the suggestion. So they haven't therefore expressed a view on likely significant effects on the SSI here.
Yeah.
So I know you've got your views in the rebuttal, but let's take that as an assumption. If that's the case, what do you, because the inspector has to make a view on likely significant effects, armed with what you know about the project and the conclusions you've reached, what's your advice to the inspector as to whether or not there's any likely significant effect on this SSI?
My advice would be that the likely significant effect, there will not be a likely significant effect from the hydrology leaving the site. There will not be effect, and there will not be a change to the quantity or quality of the water, or a significant effect caused by any variations of the flow, if they occur, and therefore there will not be a likely significant effect to well, there will not be a significant effect to the Bagman Creek, because there's no effect from the site. Therefore, there can't be effects to the adjacent areas.
And to your mind, has anyone identified a qualifying feature or aspect of the triple SI which could be affected by the water that we're proposing to come through these springs in the quantities identified?
There will not be a significant effect to the.
Well, I know that. Has anyone identified what an effect that you consider? No. Thank you. Then, can we then, last topic, but different subject, recreation.
Yeah.
You're asked about recreation and what's on offer, and just, I think, 2 questions on this. First of all, you were taken to the restoration plan.
Yes.
And which is CDC1, I think. Tell me when you've got there.
Sorry, can you send the
CDC1, the restoration plan.
CD? Sorry.
C1.
Sorry, forgive me. It was my fault
I think
for
you
not
might.
typing
Don't
it
you
into
have
the
a
right
hard
place.
copy? It's a large restoration plan.
Oh, sorry, I mistyped it into the
Oh, I see. Okay.
That's my fault. Sorry.
You're going to have to get a computer with higher processing power, Mr.
I'm not sure it's entirely the computer's fault. I will defend.
What, user error, you mean?
I think it might be user error. Yeah.
Fair enough.
CD1.
C1.
C1. Yeah. Okay.
Have you got it?
Yeah.
Okay. You were asked about the areas, the meadow, the path. You gave the areas and their size and judgments about that. Just dealing with, of course, the unspoken part of the site. That is restored and subject to a biodiversity improvement, which has been the subject of assessment, I think, elsewhere. Biodiversity assessment. Is that right?
It's been the restoration plan.
Yes.
There is a biodiversity mitigation plan for it.
Yes, but I'm talking. You were asked about the area that's on offer for others, and then there's the other part of the area which is we can see lots of green. I think it's been assessed for its biodiversity. Is that correct?
It has. It's had a biodiversity mitigation plan on it. Yeah.
Yes. And I just wanted to deal with the. I think in the Natural England, one of the comments from Natural England was whether or not that area could in fact also be helpful for birds and overwintering birds and matters of that kind. And I think that was covered, though I don't know if you can help me whether there is or help the inquiry a response on that from the appellant in response to Natural England's suggestion as to its use. If you don't know, then That's fine. I'll find it elsewhere.
The document I see, I can't take you to it because I can't remember where there is a response from Naturally where they talk about the possibility of the remediated sites once the operation site is finished being used part of the as part of the bird aware scheme for the suitable mitigation area. They allude to it in one of their documents. And I can't remember which one it was.
That's fine. So I think what I'll do is just find you the appellant's response to that, which identifies the purpose of the ecology on the site. Okay. One thing you did, I think, allude to was both for the permissive path that's created and also the restored scheme, sticking with the 11.2 hectares, you referred to the ability for others, not just those who are currently using the site, but for others to use the site and the links. Can you just elaborate on that, please, as to what you're saying?
Well, currently the site is is not, they're not permitted to use the site, so there will be a proportion of people who won't either know it's there or are unwilling to walk on it, and post restoration or during that's wrong, during operation and post restoration, there will be an opportunity for people who don't use the site to come on and use it, because it's going to be a well managed and well maintained area which will allow them to walk their dog. So there are plenty of areas nearby that people can gain access from footpaths and from the train station. So it will provide a link from areas like the train station down to the southeast of the site. So my point was that there are people using it already without permission, but the people who feel they can't use it will be able to use it once it becomes a permissive path with a management plan on it.
Thank you. And then I think the last question I've got for you was the question about the salient mitigation strategy. Do you recall that?
Yes.
And I think it was the questions went to broad effect that the appellant's not paying a contribution as if it's a residential developer. Do you recall that? But
yes.
Yet there may be displacement.
Yes.
Can I just ask you, Mr. De La Haye, whether with the mitigation that's proposed, i.e. the permissive path and the assessment of it, anyone else has suggested it's necessary additionally to pay money by way of towards the strategy?
No. Normally, if we put a bespoke mitigation strategy together and sent it to Natural England and discussed it, one of the things they would have come back to us and talked to us would have been about the requirement to pay into a mitigation fund if it was needed, and they haven't provided that input into their response.
Thank you very much. I think those are all my questions. I've just got that one document left outstanding, but I can try and identify that before we leave.
Yep, I'll pick that up in a second.
Thank you.
Thank you, Mr. Strong. That concludes the ecology evidence. There's one thing that I've learnt today is that a piece of paper doesn't rely on processing speed nor bandwidth. I might be old, but I got there quicker than anybody else did. You can make your own cost-benefit analysis of that. But anyway, that's a flippant point, but it just goes to show some of the old ways still work. All right, let's just have a little chat about tomorrow before we leave today. I'll run through it sequentially. Tomorrow morning we're going to have a roundtable session. It's not roundtable, it's got to be in this format, but I'll try and be inclusive as I possibly can. when we have that discussion, I will invite interested parties to, if they want to sit around the table, to do so. So what I'm really saying is that if people don't need to be around the table from the council, the appellant, and the Rule 6 party, some people do, not everybody does. So we can free up some space a little bit for that discussion under Section 106. There will be the landowner. We'll start with the Section 106, or plan obligation, because the representative of the landowner.
I understand that they no longer think it's necessary to.
Right. Well,
There's an
Right.
agreed statement, I think, with them, so that will
All right,
say
fair
that,
enough.
sorry, that they're participating, but through the agreed statement. Sorry, yes.
okay, all
I
right.
hope that's right.
In which case, we'll deal with the plan obligation first anyway, because I think that's something we can quickly get out of the way. On that particular matter, do we have the final version of that?
Yes,
I did say, can I take that home tonight?
Can
I'm
indeed.
not taking it home. That's we'll never get back.
You wish.
But do you have a copy for all parties? Thank you. And does that include the appendices?
Those are the
Next.
append-
Brilliant. Thanks
Thank
ever
you.
so much indeed. So I will record that as an inquiry document. I'll record that as inquiry document 11, which is the updated version of the plan obligation. So I don't see that being particularly lengthy because all parties seem to be in agreement. There might be some discussion that the Rule 6 party might want on any of the covenants in there and anything in the schedules, but that shouldn't be lengthy. Once we've done that, we'll move into the discussion on planning conditions. I assume Miss Kirby Oaks will be involved in that, and bear me a second, it's been a long day. Miss PMM will be involved in that discussion, and again, if people want to be participating in the discussion from the interested parties, you can do that.
Yes, and we have Miss Else here
Miss
on
Else,
behalf of the Rule
yeah.
6 party. I can't speak for other interested parties, but yeah.
What I will do, I'll go through those conditions sequentially. Some are not contentious, some I might have some comments, and some there is a little bit of discussion between the council and the appellant. But we'll go through those and then come to a view that we might require some amendments or we might not, and then I'll leave it for an agreed list. That will cover that particular point. We'll then have a very quick break for lunch. The site visit tomorrow. First of all, whoever put the site visit plan and itinerary together, congratulations, it's the best one I've ever had in my experience. So whoever did it, I'm not asking you to say it was me, but that's the best itinerary and site visit plan that I've ever had, to be quite honest. So well done, whoever did that. As I understand it tomorrow, I've got a couple of questions on that, but just to confirm the attendees who's coming in with the transport arrangements on the minibus or wherever, from the appellant, it's Ms. Pearman, Rachel Joest, Ben Howard, is what I have on my list. From the council, Lisa Kirby Oaks, Jane Rarrock. From the Rule 6 party, Dr. Clothier, Catherine Else, Matthew Waters, and Emma Westacott. Is that correct? There's no changes to any of that. Just when I'm suggesting tomorrow, it depends where we are, but I'm thinking it's going to be, we'll still be dealing, we've got some third party speakers to consider tomorrow. I'm hoping we can leave here by 1:30 at the latest. So we'll say 1:30. When we do leave here, where do we go to? Where have you arranged for the minibus to come?
I think it's been arranged to be picked up in the lay bar in front of the reception. Yes, so it's just at the main entrance, and there's a lay bar just down at the bottom of the steps.
So, okay. Is everyone who's accompanying us on that minibus joining that minibus at that particular point? Yes, so I'm not picking I'm not picking anybody up. Like a minibus driver. So everybody goes from here, stops on the minibus, comes back to here. Is that my understanding? That's where it needs to be really. So there needs to be a representative of all parties with me at all times.
So the two people from the Rule 6 party won't be coming back because they live there.
All right.
But I think Miss Els will be coming back, so there'll
It's all
still
right,
be a
as
representative.
long as there's somebody
Yeah.
there. That's okay. My next point on that, who's going to take responsibility for directing the minibus driver, directing directions, directing me, and keeping us on track with that programme? Whose job is that? Who's going to say, right, we need to be here? Thanks ever so much. As long as somebody's taking control and saying, right, we need to move this direction, because I've got some awareness, but not the detailed awareness that you have. So you need to keep us moving as much as we possibly can tomorrow. It will take as long as it takes. I've given up my season ticket for tomorrow night, so I'm not going to get back for that anyway, and I won't tell you what it is. But so if we're here till 10 o'clock, we're here till 10 o'clock. I ain't got a problem with that. You might have. I'm just looking at this. All right. That matter. So the site visit's covered. I'm just going to go through a couple of housekeeping things. Just before we leave the site visit, I mentioned on Tuesday the fact that these can be, it's an emotive issue, accepted. And there is sometimes on some site visits, perhaps artificial inflation of some of the conditions that you view. I'll leave it at that. What I will suggest is that I've been up and down Hamble Lane now a few times. So I know what Hamble Lane's like in a normal time period, for want of a better word. I know what it's like at school leaving times. So therefore I'll have some awareness if there's an artificial inflation of highway circumstances. For example, you can do what you want to do, but I have to make my own judgments. But what I'm trying to say, I've seen it in normal conditions. So if there are abnormal conditions, then I will be looking for the reason for those abnormal conditions. And if I can't find a reason for the abnormal conditions, then I'll have to come to the conclusion as to why that might be the case. And I don't need to say no more than that. And I'll leave it at that. And the final thing, just from a community perspective, of obviously, we're there for a purpose. We're not going to start debate. We're not going to discuss the case. I'm not going to hear evidence. So it's really please ensure, if we possibly can, that we're not impeded in the way that we do that visit tomorrow, so that we can see it for its genuine purpose, and it's not thwarted in any event by any actions that might put us off track, for want of a better word. Thank you for that. Right, just a couple of housekeeping matters then. The rainfall data has been issued. That's inquiry document 10. I've just forgotten, that's ID 11. That's ID 11. I couldn't remember what ID 11 was. My mind went blank. The section 106 is now, the revision is ID 11. The just other couple of things that we left hanging from today, just have a think about putting some timescales on that. There is outstanding matter regarding the 2013 versus 2022 note. That's for next week. I'll park that one. We do need a note at some point regarding the permissive nature of the landscape areas. Is that something for tomorrow, or is that something you want me to park?
I'm told we'll have it for you tomorrow.
Brilliant. I'll run through that tomorrow. We left the respective highway witnesses to have a think about coming to some common ground in terms of baseline information. I'm going to leave them a few weeks to do that, because we've got a few weeks to do that now. But probably next week I'll put a letter out through John, just perhaps giving 2 to 3 weeks for some kind of common ground to reduce inquiry time as a statement of common ground on highway matters.
So just I understand they have made contact with each other, but I also understand that Mr. Whittingham, for example, I think is away for the next 2 weeks on holiday, so it just factors into.
No problem. I'll give you plenty of time.
Thanks,
we've got the proofs. We're looking at reducing inquiry time. So if it's 4 weeks, 5 weeks, 6 weeks, we've plenty of time, I think. think that's it. I've got some notes here that for some reason I can't read what the heck I put. Agreed note, oh yes, the agreed note read the distances from the protected sites.
That's for Mr. LaHaye and
It
Mr.
is, that's
Andrew.
something, it's not crucial, but by the end of next week.
I'm on holiday next week, so I will get it mapped for you tomorrow and get it sent over to you.
I was going to say maybe something I can do very quickly. I think I know why the distance falls short. It's just my symbology isn't probably on paper. So maybe something we could go within a matter of minutes.
Yeah.
Okay, well, you can tell me the position on that then tomorrow morning. I think that's it as far as I think are urgent matters that I need to think about.
So can I just say on, sorry,
No, you're going to give me something as well. Some reference.
CDB94. CDB94 was the appellant's response to Natural England's
That's it.
suggestion to the use of the other part of the site, and they identify in that document
No problem.
the nature conservation elements. So that's CD. Sorry, I couldn't find it earlier, but it's B49.
All right. I think that then is kind of where we're at. I don't think there's anything else that I need to be worried about. Just looking from the council, anybody else?
So I think I'm probably teaching you to suck eggs, but I'm being told to say it's quite muddy on site, and I'm sure you've probably got a pair of wellies or appropriate footwear, but just told to mention that to you.
I don't have a pair of wellies. I've got some walking shoes,
Yeah,
but
sure
I'm not adverse to.
Fine. So,
I'm not adverse to going over the top. If that's what you mean in terms of
sure. Thank you, sir.
overtopping my boots. It doesn't matter. It's yeah, I'll live with that. Just one thing for advocates tomorrow. Actually, the final part of that. We've got interested parties speaking again tomorrow, just for an hour. I understand it. The speaking list has been revised to reduce numbers and reduce time. But nonetheless, I'm aware that you might have questions. Yep.
Not to. But
So that's the reason why I've had to leave the room as an inquiry set up, because people are going to sit at the witness table tomorrow. I'm not expecting advocates to participate in the roundtable session. If you want to do, that's up to you, if you're that way inclined, but it's unusual that you do, and I'm not expecting you to do. In fact, I'm not expecting you to be in the room for that session. I'm expecting you to be in the room for the opening. After that, until the interested parties come back in, unless you really want to do, I'm not expecting you to be back in the room. I am when the interested parties come
thank
in.
you very much.
So in terms of what do I expect of you tomorrow, only for openings. If you want to go through and participate in the roundtable discussion, that's entirely up to you. You're not going to get your way, either of you, any of you, because I'm in charge on that one. So, but if you want to do that, you can do that. But I just want you here then for the questions.
Understood.
There is a 1 o'clock curfew, because some people might want to change it to some different clothes. I ain't doing the site visit in my suit, for example. So we've got some time to do that. But it will be a 1 o'clock curfew. I have to do that, otherwise we get all sorts of out of sync issues again. That's it. I've said enough there. Unless there's anything else that crops up, let me know tomorrow. But that's my expectations. That's what I expect of you tomorrow. That's what we're going to do tomorrow. We know where we're going. We know who's going. We know who's keeping us on pace. And we know what needs to be submitted. So I think at that particular point, I can close for tonight. Oh, whoa.
Can I float one thought in your mind? When we resume in June.
In June, yep.
Well, I wonder whether we could start at 9:30.
I would have. I wasn't changing the program. I was expecting to start at 9:30.
That's fine.
We're all familiar with the room now.
That's fine.
We know it works.
Yeah.
So it will be 9:30. I will issue if it'll be probably tomorrow morning when John sends it, but I will issue the revised program that covers the June dates. But it will be. I can assure it'll be a 9:30 start with closings in the afternoon of the second day.
Thank you.
Right. Having said that, We're closed. Time for a quick visit to the pub for me. Thank you. Good night, everyone.